Yes. All 28, 29th, give it.
KDB matter, man.
ಯಾವ್ದಾದ್ರೂ ಅಷ್ಟೇ ನಾಳೆ ಅಂತೂ ಆಗಲ್ವಾ?
3 memo file, man.
Whatever, tomorrow is not possible. So next is 28.
Date fix,
Give
man.
it.
Please request.
Give it, sir.
Please, man. Senior is engaged file, yeah. Please, man. 3 times memo, man. Please.
You what to do, sir? Give it, sir.
Request, man.
Fresh matter.
Fresh matter, man. KDB matter, please.
Lordship, fresh matter.
Hello, wait. Senior counsel is there.
Lordship, fresh matter.
Sir, what is this?
I know it was becoming a little. Papa, our
Fresh matter.
Kudi,
ಐದನೇ ಸರಿ
sir.
move ಮಾಡ್ತಾ ಬರ್ತಾನೆ ಇಲ್ಲ.
ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ ಸರ್?
Urgency ಇದೆ,
ಕಂಪ್ಲೈ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈ ಆಗಿರೋದು ನಾಟ್ ಒನ್ ಸಿಂಗಲ್ ಫೈಲ್ ಇಸ್ ಪೆಂಡಿಂಗ್.
Comply
I have last week posted 500 matters, not one file is pending.
ಕಂಪ್ಲೈ ಮಾಡಿದ್ವಿ.
Comply ಮಾಡಿದ್ರೆ it will come. Then don't complain if not complied. All right.
Urgency ಇದೆ ಸ್ವಾಮಿ ಅದಕ್ಕೆ.
ಏನಾರು ಇರ್ಲಿ ಕಂಪ್ಲೈ ಮಾಡಿ.
ಮಾಡಿದೀನಿ.
ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅಂದ ತಕ್ಷಣ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ತಗೊಳ್ಳೋದೇ ಇಲ್ಲ.
ಮಾಡಿದೀನಿ ಸರ್.
You comply and then complain. Yes.
It's complied, Your Lordship.
Give it.
In order of
Complied matters will come, give it.
28th, Your Lordship.
I don't mind.
It will come, madam. Thank you. Kudi.
serial number 18 ನಲ್ಲಿ 85 ಅಲ್ಲ? serial number 18 ನಲ್ಲಿ 85.
ಇವತ್ತು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಬೇಕಾ? ಬೇಡ ಸರ್.
Senior counsel
ರೀಚ್ ಆದಾಗ ಹೇಳಿ.
senior counsel.
ರೀಚ್ ಆದಾಗ ಹೇಳಿ. ಮಧ್ಯಾಹ್ನದ ಮೇಲೆ ಬನ್ನಿ.
Tax fresh matter, man.
Give it, sir. Give it, sir.
Right, sir. Fresh matter, JNCPC.
Huh?
JNCPC, fresh matter.
What is the
The
matter?
respondents have intentionally, fraudulently taken the decree, my lord.
Intentionally fraudulently taken decree. Challenge it in appeal.
No, without, they refer to Lok Dalat, my lord. Filed a
Palm
compromise.
23 ಹಾಕಿ ಲೋಕ ಅದಾಲತ್ ಕಾಂಪ್ರಮೈಸ್.
Lok Dalat compromise ಆಗಿದೆ, but ನಮ್ಮನ್ನ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ಮೇಡಮ್. Without.
ಆಯ್ತು, ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇದೆ?
The revenue authorities here application ಕೊಟ್ಟು, they may effort making change in the revenue.
FR WP ನ
FR number ಇದೆ, I'll comply to.
ಕಂಪ್ಲೈ ಆದ್ರೆ 230 ಬರುತ್ತೆ.
I'll comply.
Yesterday's matter. It is already connected matter is posted on 3rd September.
ಅವತ್ತೇ ಬರುತ್ತೆ ಕೊಡಿ.
28th.
No, connected matter is posted on 3rd and 28th they are asking what is this?
Please.
Yes.
ಎರಡು ಸತಿ ಮೂವ್ ಮಾಡಿದ್ವಿ ಹಳೆ ಮ್ಯಾಟರ್.
ಹಳೆ ಮ್ಯಾಟರ್ ಬರುತ್ತೆ ಅಕಾರ್ಡಿಂಗ್ ಟು ಸೀನಿಯಾರಿಟಿ ಬರುತ್ತೆ.
ಒಂದೇ ಒಂದು ಸಿಂಗಲ್ ಒಂದೇ ಪಾಯಿಂಟ್
0.5 ಪಾಯಿಂಟ್ ಎಲ್ಲ ಅಕಾರ್ಡಿಂಗ್ ಟು ಸೀನಿಯಾರಿಟಿ. ಏನ್ ಸೀನಿಯಾರಿಟಿ ಪ್ರಕಾರ ತಗೊಂತಾ ಇದೆ ಸಮ್ ಮೆಥಡ್ ವೈಟ್. ಎಸ್ ಡೈಲಿ ಐ ಕಾಂಟ್ ಟೇಕ್ 500 ಮ್ಯಾಟರ್ಸ್. ಎಸ್ ವಿಡ್ರಾಲ್ ಗಿವ್ ಇಟ್. ಎಸ್ 230. ಆಯ್ತು, ಟೇಕ್ ಇಟ್. I am releasing ಲಿಸ್ಟ್ ಮಾಡಿದ್ರೆ ರಿಲೀಸ್ ಮಾಡಕ್ಕೆಲ್ಲ. I am releasing the whole lot. Yes. All right, give it. Royal again, wait ಮಾಡಬೇಡಿ. Vacating, give the application. Yes. ಆಯ್ತು, give it. ಏನು ನೋಡಿ ಮಾಡಿ. Yes, sir. We'll start.
Screen.
And for a towering personality like my learned friend, my lord, and my learned friend, there's no difficulty. The problem is for people like us.
No, sir. That is nothing to do with that.
Height, my lord.
Towering personality does not require height.
That's what.
All towering personalities are not tall lawyers. The tall lawyers are here.
No, even in history, they are not tall people. Yes.
My lords, before your lordship start, my lord's leave.
Housekeeping.
Yes.
I would like to make one submission, not on the matter, my lords. I'm taking my lord's leave and making this submission, my lords. For us from the bar, it's an extreme honor and pleasure, my lords, to have the learned Attorney General here with us for two reasons, my lords. Not that he's the Attorney General of this country, which is of course a pride for us, but more so for many of us and for many members now on the bench, my lords, in many high courts. He has been a mentor and people have interned with him.
So I've been lucky thrice now.
And therefore, my lord, and he continues to be a dear
Yes,
friend, my
yes,
lords. We
yes.
respect your
This compliment notwithstanding, I'll strongly object to their petition.
Yes.
Now, my lord, all of us have been the recipient of his generosity and
Absolutely.
there's no difficult, no.
I told you, I have been lucky thrice over. This third time sir is appearing.
No, independent of the fact that he is an attorney.
Yes. Otherwise, where do we get to interact with?
No, independent of the, I know, but
Yes.
at least we get a
Ah,
opportunity to
that's what-
interact.
That's what, yes.
But independent of the fact that he is an attorney, my lord,
Yes.
he is a
Independent of the fact that he's an attorney, he's an attorney.
Now that these opening statements have been made,
Yes, sir.
no.
I will not steal their thunder. They will have this.
Yes, yes.
I only wanted to say both Amazon and Flipkart
Yes.
have a great love for the Karnataka High Court. So they so they keep visiting here as often they can get an easy permit.
Yes,
So the
sir.
whole case is about whether they should be having a free entry to this court as and when they want.
That's
That
it.
will-
Let's see.
no, that-
We'll
that's-
start.
That point is irrelevant so far as the petitioner whom I represent.
And Sajan sir has appeared. Definitely it is.
Well, they can't buy
Well,
entry to this court, my lord, by parent court.
Very well, let them start.
Yes.
Response number.
Now who's starting? Sir is starting?
Yes, sir.
Yes.
But I am in WP number 26671. I think 1.2, my
Yes, sir. 1.1, I guess.
1.2.
1.2.
I am in, my lords, my esteemed friend, Mr. Chinnappa is in one, my lords. I'm in one.
26671, is it?
Yes.
71 is 1.1.
1.2. My lords, 26671 is 1.2, my lords.
Eh?
I'm in 1.1, which is 26627, my lords.
26627, 1.2.
I am in 26671.
Oh, I'm sorry. I have,
Oh, there's
this
a-
is the verification list.
Yes.
Yes. Sorry, sir.
Just housekeeping, my lords.
Yes,
26627, in which I appear, my lords, is 1.1.
correct.
Senior, my lords, appears in 1.2, which is 26671.
Yes,
And my esteemed friend, Mr. Chinnappa, my lords, in 26674, which is 1. my lords.
1.
Yes.
All right. Now Raghavan sir is starting.
Please.
Yes.
My lord, just before I go into the matter, my lord, just so that after I have taken your lordship's time, it should not be said that somebody has not filed a counter, somebody has, because pleadings are not, I must bring it to the notice of this court that pleadings are not complete in all matters. The reason why I'm saying this, my lord, is this. There are a number of petitions of the present kind which were filed, my lord, in several high courts in the country. And then, my lord, the Competition Commission moved the Honorable Supreme Court for transfer. The matters have all been then, my lord, transferred to this Honorable Court, and now, my lord, it's before your lordships for hearing. Now, my lord, I am given to understand that pleadings in all the petitions are not complete. I just want to bring it to your lordship's notice, my lord, and leave it at
No,
that.
let me get to know what the matter is.
I will.
Yes.
But the principle, there are not too many facts involved in this case. And there is a short legal issue, my lord, that arises for your lordship's consideration. Under the provisions of the Competition Act, there are two concepts. One, my lord, is the concept of an opposite party. The other is the concept of a third party. Now, my lord, under the Competition Act, the scheme which I will take your lordships through, there are two authorities, namely the Competition Commission of India and, my lord, the investigating agency, namely the Director General. Now, the Director General has no suo motu powers. The Director General can only investigate upon a direction issued by the Commission. Then, my lord, the Commission in the instant case issued directions. There were only two opposite parties. That report of the director indicates that there are only two opposite parties, namely Amazon and Flipkart. Then, my lord, what happens is, without impleading us as opposite parties, a notice was issued by the Commission. The question, my lord, is, can a notice for investigation by the Commission without the process as prescribed under the Competition Act be adopted in order to make a person who is a third party as an opposite party?
That's all the issue.
That's all the issue.
Yes. Hmm.
The investigation is by the DG. The Commission, my lord, makes the inquiry. The question, my lord, is, can there be an inquiry without making a party as an opposite party? Can you state? Well, we will, therefore, my lord, this
So
will.
according to you, making one an opposite party is imperative for an investigation.
Absolutely.
Yes.
without making a person as an opposite party. Now I show to your lordship. Your lordship may say, what does it matter? Is the first impression that would be. But when we look at the provisions of the Competition Act, it becomes clear, my lord, that there are certain rights which are given to an opposite party, which is now denied by virtue of this backdoor entrance, if I may use that expression, of making a third party as an opposite party without going through the process as prescribed by the statute. This is the question, my lord. Therefore, my lord, we are not asking your lordship to go into the question as to whether there is an unfair trade practice, whether there is an anti-competition practice. All that we are not asking your lordship to go into.
You are only on the periphery of procedure.
Absolutely, my lord, because today the question, my lord, is can you make a third party an opposite party without complying with the provisions of the statute, thereby depriving the third party who has now been converted into an opposite party certain rights which are vested in the opposite party. There are certain rights which are vested in the opposite party which are now being taken away is our submission, and I will make good those submissions with reference to the provisions of the statute. In fact, my lord, if your lordship sees the interim order that has been granted.
Yes.
If your lordship will kindly see the interim order that's granted by this honorable court.
Yes.
That records, my lord, in brief, the submissions.
27/9/2024.
My lord, it's,
I'm there.
my lord, your lordship.
I've seen it, 27/9/24.
Yes, my lord. Yes,
Yes.
yes. If your lordship will kindly see that order, my lord, it records in brief, in a nutshell, the contention. If your lordship will kindly see, my lord, the third paragraph. However, petitioners contend that the Director General, without seeking necessary permission from the Commission to include the petitioners as opposite parties, as mandated under Regulation 24 of the Competition Commission of India, General Regulations 2009, submitted a report to the Commission classifying the petitioners as opposite parties for further proceedings. The petitioners argue that this action by the Director General is in violation of the established procedures and regulations, as the Director General is required to obtain prior approval of the Commission before altering the status of a party from a third party to an opposite party in the course of an investigation. Given these circumstances, petitioners submit that the actions of the Director General in contravention of the regulatory framework warrant appropriate consideration and rectification by the Commission in accordance with law. Therefore, the report submitted by the DG is in clear contravention of Regulation 24 of the Competition Commission of India, General Regulations 2009, as well as Section 16(1) and 26(1) read in conjunction with Section 41 of the Competition Act 2002. Under Regulation 24, it is mandatory requirement that prior permission from the Commission be obtained before a third party is treated as an opposite party during the course of an investigation. Furthermore, Section 16(1) of the Act emphasizes the procedural fairness required in the conduct of investigations, while Section 26(1) stipulates that the Commission must be satisfied of a prima facie case before directing an investigation. The role of the Director General as laid out under Section 41 of the Act is to investigate in accordance with the directions of the Commission, but this does not extend to unilaterally altering the status of a party in investigation without obtaining specific approval from the Commission. By submitting the report, classifying the petitioners as opposite parties without the requisite permission, Director General acted beyond his authority, thereby violating both the procedural safeguards enshrined in the Act and the regulations governing the conduct of investigations under the Competition Commission of India. This procedural lapse calls for rectification, and the report submitted by the Director General should be considered void to the extent it has contravened the statutory provisions and the Commission's regulatory framework. So and so learned counsel accepts notice for respondent, etc. In addition, petitioner is permitted to take out notice, interim order aspect first. So the reason why I read this to your lordship, my lord, is to point out your lordships in a succinct manner. The learned judge, my lord, who granted the interim order, has set out what is the case of the party. So since your lordship asked me what is the case, my lord, I think this gives your lordship. My lord, I have prepared, my lord, a synopsis and list of dates. And we also have, my lord, a compilation of the various provisions of the statute and, my lord, the case law on which we want to rely upon. So that everything is in one place, my lord. Your lordships are not troubled to see the
Convenience
compilation, my lord.
इजे के हो
May I take your lordship to the
Yes,
synopsis?
yes, yes.
The petitioner in the present writ is challenging the order dated 28/8/2024 passed by the Competition Commission of India that illegally identifies the petitioner as an opposite party in case number so and so based on the observations made by the DG CCCI in its investigation report in an investigation directed against Amazon and Flipkart and its affiliated entities and the IR to the extent it related to the petitioner. Now, my lord, your lordship may kindly look at that order dated 28/8/2024, which is, my lord, what we are now agreed. If your lordship will be kind enough to turn to page 46, my lord.
1.2 could you? Give me file 1.2.
I will post it immediately.
Keep this.
I just showed your lordship what is in challenge and then take your lordship first to these statutory provisions which are relevant in the case.
Page.
My lord, please be kind enough to turn to page 46 at 47.
Yes.
The matter was taken up in the ordinary meeting held today, wherein the commission considered the investigation report, qua Amazon, dated 9/8/2024, submitted by the DG in confidential and non-confidential version. The commission notes that in the investigation report, qua Amazon, and the DG has found the following entities to be liable under section 3(4), read with 3(1) of the Competition Act 2002. And then, my lord, your lordship may kindly see all those opposite parties 1 to 13 are shown.
Hmm.
My lord, I come as opposite party number 4. Of course, my lord, my learned friends, clients also come as opposite party number
Yes.
5, 7, 8, all that.
Hmm.
The commission notes that the DG has also found certain associated individuals of the aforesaid entities liable under section 48(1) of the Act. The commission notes that Amazon has filed an application in confidential and non-confidential version requesting not to disclose the Amazon information as stated in the application to any party, including the informant, Flipkart, and or their affiliates, any third party, etc., and or B, include the Amazon information in any public or non-confidential version of the investigation report. The commission acceded to the request subject to section 57 of the Act, read with regulation 35 of the Competition Commission of India General Regulations 2009. At this stage, the commission decided to forward. Now, your lordship may kindly similar. At this stage, the commission decided to forward an electronic copy of the non-confidential version of the investigation report qua Amazon to the informant and aforesaid 13 entities OPs in the present matter for filing their respective objections, suggestions, if any, within 4 weeks of receipt of the order in electronic form besides physical copy along with brief synopsis thereof. All the OPs are directed to submit their consolidated and standalone financial statements for the financial years 2021, 2022, 2022, 2023, 23, 24. It is further directed to furnish for the aforesaid financial years the respective turnover and income based on consolidated and standalone audited financial statements along with its turnover or income derived by it directly or indirectly from the activity for which the contravention relates to as per the investigation report by way of a certificate from its statutory auditor or in his absence by a chartered accountant supported by an affidavit by a person duly authorized by it in this regard in terms of the Competition Commission of India determination of turnover or income regulations 2024 and the Competition Commission of India determination of monetary penalty guidelines 2024 within 4 weeks from the receipt of this order. It may be noted that non-furnishing of financial details, etc. My lord, I'm not going to trouble your lordship. This is the primarily therefore, please look at now paragraph number 12. The party seeking access to confidential information shall make a request for setting up a confidentiality ring, and I'm going to show to your lordship what is this concept of confidentiality ring. By way of an application within a period of 10 days from the receipt of the non-confidential version of the investigation report, qua Amazon, in terms of regulation 35 of the CCI General Regulations 2009. However, it is made clear that mere filing of application for setting up a confidentiality ring would not entitle the party to get access to the confidential information ipso facto and the same shall be decided by the Commission in terms of Regulation 35 of the CCI General Regulations 2009. The secrecy is directed to communicate. The Secretary is directed to communicate to the informant and the OPs accordingly. The principal point, my lord, is how do you show after the DG's report that I am a opposite party? When investigation was ordered, I was not an opposite party. Or the investigation was ordered only against Amazon and Flipkart. Now, my lord, having shown to your lordships what is the core issue that your lordships are required, my lord, to decide in this case, let me take your lordships to the provisions of the statute and the regulations, my lord. Your lordships will have to see the architecture of the Competition Act in order to appreciate our contention that what has been done completely puts the procedure and the safeguards provided in the Competition Act on its head. That's our submission. Now, my lord, your lordship may kindly turn to the preamble to the Act. It's important.
Yes.
Your lordship may kindly see, my lord, the statement of objects and reasons. I'm not even troubling your lordships on the preamble. Please see the statement of objects and reasons. Please be kind enough to turn to paragraph number 5.
The bill.
The bill also provides for investigation by the Director General for the Commission. The Director General would be able to act only, your lordships may mark that, my lord, if so directed by the Commission, but will not have any suo motu powers for initiating investigations. Therefore, my lord, what is mandated by the statute is that there should be an order passed by the Commission to the DG saying, you investigate against X and Y. In this case, the order was investigate against Amazon and Flipkart.
Only two.
Yes. There was no order. And that, my lord, is now borne out by the statement of objections filed by the CCI before your lordships. That there was no order that has been passed by the Commission.
Yes.
Now, simply on the basis of what the DG has or has not said, can we be made opposite parties? Now, my lord, your lordship may kindly look at the statutory provisions.
Yes.
Your lordship may now turn to how the investigation starts, my lord. My lord, first, my lord, what is the scope of this act? Please see section 3. What is it that this act is seeking to monitor or prevent or regulate?
Yes.
Anti-competitive agreements. No enterprise or association of enterprises or person or association of persons shall enter into any agreement in respect of production, supply, distribution, storage, acquisition or control of goods or provision of services which causes or is likely to cause an appreciable adverse effect on competition within India.
Yes.
How will this be ascertained? Will this be ascertained by the Commission directly? No, that is not the way in which the statute is structured. For the purpose of finding out as to whether there is any anti-competitive agreement, my lord, the first requirement is that the DG has to investigate at the instance of the Commission. DG cannot act suo motu. Commission does not act on its own. The two, my lord, act in tandem. Now, my lord, your lordship may kindly go over to the next provision, which is section 18. Subject to provisions of this act,
Yes.
it shall be the duty of the Commission to eliminate practices having adverse effect on competition, that your lordship saw in section 3.
Yes.
Promote and sustain competition, protect the interest of consumers and ensure freedom of trade carried on by other participants in markets in India. Provided that the Commission may, for the purpose of discharging its duties or performing its functions under this Act, enter into any memorandum or arrangement with the prior approval of the central government with any agency of any foreign country. Second proviso, my lord, may not be necessary. Kindly turn to section 19, which is very important.
Yes.
The Commission may inquire into any alleged contravention of the provisions contained in subsection 1 of section 3 or subsection 1 of section 4, either on its own motion or on receipt of any information in such manner and accompanied by such fee as may be determined by the regulations from any person, consumer, or their association or trade association. In the instant case, my lord, it was not suo moto. Some association of retail traders in Delhi made a complaint to the commission that that Amazon and those who are selling on the Amazon platform are indulging in acts which are violative of section 3 and section 4 of the act, and therefore it warrants the interference of the Competition Commission. That's how this entire case began. A reference made to it by central government, a state government, or a statutory authority, provided that the commission shall not entertain any information or reference unless it is filed within 3 years from the date on which the cause of action is arisen. Provided further that an information or a reference may be entertained after the period specified in the first proviso, if the commission is satisfied that there had been, that is delay, my lord, I am not going to trouble your lordships. Then, my lord, what the commission must do, what they should determine, what are the parameters that the commission must take into account for the purpose of forming an opinion with respect to section 3 and section 4 are all set out here, which I am not going to detain your lordships to read, because that is on the merits of the matter, which your lordships are not looking at today. Now, my lord, please be kind enough to turn to the next important provision, my lord, which is section 26. Procedure for inquiry under section 19. Your lordships have seen section 19, my lord. I just now placed for your lordships consideration. Now, what is the procedure to be followed by the commission in respect of an inquiry before the commission on the basis of a complaint? Now, my lord, please see section 24. On receipt of a reference from the central government or state government or statutory authority, or on its own knowledge, or information received under section 19, if the commission is of the opinion that there exists a prima facie case, it shall direct the DG to cause an investigation to be made into the matter. Now, my lord, I pause for a moment here. Your lordship may kindly see. When a complaint is filed, no action is initiated by the commission immediately on a complaint. It's not like a plaint which is filed in a suit where automatically summons is ordered. The commission has to look at it to find out if, in its opinion, there exists a prima facie case. So the first requirement before you even order investigation by the DG is for the commission to satisfy itself that there is a prima facie case. And I will show to your lordship with reference to the facts of the present case that by straight away issuing the impugned notice, which I point out your lordships on 28/2/2024, where is this prima facie opinion that has been formed by the commission? How did the commission, my lord, skip the requirement of forming a prima facie opinion? And it is only then that investigation can be done. Today, investigation has been done and you are forming an opinion. And then you are saying, now tell me, investigation has been done. Now you come and face an inquiry before me. This is exactly, my lord, putting the cart before the horse, a classic instance. So, my lord, what is important?
Prima facie differs from ex facie.
My lord, prima facie differs from ex facie. True, my lord. True, my lord. In fact, I would say prima facie and ex facie are opposites. Ex facie is, it is so clear. Prima facie, maybe there is something that I want to look at it.
That is exactly what is done.
Now, that is exactly what the commission must do. Commission has not done it. Now, commission thought that there is a prima facie case for investigation against Amazon and Flipkart. No opinion has been formed, my lord, even according to the statement of objection that have been filed now in this present case, that the commission has formed a prima facie opinion that the petitioners before your lordships are required to be investigated by the DG. Well, these are all filters, my lord, because this is not to be done just like that.
Protective filters.
These are protective filters, my lord, and in the interest of promoting competition. My lord, because it is true that the act is to prevent anti-competitive acts to prevent, my lord, what in the United States we call antitrust actions. But at the same time, while it is the anxiety of the statute to prevent such unfair practices which adversely affect the market, it is also important that these provisions are not misused for the purpose of promoting the inter se business rivalry of parties. That's the reason why, my lord, everything, just because some complaint is filed with the commission, it doesn't mean that the commission will immediately start acting. No.
Prima facie.
Prima facie, they have to form an opinion. Now I ask myself, the first question, my lord, I ask myself, and I submit that for your lordship's consideration. Where is the prima facie opinion in this case? There is none. The prima facie case must be first, DG inquiry must be next. It can't be DG has said so, therefore I issue a notice to you, but directly for inquiry. The distinction between, my lord, investigation on the one hand and inquiry by the commission has been completely lost sight of in the action that has now been taken. That is the point, my lord, that we are making. Now, my lord, your lordship may kindly see the further provisions. Your lordships may omit, my lord, subsection 2, 2a. Please go to subsection 3 of section 26. Director General shall on receipt of direction under subsection 1 submit a report on his findings within such period as may be specified by the commission. If after consideration of the report of the DG referred to in subsection 3, the commission is of the opinion that further investigation is required, it may direct the Director General to investigate further into the matter. Director General shall, on receipt of direction under subsection 3a, investigate the matter and submit a supplementary report on his findings within such period as may be specified by the commission. Subsection 4 is important, my lord. The commission may forward a copy of the report referred to in subsections 3 and 3b to the parties concerned. Now, my lord, if your lordship will kindly see the impugned order.
Page 47, 48.
The order, my lord, dated 28/8/2024.
That is
The impugned order.
47.
Yes, my lord. Please look at paragraph number 5. At this stage, the commission decided to forward an electronic copy of the non-confidential version of the investigation report, qua Amazon, to the informant and aforesaid 13 entities OPs in the present matter for filing their respective objections, suggestions, if any, within 4 weeks of receipt of the order in electronic form besides physical copy, along with a brief synopsis thereof, not more than 5 pages. Now, this paragraph 5 of the impugned order, I trace it to 26(4).
Yes.
That is, my lord, forwarding a copy of the report referred to in subsections 3 and 3b. Now, when can a report under 3 and 3b be done? Only after an investigation is made by the DG.
Yes.
Today, there was no order by the commission. Admittedly, my lord, on that factual aspect, there is no controversy. There is no order passed by the CCI directing the DG to make an investigation against us. If in the course of investigation, the DG thinks that, well, you have asked me to investigate A and B, I think there is something to be done vis-a-vis C and D. What is the procedure, my lord? Not that there is a blank in the law on that. The DG has to then go back to the commission and then say, in the course of my investigation, I now find that you directed me to investigate A and B, but in the course of my investigation, I find C and D are also required to be investigated. Please permit me, because I don't have a power. DG didn't go, commission didn't pass an order. When the DG goes to the commission and then say, I want to investigate C and D also, along with A and B, the commission then will start the process under section 26(1). Prima facie, is there can I form an opinion that I should start an investigation and C&D. You may think so, but ultimately the opinion has to be formed by the commission. Neither in this case did the DG go, nor opinion was formed. The procedure prescribed for impleading a party, which I showed your lordships in the regulations, has not been complied with. And the commission always treated us as third parties. Because, my lord, under the statute, I showed your lordship the regulations. I'll just tell your lordship the point is, when I ask for a copy of the proceedings and the documents before the commission, if it is a party, opposite party, I am entitled to it as a matter of right. If I am a third party and I ask for copies, the commission in his discretion can say, sorry, I will not give it to you because you are not an opposite party. We made an application for copies. Commission said, sorry, I am not giving it to you because you are a third party.
But your opposite parties here.
No, my lord.
Your initial stage.
Initially.
That's what.
Now, between that date and this date, there is nothing that has happened. Between that day on which the commission said, you are a third party, therefore I am not giving you copies, and the date on which this communication was sent on 28/2/2024, then nothing happened. That's the, therefore, my lord, there is direct material for your lordship's consideration to show that even the commission said we are third parties. And between these two dates, there is nothing that has happened.
TP becomes OP.
The TP becomes OP. By the way, all that is done under the order dated 28/8/2024. Can that be done, my lord? It is our respectful submission that that cannot be done.
Right.
And I showed your lordship their objections. I just take your lordship to the statute and showed your lordship that some of these crucial facts are not in dispute, that there is no order that has been passed. And now, my lord, your lordship may kindly turn to subsection 4, which I was pointing out, your lordships of section 26.
Yes.
The commission may forward a copy of the report referred to in subsection 3 and 3b to the parties concerned, provided that in the case of investigation is caused to be made based on reference, etc. My lord, we are not concerned with all that. Then, my lord, your lordship may kindly turn to section 48b. Now, my lord, this is an interesting provision, my lord. In the Competition Act, there is what is called as a commitment procedure.
Yes. 48.
48b. 48 capital B, my lord. And this was introduced, my lord, in 2023.
Yes.
Your lordship have that? Well, my lord, we have put it in our.
Yes, it's here. It's
In our
It's at page 23
Yes.
of you. Yes.
May I read that, my lord, for your lordship's?
Any enterprise.
Yes, yes. 48b, sir. 41? Yeah, okay. Let me finish 48b, my lord, and then I showed your lordship this commitment concept. This is little peculiar to the Competition Act. The closest, my lord, we can think of is compounding, but I think that's a very different concept. That's a very different concept.
Yes.
That's some, if it was some analogy, that is it. But according to me, my lord, that is a wrong analogy. 48b.
Yes.
Yes. My lord, 48a is settlement. Your lordship may kindly see those two companion provisions of, yes, 48a and 48b.
Yes.
Maybe, my lord, 48a may be closer to compounding than 48b. But this concept of commitment is something peculiar to the Competition Act. Let me read 48b for your lordship's consideration.
Yes.
Any enterprise against whom an inquiry has been initiated under subsection 1 of section 26 for contravention of subsection 4 of section 3 or section 4, as the case may be, may submit an application in writing to the commission in such form and on payment of such fee as may be prescribed by the regulations, offering commitments in respect of the alleged contravention stated in the commission's order under subsection 1 of section 26. Your lordship may kindly see how closely the commitment provision is linked to that prima facie opinion that is referred to in section 26(1). Then, my lord, an offer for commitment under subsection 1 may be submitted at any time. Now, your lordship may kindly see this provision, my lord, which is very important. An offer for commitment under subsection 1 may be submitted at any time after an order under subsection 1 of section 26 has been passed by the commission, but within such time prior to the receipt by the party of the report of the DG under subsection 4 of section 26 as may be specified by the regulations. Therefore, my lord, to pause for a moment and to analyze 48B2, the right of commitment is available only after 26(1) order is passed, but before a copy of the report is given.
Before a copy of the report.
Yes, that's what it says.
Yes.
Prior to the receipt by the party of the report of the Director General, that's what the copy is given to us. That's what I pointed your lordship under 26(4). Now, therefore, it is the interregnum between the date of the 26(1) order and the 26(4) report that there is a provision for commitment
48B.
under 48. Now, I ask myself, to my what happened to my right to commitment? Today, in so far as I am concerned, there is no 26(1) order. I am straight away given a copy of the report under 26(4). Then where do I go and commit? Commitment, my lord, is an important statutory right that was given to me by this act, by this amendment.
Yes.
Now, my lord, I may read 48B completely. The commission may, after, I am reading subsection 3.
3, yes.
The commission may, after taking into consideration the nature, gravity, and impact of the alleged contraventions and effectiveness of the proposed commitments, accept the commitments offered on such terms and the manner of implementation and monitoring as may be specified by the regulations. While considering the proposal for commitment, the commission shall provide an opportunity to the party concerned, the DG or any other party, to submit their objections and suggestions, if any. If the commission is of the opinion that the commitment offered under subsection 1 is not appropriate in the circumstances, or if the commission and the party concerned do not reach an agreement on the terms of commitment, it shall pass an order rejecting the commitment application and proceed with its inquiry under section 26 of the Act. The procedure for commitment offered under this section shall be such as may be specified by the regulations, and the regulations have been framed, and I should show to your lordship those regulations, the commitment regulations I showed to your lordships. No appeal shall lie under 35B, 53B against any order passed by the commission under this section. An analysis, therefore, of the provisions of 48B will indicate that there is a right for a party to say, please close this investigation. I know there are certain anti-competitive conduct on my part. I will now steer clear of it going forward. That is the commitment that I am giving to the commission. And then when that is done, there is no penalty, nothing. That's the end of it. And the commission says, well, I think you're a good boy. You have realized the problem. So I will let you off. But do this going forward. Don't do what you were doing. So this seems to be the scheme of the statute. Now, if this is the position, and this can be done when, my lord, after 26(1) order has been passed, before a copy of the report is given under 26(4), that is the window that is available.
Now, with the impugned order,
yes,
that window is gone.
They have put that's why, my lord, I said they have put this law on its head. The whole thing is reversed now. There is no prima facie opinion by the commission. Admittedly, my lord, no dispute on that. There is no order that has been passed against me under 26(1). Without an order being passed against me under 26(1), you straight away have issued a notice for investigation for inquiry under the Act.
Yes.
Because I should see, my lord, under 26(4), when can an inquiry be started? Your lordship may just go back to 26(4) for a minute.
Yes.
And 26, my lord.
Yes.
Your lordship may kindly see, my lord, subsection 7.
If after consideration.
Yes. If after consideration, the objections or suggestions referred to in subsection 5, if any, the commission is of opinion that further investigation is called for, it may direct further investigation in the matter by the Director General or cause further inquiry to be made in the matter or itself proceed with further inquiry in the matter in accordance with the provisions of this Act. If the report of the Director General referred to in subsection 3 and 3B recommend that there is a contravention of any of the provisions of this Act, the Commission is of the opinion that further inquiry is called for. It shall inquire into such contravention in accordance with the provisions of this Act. Upon completion of the investigation or inquiry under subsection 7 or subsection 8 as the case may be, the Commission may pass an order closing the matter or pass an order under 27 and send a copy of its order to the central government or the state government as the statutory authority or the parties concerned as the case may be. Therefore, the entire procedure, my lord, contemplates that there should be an inquiry by the DG. DG passes an order, inquiry report. Report may say there is no contravention. That's the end of the matter. They may accept it. They may say, sorry, DG, I don't think you have looked at one other aspect, or your investigation doesn't appear to be complete. Please further investigate. So second course open to them is direct further investigation. After all that is done, they hold an inquiry. DG report is not, my lord, the final. It is they who have to decide. The DG, my lord, that is why I showed to your lordship the statement of objection written. It says that the DG does not have
Suo motu
powers. DG has to act only on the basis of an order passed by the commission. And the question, my lord, that I ask myself and I place that for your lordship's kind consideration
Is it an admitted position that there is no order from
yes,
the commission?
there is an admitted position that there is no order.
No, I would not endeavor to disrupt the flow of thoughts by Learned Train. But probably you should tell your lordships whether this key would apply to this case at all.
Of course it does.
The
I will show
provisions-
I am aware
The
of it.
provisions come much later in point of time. The
Yes,
regulations come at later in point of time. I just wanted to say that.
He's right. In fact, that is the reason why, my lord, I specifically pointed out, I am quite conscious of the objection that has been taken in the statement of objections, that the commitment provisions came only in 2022.
Yes.
And that's why, my lord, 2023.
Amendment, yes.
2024.
Four amendment.
My lord,
yes.
that is, my lord, on 6/3/1924 or 2024. Correct.
Yes.
But the question, my lord, is as on 28/8/2024, did I have a right? That's the crucial date. That is the first time that I am told that you are a OP.
If the investigation has taken place earlier, the result is only drawing you as an OP.
Yes.
What is the procedure that would be followed? Because this comes about on 6/3/2024.
This is only-
48B comes then.
Commitment is not a procedure.
True, commitment is
See, the procedure
compounding
is
of an
already there.
offense, that's all right. Now 6/3/2024,
Yes.
the 26(1) had already happened
Yes.
by 6/3/2024. Is that correct?
Which one, my lord?
26(1), the investigation had happened.
Yeah, against us, no investigation at all. Of course, my lord, there's no investigation against us.
No, only two, Amazon and Flipkart.
That's all.
Yes.
And I showed your lordship that
So
report.
that's that. Investigation had happened, Amazon
That's
and
all.
Flipkart.
Yes.
So 20, this, the,
And I'm and in the
No, the-
batch of petitions that are there before your lordship's, my lord, Amazon and Flipkart are not here.
no, one clarification.
Yes, ma'am.
The ball was set in motion, Amazon and Flipkart. Now, in the interregnum, this amendment comes about.
Correct.
Now, after the coming of the amendment, you are drawn as OP.
Yes.
Now, for that, there is no basis, is what you say, because there is no investigation against you at all.
That's right.
So, if there is no investigation against you, and for the first time you come here, you have lost the right of 48B
Yes.
of getting the offense committed or compound, whatever you say.
It's not compound, it's commitment.
That is the broad submission you're making.
Yes. That's. Therefore, my lord, the fact that the learned attorney points out that this amendment came subsequently is not material, insofar as we are concerned. Because if after the report had been submitted by the commission, an order had been passed by the commission, and I showed your lordship the regulations of the commission relating to impediment, then I would have had the benefit of the provisions of 48B. Therefore, the fact that 48B came subsequently, somebody else, how does it take away my right? If the commission had followed the procedure under 26(1) and passed an order, me, I would have had the benefit of 48B. Today, you have jumped all the provisions of the statute, you have gone across all that, ignored everything, and then straight away issue a communication saying, I'm sure treating you as opposite party. Now, if I therefore take 28/8/2024 as the date, by then, my lord, this provision was there. Then where is the inquiry? Where does it begin? Where does it end? So the provisions of this, the provision of 48B, my lord, has been completely given a go by. And it's all right, my lord, for them to take shelter saying, it came subsequently. So what? That's the point I'm going to. That's why, my lord, I point out to your lordship that this was introduced by an amendment. And I'll make my submissions on the amendment, my lord, when I come to it. I just want to finish the
Yes.
provisions of the statute.
Yes.
Then, my lord, having seen the, kindly see, before I go further, my lord, I'm sorry to take your lordships back. Would your lordship be kind enough to turn to section 41 for a minute?
Yes.
36 first and then 41.
Yes.
In the discharge of its functions,
Yes. Power of the commission.
yes, my lord, to
Yes.
frame regulations. In the discharge of its functions, the commission shall be guided by the principles of natural justice and subject to the other provisions of this act or of any rules made by the central government. The commission shall have the power to regulate its own procedure. The commission shall have, for the purpose of discharging its functions under this act, the same powers as are vested in civil court under the CPC while trying a suit in respect to the following matters.
Yes.
Then, my lord, subsection 3. The commission may call upon such experts from the field, but not all that we may not.
Yes.
And then now kindly see 4. That's important. We were called upon. We were called upon. Please see subsection 4. The commission may direct any person to produce before the Director General or the Secretary or any officer authorized by it such books or other documents in the custody or under the control of such person so directed, as may be specified and described in the direction, being documents relating to any trade, the examination of which may be required for the purpose of this act, to furnish the DG or the Secretary or any other officer authorized by it as respects the trade or such other information as may be in his possession in relation to the trade carried on by such person as may be required for the purposes of this act. The reason why I'm reading this provision for your lordship's consideration is, if it is a third party, then 36(4) says, please give all the assistance, cooperation, documents, information, etc., to the DG. This
Yes.
is not in respect of a OP. This was the third party.
Yes.
Therefore, the law itself makes a clear distinction between an OP and a third party. Now, my lord, please be kind enough to turn to section 41.
Yes.
The Director General shall, when so directed by the Commission, that, my lord, your lordship saw under 26(1),
Yes.
assist the Commission in investigating into any contravention of the provisions of this Act or any rules or regulations made thereunder. The Director General shall have all powers as are conferred on the Commission under subsection 2 of section 36. That's what your lordship saw, my lord. 36.
Yes. Yes.
Yes. And your lordship may kindly mark, my lord, the opening of section 41(1). The Director General, when so directed by the Commission, even here, even in the proceedings before the Commission, the Director General has no right to come and say, I want to participate. You come if I direct you.
No, that's in the objects and reasons.
That's what, that's it. No, I'm only showing your
No,
lordship.
no kind of suo motu powers.
No kind of suo motu powers. He can't start an investigation. He can't do anything beyond what the Commission has told him to do. The Director General shall have all the powers as are conferred upon the Commission under subsection 2 of section 36. Without prejudice to subsection 2, it shall be the duty of all officers, other employees and agents of a party which are under investigation to preserve, etc., records. Now, my lord, please be kind enough to turn to subsection 4.
Yes.
Yes. Yeah, I'm coming to 4. 4. Kindly see 4. Director General may require any person other than a party referred to in subsection 3 to furnish such information or produce such books, papers or other documents or records before it, or any person authorized by it in this behalf, if furnishing of such information or the production of such books, papers, or other documents or records is relevant or necessary for the purpose of its investigation. This is again a power given to the DG to ask a third party to say, please produce your records, because I think it is necessary for the purpose of investigation which I am conducting.
This also is not done.
My lord, in our case, I think, my lord, the DG did ask for documents and we have furnished it. In our capacity as third parties.
That's all right. This
Yes,
is
my lord,
third party itself.
answer to the court's
Whether-
question, my lord, is,
Yes.
were we asked? Yes, my lord.
You
And
are
in
asked.
fact, we have cooperated in investigation. No difficulty about it.
Yes.
It is nobody's case that the petitioners before your lordships, my lord, did not cooperate with the investigation before the DG. We did. DG asked us to produce documents and then we have given the documents. All that has been done. If the Director General may keep in his custody any information, books, papers, other documents or records produced under subsection 3 or subsection 4 for a period of 180 days, and thereafter shall return the same to the person by whom or on whose behalf the information, books, papers, other documents or records were produced. And then, my lord, examine on oath, etc., etc. The detailed procedure to be followed by the DG is set out, my lord, in section 41.
Yes.
Now that I have shown to your lordship this, and I have shown to your lordship section 48B, now let
Yes.
me show to your lordships, my lord, the relevant regulation first. 41? Yeah, one. But would your lordship kindly see also, my lord, I think, my lord, 41(6) may also be relevant for your lordship's consideration. Director General may examine on oath.
That's procedure.
Yes, that's the procedure. That's the, kindly see, my lord, the reason why I'm pointing out, your
41
lordship, my lord,
deals-
is the same distinction that the statute has made between a party under investigation and a third party. Now please see 41(6) in
41
that
deals
line.
with procedure qua third party.
Yes, that's what. Please see, my lord, kindly see 41(6).
Yes.
Director General may examine on oath any of the officers and other employees and agents of the party being investigated. So, my lord, 41(6)(a) relates to a OP.
It's not TP.
My lord?
It's not third party. It's opposite.
No,
party.
no. It's a third part. That's what. B, now kindly see B. Director General may examine on oath B. With the previous approval of the commission, any other person. The other person is
Third party.
person other than the party being investigated. That's a third party. And even there, kindly mark the words, my lord, with the previous approval of the commission.
Correct. That is
That,
the foundation.
That's the foundation. That's why I'm pointing out, your lordship, my lord, that the DG just cannot say, in the course of investigation, it's not like the police, my lord, who say in the course of investigation, no doubt the complaint is against A, but in the course of investigation, I find B and C have also done the same offense.
Correct. That is the filing of charge sheet. You can draw.
You
Everybody.
can, not that way, it can't be done. That's what I'm trying to point out. That is the distinction, my lord, in the procedure prescribed by the statute. So, my lord, 6A refers to a party being investigated. 6B refers to any other person. Therefore, the statute itself makes a clear distinction between opposite party, who is the party being investigated, and a third party, that is a party other than the party who is being investigated. There is nothing on record to show, and without fear of contradiction, I tell your lordships, on the basis of the statement of objections filed, that there is no order by the commission treating us at any point of time that we are opposite parties, excepting the bolt from the blue, namely the 28/8/2024, the impugned order. There's nothing else. Now, my lord, your lordship may kindly look at the relevant provisions, my lord, of the regulations.
Yes.
Lord, if I may, come your lordship to take this compilation at page 11.
Which already given.
Yes, my lord, what we just now given.
Yes. Page 11.
Yes, my lord.
Yes.
These are the 2009 regulations, my lord.
Yes, yes.
The Competition Commission of India General Regulations 2009.
Yes.
If your lordship will be kind enough now to see the definitions. It's comparative. Couldn't. Oh, sorry, sir. Sorry.
Which way?
Page number 11.
It's okay.
My lord, kindly see, my lord, regulation definitions under section 1I.
Party.
Party. 21I.
Yes, yes.
21I.
Regulation 219.
Yes, 21I. Party includes a consumer or an enterprise or a person defined in clauses F, H, and L of section 2 of the Act respectively, or an information provider or a consumer association or a trade association or the DG defined in clause G of section 2 of the Act, or the central government or any state government or any statutory authority as a case may be, and shall include an enterprise against whom any inquiry or proceeding is instituted, and shall also include any person permitted to join the proceedings or an intervener. Mark the words, my lord, includes an enterprise against whom an inquiry or proceeding is instituted.
Yes.
So, my lord, a person against whom a inquiry or proceeding is instituted is a party.
Yes. The same thing in the
DG is a
section.
party. DG is a party. No difficulty. The person against whom an inquiry is instituted is a party. No difficulty. A third party is not a party. That is what I want to point out, your lordship.
Same 2KA of the Act.
Yes, my lord, it refers to that. Now, kindly see, my lord. lordship may kindly turn
Definitions
to-
under the Act, section 2,
Yes.
KA.
No, my lord. KA is slightly different, if I may point out, your lordship.
Slightly different?
Yes, my lord. Because that was introduced, my lord, with effect from 18/5/2023.
Correct.
Yes, your
But
lordship
this
may
is
kindly-
2009
Yes,
itself.
yes, that's
All
fine.
right.
That's fine.
Yes.
Now, my lord, your lordship may kindly turn to regulation 24.
Yes.
I was telling your lordship, my lord, that the statute and the regulations provide for a set procedure by which a party who is not a opposite party can be dragged into the proceedings as an opposite party, even though initially you were a third party. Now, what is that procedure, my lord? It is not that the commission can do it just like that, as it has been done in the instant case on 28/8/2024. Now, please see 24, regulation 24 at page 12. The commission, kindly see the heading, my lord. Power of the commission to join or substitute parties in proceedings.
On an application made in writing.
Commission on an application mean by writing.
Whose
by-
application?
Well, exactly. Your lordship will come to that. I'm very grateful to the question.
Yes.
By whom? It
Yes.
is mentioned there. By any party to the proceedings. DG is a part. That is why I read to your lordship the definition of the word party. DG is a party to the proceeding. Therefore, DG could have gone to the commission and said, look, I want to join A, B, and C as parties to this case in addition to Amazon and Flipkart.
Oh, wait a minute. So what you're saying is proceedings are already initiated against Amazon and Flipkart. By a party to the proceedings, that is Amazon, Flipkart, or DG is a party as you read. DG had to make an application to the commission to include all these as opposite parties. That is what you're saying.
Exactly.
And that procedure is not.
No,
followed.
admittedly not.
All right. Yes.
Admittedly.
All right.
This is the point.
Yes.
Therefore, the regulations, the regulations will not clearly tell us how a third party can be made an opposite party. The commission on an application made in writing by any party to the proceedings may combine any number of persons or enterprises, whether jointly and severally, separately, or in the alternative, as parties in the same proceedings in an ordinary meeting. That is the meeting of the commission. If A, any right to relief in respect of or arising out of the same act or transaction or series of acts or transactions alleged to exist in such applicants, whether jointly, severally, or in the alternative. My lord, when an application is filed by the DG in the instant case, it should have been done. Then it is not as if automatically it is, the commission will add the A, B and C as parties. No. The commission has to be satisfied with respect to matters specified in A, B and C. Now what is B, my lord? Kindly see A, I read to your lordships.
Yes,
Now see B. The applicants can show
yes.
to the satisfaction of the commission that common question of law or fact would arise. Therefore, it requires, my lord, a judicious application of mind by the commission on the application that is filed by the DG to join a third party as a party to the proceedings.
Yes.
And see, the commission is satisfied that the participation of such person or enterprise, as the case may be, is necessary for the determination of the issues before it. And
Now, one
I'm
clarification,
sorry.
sorry. I have just clarify the doubts that's all,
I bowed down.
Now, you said Director General is a party here. The communication should have emanated from the Director General. These proceedings are admittedly after 2023. KA is in place.
Yes,
KA is the section, the Principal Act.
yes,
Regulations are framed power under the Act.
yes.
This does not include Director General here in KA. So whether it emanates from Director General or otherwise, with this amendment,
I understand.
because your entire submission was it should have emanated from the Director General,
Yes,
who is a party to the proceeding, to include these persons as parties.
yes.
Now with this KA, the Director General is omitted here.
No, my lord. It only says
No, it
includes.
only says
It
C.
only includes.
No, Trade
A
Association,
party includes.
where is inclusive?
KA, my lord.
KA.
Includes.
Director
It
Gen-
is not necessary, it is not that.
No, here there was specifically Director
That's
General.
right. Therefore, the
Here it
commission
is not
regulations.
there.
Yeah, that's, yes.
No, why I'm saying this is section, this is regulation.
Yes, yes, it doesn't really matter, my lord. The regulations are not in contravention of the section at all. The section only says party includes a consumer, an enterprise or a person
Correct.
or an information provider or a consumer association or a trade association or the central government or any state government or any statutory authority, as the case may be.
Everything else is the same, except the words Director General defined in clause G of section 2 of the Act is omitted.
Well, that's true. Now, that's please.
What would prevail?
Well, I would say, my lord, that the regulations are not against the statute. A
No,
statute
because
only
the
says
foundational
includes.
statement was the communication should have emanated from
Yes,
the
yes.
Director
Yes, my
General
lord.
for adding you as opposite parties.
Yes, my lord.
Because party as defined under the regulation includes Director General.
Correct.
Now it excludes here in 2K.
No, it doesn't include. It only says party includes A, B, C, D, E, F. It does not, it's not exhaustive. It is not party means.
All right, no doubt that's.
No, it
yes,
does not
yes.
mean it. I understand.
Yes.
Hold on. We cannot have any greater pleasure
Yes,
than a query from the bench.
that's what.
That's.
Yes.
I want to put it in this way, not in answer to the Honorable Court's query. Party in KA is not an exhaustive definition. It does not say it means. It says it includes A, B,
No,
C,
that is
D.
what includes a consumer.
That's all. It only says includes. It is not. It does not say
No,
means and includes.
both are includes. It's not. It doesn't say means.
My lord?
No, both are include. It begins with includes.
Yes. Both, my lord.
Regulation and
even,
KA both.
It says your lordships are right. Even the regulations say it includes. The first answer I give to my lord is: are the regulations going beyond the definition of KA in the statute? The answer to that question, my lord, I would say is no. Why, my lord? Because the definition is not exhaustive.
No, when I heard you say
Yes.
that it should have emanated from the Director General.
That is because of the regulations.
A regulation.
Yes.
So that was your sheet anchor.
Yes.
So it is not here is what I
It is
want.
true. It is not there. My lord, I bow down to what the court is
Yes.
pointing out. My lord, that there, I mean, it's not there, it's quite clear.
Oh,
It's
yes,
quite clear,
yes.
my lord.
No, just to clarify myself.
Correct, madam.
yes.
But does that make the regulations doubtful of its validity? No.
No, it's not. There's no doubt about its validity.
Yeah, if there is no doubt, then the definition of party as contained in the regulations.
Party, even in K, we'll have to draw Director General into it.
Exactly what I'm saying.
If we have to answer that.
Yes, madam. Now, my lord, please look at the power to make regulations.
36.
Yes, madam.
Hmm.
Which I showed to your lordships when I was.
Yes. Section 36,
Yes,
right?
madam.
Yes.
In the discharge of its functions, the commission shall be guided by the principles of natural justice and subject to other provisions of this act and of any rules made by the central government, commission shall have the power to regulate its own procedure. But what is now clear up to now is that the DG has no suo motu sui generis power to act. That is point number one. That when the investigation was ordered by the commission, it was only against two entities, namely Amazon and Flipkart, not an issue. That we were not parties at any point of time as opposite parties, not in dispute. Till, my lord, the impugned communication comes into existence. That there is no order that has been passed by the commission joining us as opposite parties, not in dispute. That there is no proceeding before the commission to join us as opposite parties, not in dispute. Without all this, the question is, can there be a notice issued to me under 28(8), circumventing, my lord, 26(1) completely?
Yes.
Suppose, my lord, the commission had said, well, I don't think I need to proceed against A, B, and C. Prima facie, I don't think there is a case made out.
Yes.
My lord, why, I ask myself, should I be subjected to the proceedings before the commission without the safeguard put in the act against a vexatious and frivolous proceeding? My lord, why I ask myself is 26(1) enacted in the statute in order, my lord, to ensure that the proceedings are before the commission is not misused, is not used to promote business rivalry between A versus B, between the complainant before the commission and the others. My lord, maybe, my lord, shopkeepers who are selling mobile phones may think, my lord, that they're losing business because on the platform of Amazon or Flipkart, the phones are being sold at a lesser price for whatever reason, because a brick and mortar shop is always more expensive, my lord, than selling it on a platform.
No, that the rival is always there.
That I will. Now, will you, I ask myself, use the provisions of the statute in order to settle your scores instead of doing it in the marketplace? That is the reason why 26(1) is enacted. The commission says, no, I think you are trying to misuse the forum of the commission. You are misusing the provisions of the Competition Act.
That is why prima facie.
That's why prima facie case.
26(1) says prima facie
Prima
because
facie,
of this.
Now, that today, no order.
According to you, complaints may galore. Rival operators, rival business, they may complain. Prima facie opinion and beginning of proceedings is what 26(1) contemplates.
Today, admittedly, my lord, there is no opinion that has been formed by the commission that prima facie a case is made out against A, B, and C for violation of any of the provisions of the statute. That protection is taken away. That's the point, my lord, that we are making for your lordships. And these are all admitted facts. When I have finished reading
Correct,
this, I'm
yes.
going to show to your lordship the
No,
statement
you
of
continue.
objections.
I disturbed you, I guess.
No, my lord. I am very grateful, my lord.
No, whatever clarification.
Absolutely, my lord. In fact, it also, my lord, it's not as if, my lord, we would have noticed all the provisions. There are always, my lord. That's why, my lord, this is the benefit of a oral submissions in court,
Yes,
as opposed to
written submissions.
in fact, my lord,
In the
there is
West,
in fact, it appears, my lord, a commission was appointed in England to find out the merits or demerits of oral submissions as opposed to written submissions. As your lordships are aware, my lord, in the United States, most of it is
written
written.
submissions, yes.
Whereas, my lord, the common law system permits, my lord, oral advocacy. And the report came back and said, my lord, a meaningful shrug of the shoulders of a Queen's Counsel is worth 100 pages of written documents.
My learned friend reminds me of the argumentative Indian book.
Yes, yes.
So this is how, my lord, therefore, my lord, this is
Yes.
apart from the case, my lord, it keeps us young.
That's
This type of a debate.
the core issue.
Core issue, my lord. Speaking personally, my learned friends are all very young, my lord, but so they are in a different boat. So my
Yes.
lord, now I go back to the regulations. Your lordships have seen the regulations. My
Yes.
lord. There is no contradiction between KA on the one hand and regulation, my lord, L on the other. I on the other.
One more
Yes,
clarification.
please.
Sorry. You said Director General has no suo motu powers of any kind.
Of any
For
kind.
anything. For anything.
But with a caveat. So he can possibly say in the course of investigation,
Wow.
I call upon
Exactly.
you to.
This is
that-
where I
that-
was asking.
That much again.
If Director General has no suo motu power to do anything, how can you expect him to communicate these are the parties should be added as opposite parties? I have found something against them during investigation with Amazon on Flipkart. Is that permissible?
My lord, that the Director General has no suo motu powers
To initiate
to
investigation.
initiate is what I'm saying.
But this communication, yes.
Not to us.
No.
He should
to
go and tell the commission.
Not to
He
you.
has not
Not
done
to you at
anything.
all. I'm not referring to a party at all here. Now, Director General, while investigating two parties, now Amazon and Flipkart, comes across certain violations of the Act, qua others. Now, is it that he has no power to even communicate that to the commission?
He has.
Saying that, yes, these are the things I have found. These also are to be
Oh
investigated.
yes, he can. My lord. That is why 24.
That is why
That is why
suo
24.
motu powers, as found in the objects and reasons, is only for the purpose of commencement of investigation.
I agree.
During investigation, he
He
has
can.
powers to
Of,
communicate.
my lord, in investigation, he can even call upon third parties to produce documents.
Exactly,
All
that's
that he
what-
can
yes.
do. He has got the same powers as a civil court. He can
So
summon.
it is not that he is toothless. It is only to begin
no.
investigation.
No,
Yes.
I'm not saying he's toothless. I am saying, but his investigation is confined to the parties he has been directed to investigate.
How can investigation be confined to the parties? Because he is investigating into
Go
it.
back. If you
While
go-
investigation, he finds so
He
many
can.
other parties.
Go back to the commission and says, sir, in the course of my investigation, I have found in addition to Amazon and Flipkart.
That
there
is
are
not done
That
here,
is
is
not done is what I'm saying.
All right.
Of course, my lord. That is why 24 specifically gives that power.
Correct.
The commission on an application made in writing by any party to the proceeding, which includes the DG,
DG.
may combine any number of persons or enterprises whether jointly and severally,
No,
separately.
that is
or
regulation 2I.
2I,
And
read
20
with 24.
24.
Read with 24. And when the DG comes before the commission,
Yes.
now this is the second stage of filtration. Now 26(1), not there. Today, regulation 24 protection also is not there, taken away so far as I am concerned, because when a DG comes before the commission and says, sir, I want to make A, B and C also as parties to the present proceedings to join them, it is not as if the commission will say, yes, DG, I will make them parties because you have requested me to do so. No, the commission has to apply
Proceed,
its judicial mind. Now that has not been done. There is no order by the commission joining me as a party. There is no application by DG, no order by the commission saying, yes, DG has requested A, B and C to be made parties. I have investigated, I have looked into the matter, and I think A, B and C are cumulatively satisfied. Your lordships may look at that, but it is not one.
No, it's
Not,
three. A, B,
it
and
is
C,
not
yes.
like in the CPC where it is proper or necessary parties. All the three have to be satisfied. In any ordinary meeting, if any right to relief in respect of or arising out of the same act or transaction or series of acts or transactions is alleged to exist in such applicants, whether jointly, severally, or in the alternative, applicants can show to the satisfaction of the commission that the common question of law or of fact would arise, and C, the commission is satisfied that the participation of such person or enterprise as the case may be is necessary for the determination of the issues before it. Please mark the word "and." Therefore, my lord, the three preconditions before a person is added as a party to a proceeding under 24 have to be satisfied
Yes, it's here.
on an
again.
application that is to be made by a party to the proceeding, and in the instant case, there is no such application. My lord, the controversy as to whether DG can do it, anybody else can do it, DG not being there as a party
Need not be gone
may
into.
not be very important, my lord, in the facts of case, because
But there is nothing
there is
emanating.
nothing. Nobody has come before the commission to say, please make these people as parties. Then possibly, my lord, the controversy is, oh, is an application made by somebody else maintainable, or it should be by the DG, or can the DG make an application? In the absence of DG being specified in KA, all that may be, if I may respectfully, with
Yes.
all humility at my command, say, my lord, academic in the instant case. Because there is no application by anybody. There is no application of mine by the commission. There is no order passed by the commission. Straight away, I am faced with a communication of 28/8/2024. Now, my lord, kindly now see sub-regulation 2. If in any proceeding it becomes necessary to substitute a person or enterprise for an existing party, commission may make an order for substitution. We are not concerned with that today. We are concerned with 24(1). On an application made by a party admitted to the proceedings under sub-regulation 1 or sub-regulation 2, secretary shall furnish to the person or enterprise as the case may be, joined or substituted as parties, copies of such documents previously filed in the matter by other parties as may be decided by the commission within 10 days of the order. Your lordship may mark that word.
Yes.
So, my lord, the regulations themselves contemplate an order.
Yes.
My lord, where I ask myself, is this order contemplated under regulation 24? So far as I am concerned. And the statement of objections is clear that there is no such order.
Yes.
Yes. And once if I am added, of course, my lord, regulation, sub-regulation 3 specifically says, secretary should furnish to me all the copies. Nothing has been done in this case. Oh, the first time I am faced is on 28/8/2024 when I get this communication.
No, that is on an application made by a party admitted to the proceedings.
Yes. Application contemplated under 24(1).
Yes.
Admitted is an order, my lord, under section 24(1) where the commission is satisfied.
Yes.
Then the secretary must give me copies. So, my lord, these steps are very clear. First, an application should be filed. That application must disclose the reasons as to why I should be made a party. The commission must look at that application, form its conclusions, cumulatively holding A, B, and C satisfied. Then an order is passed that I am to be made a party. Thereafter, my lord, the secretary must furnish copies to me. None of this has been done. No application, no order, no reasons, nothing. Straight away, my lord, it can't be that I am issued a notice on 28/8/2024 saying, look, I am treating you as parties. Yeah. I will come. Now, my lord, your lordship may kindly now turn to the next regulation which is relevant, my lord.
Yes.
Please see, there is what is called as a confidentiality ring under the statute. Your
Yes.
lordship may kindly turn to regulation 35.
Yes.
The commission shall maintain confidentiality of the identity of an informant on the request made to it in writing, my lord. And then there are elaborate procedures which I am going to skip. Kindly turn to regulation 37.
Yes. Inspection.
Yes, my lord. 37 is important, my lord. Your lordships will recall, I mentioned to your lordship that 37 makes a distinction between a party, that is opposite party, and a third party.
Yes.
Please see 37. Subject to the provisions of section 57,
Yes.
and regulation 35, a party to any proceeding of an ordinary meeting of the commission may, on an application in writing in that behalf, addressed to the secretary, be allowed to inspect and obtain copies of the documents or records submitted during proceedings or payment of fee as may be specified in regulation 50. Now, who, my lord, is entitled to this as a matter of right? A party to the proceeding. Your
Yes.
lordship will see the opening words of regulation 37(1).
Yes.
Now what happens if I am not a party? If I then make an application for inspection and copies? That, my lord, is regulated by 37(2). The commission may, on an application of a person who is not a party to the proceedings, on sufficient cause demonstrated, allow such a person inspection of documents or records mentioned in sub-regulation 1 on payment of fee as may be specified in regulation 50. So, my lord, as a matter of right, a party to the proceedings has a right of inspection and getting copies under 37(1). If I am not a party, then, my lord, it is a matter of discretion by the commission. The commission can say, show me why you want it. If you show that there is sufficient cause and you demonstrate it, then I will allow you. Now, my lord, in this context, I want your lordship to kindly see an important factual position. Please be kind enough to turn to page 61.
Of the petition?
Yes, my lord. Yes, my lord.
Yes.
My lord, we made an application
Yes.
on 27/7/2023 through our lawyers
Why did you make an application?
because we wanted copies of inspection.
No, you were.
I was not a party.
You are not yet drawn in.
Yeah, that's why I'm entitled to make an application. I have to make an application under 37(2). 37(2), a third party application.
No, no, what was the need?
But we want, because
Like
we're
that?
not, there was a lot of investigation that was going on. They came to us, they took our documents. DG wanted all the information. We also want to know what all the things that you have collected. My lord, why? Maybe, my lord, I did it without, let me assume for the sake of argument that I did it without sufficient
That's all right.
cause. That's a different
You're
matter.
anyway a third party.
That's the point.
Third party is governed under 37(2). You have made an
No, my lord,
application.
that's very important. That's the point
The
I'm making.
investigation is there or not there, any third party can
I'm a
apply.
anybody can do. I can do it as a matter of interest. I'm a newspaper journalist. Please give me copies.
Or people not connected cannot.
That is for the commission to say.
Yes.
Making an application, anybody can do.
All right.
Granting or refusing is for the commission to decide. Saying, well, sorry, you have not demonstrated sufficient cause. Now, my lord, please see this letter. That's very important. Now, my lord, this is a communication addressed to our lawyer.
On sufficient cause demonstrated.
Yes. Now, kindly see, my lord. In this regard, the undersigned is directed to state that the commission considered the aforesaid application filed by Darshita and noted that no sufficient cause has been demonstrated by it as required under regulation 37(2). So, my lord, even as of 27/10/2023, I was treated as a outsider. I was treated as a third party. I asked myself, what happened between 27/10/2023 and 28/8/2024?
Investigation was on.
No, report was there.
The investigation report was
Yes,
already
yes,
there.
my lord, I tell you, that's the important point. my
Date
lord.
of the report,
I will give you your lordship.
that's the most important thing.
My lord, the investigation report is dated 11/12/2023. That is the breakup report,
11/12/20.
2023. The investigation is over. The report comes on 11/12/2023. And then, my lord, there is another interesting aspect I want to point out to your lordships, my lord. Now, my lord, the report was submitted on 9/8/2024. My lord, a consolidated report was given on 11/12/2023. There was a split report given on 9/8/2024.
So you are drawn on 28/8/2024
That's
pursuant
correct.
to that.
That's correct. That's correct. That's the sequence of events. Now the question is, what happened between 27/10/2023?
That is when you were.
Yes,
not-
when I was told,
not
sorry, I will
divulge- Not divulge the information
Yes,
as
I will
sought
not
for.
give it to you under 37(2). Well, those dates are there, my lord, in our list of
No,
dates.
no,
We
no,
have put them.
I'll look into it.
Yes,
yes,
that's
yes.
right. Now, my lord, therefore, on 20, what happened is, question, my lord, is what happened between 27/10/2023, on which date, admittedly, I was treated as a third party and I was denied access of inspection and copies under regulation 37(2). Is there an order that has been made after
To
27?
draw you as OP.
To be asked. Admittedly none. Huh? That's all. 27. So therefore, my lord, the question, my lord, therefore would be, if they're able to show an order, then, my lord, all that I'm saying may not be.
Yes, everything will fall flat.
Nothing.
Yes.
There is no order, admittedly. So they just can't do this.
Even in the objections, there is no order.
Admitted that
produced.
there is no order. I will show to your lordship the objections. I will show to your lordship. I'm coming to that. Let me complete the
All right.
statutory
No,
provisions.
yes, yes.
Admittedly, my lord, there is no order that has been passed at any point of time in any event after 27/10/23, excepting on 28/8/2024, which I
No,
don't consider.
that is the impugned order.
That is the impugned order. And that is not an impugned order. Where is the satisfaction with
No,
respect
that's
to the
all.
three?
That's what is impugned. I say.
That's all. So this is the aspect, that
So
requires your
according
lordship's-
to you,
Yes.
27/10/2023 to 28/8/2024, the procedure that is necessary to be followed to draw someone as an opposite party is completely given a go by.
Completely. Nothing has been. And even the date on which, my lord, the investigation was ordered, your lordship may kindly look at that, my lord.
Yes.
That is, my lord, on 13th of January 2020, which your lordship will find, my lord, Annexure B.
Yes, yes.
Your lordship may kindly look at that, my lord. That's very important at page
So
50.
for 3 long years
Nothing.
or 4 long years, rather, you are a third party.
I'm sorry. Till 2024.
Investigation was on.
Yeah. And now, my lord, when your lordships are looking at page 50,
Yes.
there is a very important, one significant aspect which is borne out, supporting what I have been saying.
Yes.
Kindly see who are the opposite parties.
On page,
My lord, 50.
Flipkart, Amazon.
That's all. Only 2 of them.
Yes.
And kindly now see, my lord, in that prima facie opinion, I just want to draw your lordship's attention to a few paragraphs of this opinion. The prima facie opinion, please be kind enough to turn to para 26, my lord, at page 59.
Yes.
Yeah. This is, my lord, up to paragraph number 26. They're all allegations. Now, where is the the prima facie opinion of the CCI, which is the prerequisite for proceeding further, having regard to 26(1). Your lordship may kindly see 26, para 26 now.
Thus the commission.
As the
observed.
commission observes that the exclusive arrangements between smartphone, mobile phone brands and e-commerce platform select sellers selling exclusively on either of the platforms, as demonstrated in the information, coupled with the allegation of linkages between these preferred sellers and OPs alleged by the informant, merits an investigation. It needs to be investigated whether the alleged exclusive arrangements, deep discounting and preferential listing by the OPs are being used as exclusionary tactic to foreclose competition and are resulting in an appreciable adverse effect on competition, contravening the provisions of section 3(1) read with section 3(4) of the Act. The allegation, therefore, my lord, is as between the preferred sellers and the OPs. And then, my lord, kindly see 27 also. In view of the foregoing, the commission is of the opinion that there exists a prima facie case which requires an investigation by the DG to determine whether the conduct of the OPs have resulted in contravention of the provision section 3(1) of the Act, read with section 3(4) thereof, as detailed in this order. And it is the conduct of the OPs. And I'll tell you, Lordships, also, my lord, I should point out that to your Lordship. Any straw, my lord, for a sinking person is good enough. And I'll tell you, Lordships, what the argument is. Please be kind enough to turn to that at the top of the page, my lord, who is an OP.
Which page?
My lord, page 50.
50.
Yes. Sinking person, my lord, will catch hold of even a blade of a clutch at a straw in order to save himself. Kindly see what they're saying. Flipkart Internet Private Limited and its affiliate entities. And then say, see, we have not restricted it to Flipkart. We are also doing it on affiliated entities. It is not only Amazon, it's also its affiliated entities. Not a word to say, how am I an affiliated? I am a company independently doing business. And please see, my lord, paragraph number 1.
Yes.
This is what they are going to tell your Lordships. These are affiliate. Investigation has been started. They are the OPs. Then why did I ask myself, if that was so, why was it that regulation 37(2) was applied to me?
27/10/23.
Yes. Why did he apply it to me? If there was an order like this, the prima facie opinion order was passed on 13/1/2020. If 13/1/2020 you said that affiliates includes these A, B, C, D, then why is it when I ask myself that on 27/10/2023 you
Yes.
passed an order relying on 37(2)?
Yes.
On the face of it, that argument, my lord, if I may say so, as your Lordships normally say, my lord, when a frivolous contention is raised, it must be stated to be rejected.
Yes.
Now, my lord, your Lordship may kindly see the first paragraph of this opinion.
Present information.
The present information has been filed by Delhi Vyapar Mahasangh. That's what I told you, Lordships,
Correct.
that there's some association which has filed it. Hereinafter referred to as Informant/DVM, that is Delhi Vyapar Mahasangh, a society registered under the Society Registration Act and under 19(1) of the Competition Act, alleging contravention of the relevant provisions of section 3(4) read with 3(1) of the and section 4(2) read with section 4(1) of the Act by Flipkart, hereinafter referred to as Flipkart, Flipkart Marketplace, and Amazon, Amazon Marketplace, Flipkart, and Amazon are hereinafter referred to as opposite parties. My lord, no such affiliate is mentioned here.
Yes.
Affiliate, we all understand, my lord, under the Companies Act is where it is a relationship of a holding company and a subsidiary company.
Yes.
It doesn't mean, my lord, that anybody under the sun who has a relationship is an affiliate. How nice it will be, my lord, if we can have a share in the assets of Amazon.
Oh. Can go to the moon.
I know. This is the, if I may say so, my lord, this is what they're relying upon to say affiliated entities.
Yes. Hmm.
And now, my lord, I have shown to your
Better
lordship.
place if your Lordships later.
Yes.
There's an interesting article saying the paradox of Amazon's antitrust. It traces the entire history of what Amazon has been doing. Amazing.
Yes. Yes, sir.
By all means, my lord, proceed against Amazon. By all means, proceed against Flipkart. Do whatever is required. Everybody must comply with the.
Leave us alone.
Everybody must comply with the provisions of the law. I am not saying leave us alone, but please
No, in
deal
these
with
proceedings.
me in the manner the law contemplates. Even in these proceedings, if you want to do it according to the law. Lord, nobody is above the law of this country.
Course.
Nobody is. They're all, everybody is doing their business, but do it in accordance with the law. Otherwise, my lord, the entire provisions of the statute, which I thought, my lord, were fairly peculiar, are completely given a go by. I don't have the benefit of a commitment proceeding. I don't have the prima facie opinion. I don't have an application for joining me as a party. I don't have an order under which the commission records its satisfaction with respect to A, B, and C. Nothing. This is the point, my lord. Now, my lord, your lordship may kindly look at the commitment regulations, my lord, which I want to point out, your lordships. My lord, that commitment regulations are found where is your commitment regulation?
Page 20 in your paper book.
No, no,
Convenience.
20.
Page 20. That's 2024.
Obviously, my lord, after the provisions was introduced in the statute, I am now saying that if you had started, if you comply with the requirements of 26(1) and the regulation relating to impleading, if you do it, let me take for instance, my lord. Suppose, my lord, what I am saying is right, and my petition is allowed, and I am confident, my lord, that it will be. Let me assume that it will be. And then, my lord, a proceeding is started today. DG says, well, you're right. The High Court has said that we have not complied with the provisions of the statute. DG says, I am now making an application to the Commission to make A, B, and C as parties. The Commission then passes an order making me a party, which is the first step required under the regulations. And then the question would be, should I order an investigation? Again, go back to 26(1). At that point of time, on that day, admittedly, the commitment provisions were there. Admittedly, my lord. It may be today, it may be tomorrow, it may be 1 month later, 2 months later, whenever. Commitment provisions are there. Now, today, why is it being said that I don't have a right to the commitment?
No, that if this court would set things at naught, then they would initiate fresh
exactly, of
proceedings.
course.
Definitely 48,
That's what, that is the reason why I'm
48
saying
A and B,
B will be
48B will be applicable.
applicable to us. That's what
But
I'm
was
saying.
it applicable for an investigation that commenced long before 2024?
Investigation against AB and
Correct, against them,
Amazon and
against them,
Flipkart.
correct. But this comes into effect only in 2024.
My lord.
So commitment regulations will answer this.
If they can't, my lord, commit an illegality. My submission to your lordship is that they have committed an illegality. Now you can't say, yes, I committed an illegality, but because of what I did, you lose a benefit. My lord,
Because of
the
Amazon and Flipkart.
we are not concerned with Amazon. I'm concerned with the petitioners, but not the position.
No, that's what you said. If Amazon and Flipkart have committed some illegality, you should not be made to lose the benefit of commitment.
Lord, I'm not saying Amazon and no, Lord. If the commission has committed an illegality,
Commission has committed, all right.
if the commission has committed an illegality in issuing this communication of 28/8/2024, showing me as an opposite party, can you now say, no, investigation was much earlier?
So that's exactly the point. 28/8/2024, on that day 48B was there.
Was there?
You were drawn in for the first time.
Yes.
If you are drawn in for the first time, prior to that, you should have been given commitment opportunity in terms of 48B. Because 48B, 2 months at least before that, it was already in the statute.
Correct.
That's your submission.
Correct. And now that's one part of the submission. Another part of the submission. If I am right in my submission that today I am not a party, I am not an opposite party. Because this 28/8 communication, your lordships will hold is ultra virus the powers of the commission. Then, my lord, what happens? The DG will say, yes, I am now making an application to join these A, B, and C as parties. Order is passed. And then a prima facie opinion is recorded. Maybe in the same order, maybe in a separate order. That's a different matter. Because there may be a slight overlapping between an order, my lord, under the regulations, joining me as a party and 26(1). That's a different matter. My lord, or scope of 26(1) may be different. The order under the regulations making me a party may be different. That controversy, my lord, we will reserve it for another day. But The order making me or joining me as a party would be from sometime in the future. On that day in the future, admittedly, commitment proceedings were there. Yes. Now, am I not being deprived of that? Why? Because of the illegality that has been committed by the commission. But and how many times, my lord, your lordships have held that a party cannot take shelter under his own illegality and then say, I deprive on account of that illegality the right of another party. This is exactly what is being said. Yes, yes, I might have done something illegal, but don't worry, the investigation started long ago. But the right of commitment starts from the date on which the opinion is formed under 26(1). I can quite understand, my lord, if the section had said the right to commitment is from the date of investigation, and which date there was no such right. But that's not the section. The section clearly says it is from the date on which a 26(1) order is passed.
Yes.
And 26 order 1 may be passed, I don't know, may not be passed at all.
We'll see. We'll ask them.
There's no order today.
Today there is no order.
That's all that I'm saying. My lord, that is enough for my case, my lord. Today there is no order. And if there is no order today,
So tomorrow we'll see later.
we will say, my lord,
Yes.
that's another good day. We'll come. We'll come before your lordships.
Yes. That's it.
That's another innings, my lord. That's another innings.
Now, what is the allegation?
In the complaint,
in the
my lord,
complaint.
the complaint allegation, my lord, is that principally two allegations as I notice. One, my lord, is that you are a preferred seller. In other words, my lord, when somebody wants to buy a smartphone, your names comes on top of the Amazon list or the Flipkart list. Second, my lord, is that there is deep discounting. If a smartphone is available for 25,000 rupees in a brick and mortar shop, on Amazon website or Flipkart website, it is available for 20,000 rupees. Why? Because Amazon is trying to promote its own business by giving all these discounts.
So you're an affiliate of Amazon.
And the third allegation, my lord, is
Page 52 and 53.
Yes, that's complaint is there.
Whereas 7,
That's the
7.1, 7.2.
Yes, that's the complaint.
my lord, your lordship, may kindly, my lord, I'm grateful. I'm very grateful to my learned friend, my lord. Kindly see para 52, page 52.
Yeah, the whole of it.
Yes, yes, I will.
So I saw that. So what exactly is the
This is the
complaint
allegation, my
about?
lord. And the third allegation is that
Deep discounting is the primary allegation.
no, that's one of the allegations. Whether it is true, false, we don't know, my lord. Allegations are there. Who gives the allegation? Is it by me? Is it by somebody else? If the discounts are given only by the platform and not by me, how am I bothered? That's a matter between the commission and the platform. These are all disputed questions of fact.
That's exactly investigation is needed.
Exactly.
Yes.
Please do it. Nobody is saying don't investigate Amazon and Flipkart. They are not before your lordships.
Not you.
Not me.
The
I am only
procedure is
saying-
not followed. That's all.
That is all that I am saying. My lord, if as your lordships have said so many times, my lord, if the law requires something to be done in a
Correct.
particular way, it shall be done in that way and in no other.
So the entire fulcrum of the list revolves around procedural aberrations.
My lord, I would not respectfully, my lord, simply say it is
any.
procedural aberration.
If any.
I understand.
If any,
I
that I
of
will
course,
ask
of course, of course, I understand. Of course, my lord, I understand.
Yes. Yes.
Assuming there is one, I would not, my lord, simply categorize it as a procedural aberration. I would say, my lord, that there is a substantial deprivation of a right and a protection given by the statute.
So-
26(1) is a protection. Regulation to impede me.
So it is procedural protection being deprived has taken away your right to
Absolutely.
defend the action.
Therefore, my lord, it is not simply what's the harm that's caused to you? Is it mere violation of a procedural requirement? No. It is a procedural requirement which has within it the deprivation of a statutory right. That's why, my lord, this law is not, my lord, like, for example, my lord, if a particular document is sought to be produced before the court, and the court says, all right, produce the document. Direction is given. Your lordship will ask me when I come before your lordship will say, what is going to happen to you? Produce the document. Nothing is going to happen to you.
The normal circumstance is not applicable.
Not applicable is what I'm saying. The normal approach to such matters of procedural aberration
No,
is not
there are a lot of qualified approaches.
qualified approaches. Whereas everything is intrinsic. By providing for this filtration process, the law, my lord, has ensured that the law is not misused, rights of parties are not taken away, and most importantly, my lord, it is all, there is a public interest involved in every one of this. Do not use the act and the commission for the purpose of promoting your business rivalry.
So many issues are interwoven.
Many issues are interwoven. My lord, it's not simply a case of procedural aberration. It's a respectful and humble submission I
Yes,
make for your lordship's
yes,
consideration. Now, my lord, your lordship wanted to know what is the broad contours of
No,
the
that I
controversy.
see here.
Your lordship may kindly see. I'm not going to take your lordship the details, my lord. It's
Yes,
unnecessary for the purpose of this
No,
case.
because we are only
52,
on
my lord,
the-
kindly see. Deep
on-
discounting is one.
Yes.
Preferential listing, I told your lordships.
That's what,
Yes.
these, Vision Star, Flash Star, Commerce, one of you,
Which one, my lord?
no, paragraph 7.2, preferential listing.
No, my lord. We are not. No, we are not.
No,
To be
anybody,
products by
those,
preferred sellers
when you
such as.
search on Amazon, those are the persons whose,
And it says such
ads-
as, such as.
such
My lord, they are Flipkart sellers. Flipkart lends the word assured seller
sellers,
to the
yes.
products sold by its preferred sellers such as Vision Star, Flash Star, Commerce and Flash Tech
No,
Retail.
the Amazon fulfilled will have a preference over other players.
So
That
this
is
is
why
Flipkart,
Amazon
my lord. This is only for
fulfilled.
Flipkart. And Amazon, my lord, has a a
They
preferred
fulfilled.
seller.
Amazon fulfilled.
They are not
My lord,
affiliates.
Amazon
They're not
has
affiliates.
Not
Cloudtail.
affiliate. We are talking about preferred list.
Yes, yes.
No, we are not there. We are not there. I must
No,
tell
you're
you
not
that.
there.
Kindly see Amazon, for example. Amazon has preferred sellers on its platform, namely Cloudtail,
And
a
apparel
joint
retail.
venture of Amazon and Catamaran, and Aperio Retail, a wholly owned subsidiary of joint venture between Amazon, Mr. Ashok Patni, which received a round of investment from Frontiers of Business Services, which are related to Amazon. So, my lord, we are not. You are appearing for Aperio.
I'm silent, brothers. I appear for Aquario.
He will answer. He will answer. He will answer.
He who fights and runs away remains to fight another day.
From what my learned friend says, my lord, he is more interested in fighting the next day. My lord, we are not named anyway. No, my lord,
Another- Mr. Puvia reminded me of Bond movie, Die Another Day.
Another day, that's what. You'll have a chance to.
I don't realize e-commerce has 9 lives, brothers. So-
they like the cat, like the cat.
Yes.
Now, my lord, in a situation of this kind, to say, look at that heading in the prima facie opinion, Amazon and its affiliates. Lord, where am I an affiliate? Look at what you have said here when with respect to deep discounting. You have referred only to Cloudtail and Aperio.
No, this is only an information.
Information, that's all. Therefore, my lord,
No, this is only information. Information has triggered investigation. Investigation has drawn you here. Procedure is not followed to draw you as OP.
with only one caveat, my lord, which has mentioned. It is not procedure not followed. It is deprivation of my rights.
Rights.
So therefore, my lord,
Here it's-
I would not, my lord, respectfully, I would request your lordships not to treat this as simply a procedural aberration or
Correct. No,
a
no,
violation of the
it's,
procedure.
It's a higher pedestal than.
Higher
that,
pedestal.
yes.
That's the submission. That is, my lord, if there anyway, what is going to happen? Tomorrow you will be joined as a party. Why should I interfere in Article 226?
No, according to you, all the procedure that is stipulated here touch upon your rights.
Touch upon my rights, touch upon the public policy behind the law.
That will answer. That's a larger issue. Yes.
Larger issue. Well, that's very important because that larger issue has players like me. Well, what is the whole object of all this? Allow free competition. Don't allow unfair competition. Well, to allow, my lord, free competition is the norm. To prevent unfair competition is the law. So, if in the guise of unfair competition, if you want to prevent free competition, please do not entertain the law to be misused. That is the reason why we have all these various steps like 27-1, and before you can make a person a party, DG has to investigate, and an application has to be filed, all the three conditions to be fulfilled, order to be passed. All these come into play, my lord, in the context of this Competition Act. Anything else you want me to point out? No, yes or no? My lord, there's some case law which I'll point out.
Case, anybody else? Sajil sir?
Case law ಆಮೇಲೆ ತೋರಿಸಿ.
ಈಗಲೇ ಹೇಳ್ಬಿಡ್ತೀನಿ.
If your
ಹೇಳ್ಬಿಡಿ.
lordship permit,
Oh,
my lord, I will just
yes,
cite a
yes,
few provisions.
absolutely.
My lord, in fact, my lord, as your lordships always have guided us, this is a list with a gist.
Always, yes. Yes.
So, my lord, and knowing this court, my lord, I don't think I should detain your
Yes.
lordships at the valuable time in the court reading this case law. Your lordships
I'll
know
look
will
into
read
it.
it.
I'll look
I know,
into
my lord, I know your lordships. But I just showed your lordship this
And everything will bear consideration as I keep it. Don't worry about
My
it.
lord,
Yes.
we have
Yes.
no. I just showed your lordships, my lord, the heads under which the
Yes,
case law
yes.
have been put in.
Yes, sir.
My lord, please see. Yes, sir. Same.
Same convenience compilation.
The
itself.
convenience compilation,
Yes,
serial
yes.
number 11.
Yes.
CG shall investigate in terms of section 26(1) order. My lord, we are given the judgment of the Steel Authority of India, the Supreme Court judgment. And we have set out, my lord, the relevant paragraphs also. So I'm not going to read all that.
Yes.
Then, my lord, prior approval from CCI is a sine qua non to add parties to an investigation.
Yes.
My lord, your lordship may just look at one judgment, my lord, of the Madras High Court at page 88.
Hyundai Motors.
Yes, my lord, Hyundai.
Yes.
Which paragraph Hyundai? Well, kindly see paragraph number 31. MRF is better, is it? Well, may I just show to your lordship MRF first and then come to Hyundai?
Yes, sir.
Please be kind enough, my lord, to turn to page 78. Which is MRF? Which paragraph? My lord, MRF, your lordship may kindly turn to paragraph number 24 at page 82.
Yes.
In my considered view,
Yes, I'm there.
my lord, if your lordship will kindly see para 20, my lord, at page 82. The
Larger
larger
issue,
issue
yes.
that arises for consideration is as to whether the change of status of the petitioner from participant to party or opposite party in the reference is material and whether it is contrary to the provisions of law and the procedure contemplated under the Act and the concerned regulations. Then, my lord, kindly see para 21. I'll read a few paragraphs, my lord. This will be throw some light on the controversy before your
Yes.
lordship now. The records reveal that the petitioner has responded to the notices issued post passing of the first order on the clear understanding that it is only a third party participant in the proceedings. The change in status to party was never intimated to it, and neither was the petitioner put to notice prior to such change in the status. It is only when the order dated 26/8/2020 was furnished to the petitioner on 1/3/2024 that the petitioner was aware of the change enhancement in status. It is enhancement, and I don't know whether it's enhancement or it is pushing me down. Then, my lord, para 22. It is also my considered view that there has been considerable opaqueness in the manner of conduct of proceedings and the considerable delay on the part of R1 to R5 in making available the order dated 26/8/2020 to the petitioner. Having expressly stated under letter dated 24/4/2020 that the role of the petitioner is only a third party, like your lordship saw in the communication that issued to me, that I will treat you under 35(b)(2). It was
Yes.
incumbent upon authorities to have solicited the response of the petitioner prior to changing the status, which change has serious and grave implications. Instead, order dated 26/8/2020 has been passed ex parte and based solely upon note of R2 dated 17/8/2020, which was not even supplied to the petitioner. Order dated. Yeah. I'll come to that. Order dated 26/8/2020 was not even served, and a copy was supplied only on 1/3/2024. Clearly, the proceedings lack transparency. In my considered view, an entity is entitled to know the status under which its presence and participation is sought in statutory proceedings.
Yes.
The application of the statutory provisions and the connected regulations, their consequences, as well as available protections would vary depending on the status of the party. Thus,
Yes.
unless a party is aware as to the specific provision under which the involvement is sought and obtained, it would be in the dark as to the measures available to it under the law. Now, my lord, your lordship may kindly see, there is a note of R2. My lord, your lordship may kindly turn to para 12 here.
Hmm.
But you're not, I just read that few lines in para 12 at page
Yes.
80.
Yes.
Thereafter, communications are exchanged interstate of parties, culminating in the order dated 26/8/2020, impugned in WP number so and so. That
Yes.
order reads, now kindly see serial number 2.
Yes.
Now the DG has moved a note dated 17/8/2020, stating therein that it proposes to investigate the following tire manufacturers in the matter, namely CH so and so so and so. Today, the Commission considered the aforesaid note of the DG and observed that in reference, though JK Tire Industries alone was impleaded as opposite party, yet it was averred therein that other tire manufacturers had not participated in the tenders floated by the informant. In these circumstances, it was directed by the Commission that the DG shall be at liberty to investigate the role of the other tire manufacturers who have not been specifically arrayed as opposite parties as may be required for the investigation purpose. In view of the aforesaid, no other or further direction is required to be passed to the present note. So therefore, my lord, in that case, DG made a note, went to the Commission and said, I want to investigate A, B and C tire manufacturers. And in spite of it, the Honorable Court, my lord, said, no, this is not enough. Now in that context, now my lord, your lordships are referring to the order of 26/8 in para number 12, which is the order that was passed by the Commission. Now, my lord, please see para 22.
Yes.
Para 21. In that context, please see para 21.
Yes.
The records reveal that the petitioner has responded to the notices issued post passing the first order.
Yes.
On the clear understanding that it is only a third party participant in the proceedings. The change in status to party was never intimated to it, and neither was the petitioner put to notice prior to such change in status. It is only when the order dated 26/8/2020 was furnished to the petitioner on 1/3/2024 that the petitioner was aware of the change or enhancement of status. In our case, my lord, I stand on a much better footing where there is no such order. There is not even an order. Admitted position. In fact, I want to show to your lordships the counter and then I'll conclude, my lord. Now, my lord, now kindly see para 23. Instead, the order dated 26/8/2020 has been passed ex parte. We have not even had that courtesy, my lord, of an order. Forget an order after hearing. We don't even have an ex parte order. Instead, order dated 26/8/2020 has been passed ex parte and based solely upon note of R2 dated 17/8/2020, which is what your lordships will see referred to in para 12 point number 2, which was not even supplied to the petitioner. So, my lord, if an application is made or even a note is given to the Commission saying, please implead the other as parties, give me a copy of it so that I can come and tell the Commission why order should not be passed joining me as a party.
The apex court has not interpreted this.
My lord, not directly on this, my lord. I must confess, not directly. Order dated 26/8/2020 has not even been served and a copy was supplied only on 1/3/2024. Clearly, the
The
proceedings.
decision you get in para 44, 46
Yes, yes,
on that.
yes.
Why is it important?
Yes, that's it. Section 27, which I have referred to earlier, sets out the scope of the orders that may be passed by the Commission and provides for strict penalties. Thus, for a party to be subject to the rigor of Section 27, it must be afforded a sufficient opportunity to contest its inclusion, implement as contesting party, opposite party, and must be put on notice.
46.
Yes. In the light of the discussion as above, this court is of the view that the petitioner ought to have been given notice prior to implement as a party, and the satisfaction of the authority as to the justification for such implement ought to have been made out by way of a speaking order. This is, my lord. Then, my lord, your lordship may just see the another judgment, my lord, at page 88, Hyundai case.
Hyundai Motors.
Yes, my lord. If your lordship will be kind enough to turn to para 33
Yes.
at page 96.
Hmm.
Therefore,
Yes.
the Director General merely placed an additional information before the Commission in his memo dated 19/4/2011. If the Commission had not issued a direction on 26/4/2011, Director General could not have proceeded against all other car manufacturers. That will not, I think that is understanding of everybody. It is only in this case that the DG does nothing. Every other case, DG has gone before the Commission and said, sir, please give me permission to join somebody else as a party. And then, my lord, the Commission follows the required procedure under the statute before issuing a direction one way or the other, joining or not joining. Direction issued by the commission on 26/4 would tantamount to a direction under 41(1). That's a different matter. So therefore, my lord, in this case, I am all that reason why I am pointing out Hyundai, my lord, to say every case they went before the commission. In our case, my lord, there is none. Then, my lord, of course, my lord, on that the appellate authority cannot cure jurisdictional defects. I mean, that your lordship's judgment, my lord, is complete answer in
That's
my.
settled.
Yes, settled.
A Guru Shri.
My lord, exactly. We have filed that, my lord, for your lordships. My lord, rest of it, my lord, I leave it for your lordship to look at it. Now, my lord, all that I want to do is to point out your lordships what is their stand in the
objections.
statement of objections. My lord, the best thing I can do in order to not take too much of your lordship's time reading that and a reply, please see our rejoinder, my lord. What we have done in our rejoinder is given the admitted facts and with reference to paragraph numbers of the statement of objections, please be kind enough to turn to the rejoinder. May I trouble your lordships to kindly turn to paragraph number 2 of the
Just
rejoinder.
one moment.
Ah, yeah, yeah, of course.
Yes.
The respondents have adopted
Para?
para 2, man.
2.
Yes. The respondents have adopted the statement of objections filed in WP number 26627 of 2024 in the present matter. It is submitted that the facts of the case in relation to the petitioner in that case, Aperio, that is the case, my lord, where my learned friend, Mr. Sajjan Povaya appears, are distinct from that of the petitioner. Accordingly, several assertions made by the respondents in the statement of objections are irrelevant to the petitioner's case. Moreover, the respondents have not specifically denied and several averments in the writ petition, and by implication, such averments should be deemed to be admitted. Further, respondents have specifically made the several admissions. Such admissions are set out upfront for the ease of this honorable court's reference. 1. That the petitioner was admittedly not named in the prima facie order passed under 26(1). I have shown to your lordship the order itself, where they only say Amazon affiliates, Flipkart affiliates. By respondent number 1, admission in para 14 at page 8 of the statement of objection. I'm not going to read it, but it's there, so your lordship will read it. That 26(1) order named only Amazon and Flipkart as opposite parties. Admission in para 36 at page 18 of the SO. Respondent number 1 has added petitioner as an opposite party basis the investigation report of respondent number 2 by way of its order dated 28/8/2024. That is the impugned order. Admission in para 11 at page 6 and para 31 at page 16 of the statement of objections. Respondent number 1 had passed an order under 26(1) in this investigation on 13/1/2020 and no subsequent order has been passed under this provision in this case. Admission in para 5 at page 3 of the statement of objection. That is, my lord, that prima facie opinion that was formed on the basis of which, my lord, Amazon and Flipkart were to be investigated. Then, my lord, petitioner has only added as an opposite party upon conclusion of the investigation. Admission in para 14 at page 9 of the statement of objections. Respondent number 1 admits that it did not consider the petitioner to be an opposite party when it denied inspection of records by way of communication dated 27/10/2020. What I point out to your lordship, my lord, on the ground that the petitioner is not a party to the proceedings. Then, my lord, that no other order was passed. This is what your lordships have been asking us. That no other order was passed by respondent number 1 under 26(1) naming or directing investigation against the petitioner. Admission in para 31 at page 16 of the statement of objections. That the DG did not file any application under regulation 24 of the Competition Commission General Regulations seeking addition of the petitioner as an opposite party to the investigation, and accordingly no order in this nature was passed by respondent. Then, my lord, that petitioners are cherry picking facts according to convenience. On the one hand, respondents contend that 28/6(1) order was broad enough to conduct investigation against petitioner. It is only by the impugned order that respondent number 1 added the petitioner as an opposite
water,
party.
sir?
No. Therefore, rights available to opposite parties under investigation should be available from 28(8). Thank you. I'm grateful. Therefore, rights available to opposite parties under investigation should be available from 28/8/2024, that is the date of the impugned order. Respondents have admitted that the petitioner fully cooperated during the investigation. However, respondent number 2 did not inform the petitioner of its status in the investigation, and respondent number 1 misled the petitioner to believe that it is not a party to the proceeding by denying inspection of records under regulation 37(2). That's what we have pointed out, Your Lordship. Then, my Lord, rest of it, they say this court has no territory jurisdiction, my Lord, cause of action, we are located here, and anyway, my Lord, that issue today I don't think is material because all the cases have been transferred to this court. But therefore, my Lord, that may not be
that's not even
pertinent point
needed.
at all, may not be necessary.
No, we'll assume there is no jurisdiction.
But I'm saying, of course, this court has jurisdiction. Of course, this court has jurisdiction, and in any event, my Lord, today that is a non-issue.
Because all the cases are here.
It transferred by the Honorable Supreme Court. So, my Lord, this is my respectful submission, my Lord. Therefore, I would say, my Lord, that this communication of 28/8/2024 needs to be quashed. This is my.
Sir,
My lords, with due respects to my senior my lord, sir. Illa, sir. Thank you, sir.
No, thank you.
Thank you. My lords, I'm grateful. My lords, I appear, my lords, in 1.1. My lords, 1.1, my lords, is apparel retail private.
yes.
And my lords, 1.12, which is Amazon Smart Commerce Solutions Private Limited.
Yes.
This Amazon Smart Commerce Solutions Private Limited at 1.12.
Yes, sir.
Sorry, thank you, sir. Was earlier called, my lords, Cloudtail. Your lordships
Oh,
will
it's
find
Cloud-
that
all
name,
right.
my lords, in the
Yes. Complaint.
26(1) order, my lords.
Information rather.
In the
Order
first-
and, no, 2020 information also refers to Cloudtail.
Yes, my lords.
And the 28/8/24 also refers to Cloudtail.
Yes, the 28/8/24 also says Cloudtail, but that is OP3. That name, my lords, is now Amazon
Yes.
Smart Commerce.
Yes.
My lords, I would respectfully, my lords, seek leave to pitch the matter a little differently, my lords, before your lordships. Because I think Senior Mr. Raghavan, and I'm obliged, my lords, for taking your lordships through the scheme of the act. My lords, I'm predicating, and I'll just, my lords, place the predication, and then, of course, request your lordships time to take your lordships through all of it. Although there are multitude of parties before your lordships, not all of them, my lords, sail on the same boat. Somebody like Darshita, my lords, that is Senior Mr. Raghavan's client, might come up here to indicate, my lords, that I'm a rank outsider, I'm after all a seller, I'm an entity selling on a platform, why am I brought in? The entities for whom I stand to plead before your lordships, my lords, are entities which are today, and my lords, I must be very clear on that, are today affiliates of Amazon. That affiliation to Amazon under the standards applicable under the company law in this country occurred with the approval of the Competition Commission after, my lords, the DG report was tabled. My lords, for an entity, my lords, to go through the combination, etc., there is, my lords, approvals under Section 5 of the Competition Act for approval of combinations, which is, my lords, a pre-approval. In fact, an ex-ante approval, my lords, not an ex-post scenario.
Yes.
Therefore, for me to go through the affiliation process, I had to go to the commission. Commission has approved it, and therefore, my lords, today these two petitioners before your lordships are affiliates of Amazon, and there is no problem about that. But as on the date when the information was filed before the Competition Commission, as on the date when the direction to investigate under Section 26(1) was issued by the Competition Commission, as on the date when the investigation went on, my lords, for 3 long years from 2020 to 2023, as on the date the final report, my lords, of 23 came in, thereafter a direction by the Commission to the DG not to give a combined report for Flipkart and Amazon, to bifurcate it and issue separate reports on that day too. And on the date of the bifurcation of the report and the last report, my lords, being tabled.
10/6/2024.
My lords, that's correct, my lords. Being tabled before the commission, I was not an affiliate. In fact, my lords, subsequent to it comes the impugned order. Therefore, my lords, admission is, and I'm obliged to the learned attorney. The attorney said that it is not their case that I am actually affiliates. Preferred sellers are not affiliates, and that is correct. That is the flavor, my lords, of the 26(1). My lords, before I take your lordships to the scheme of the act and what I am, my lords, placing for your lordships to consider, please permit me to put that in the conspectus, my lords, and I'll stick to that conspectus. It's not my case before your lordships that there cannot be an investigation against me at all. My lords, whether I am today Aperio and my lords erstwhile Cloudtail, which is called Amazon Services, I will use the name Cloudtail for the purposes
Yes.
of this proceedings, my lords. Both Aperio and Cloudtail were preferred sellers. Am I disputing that fact that we were preferred sellers? No. Am I even, my lords, jurisdictionally indicating that there is an argument that the DG could not have investigated me at all? Answer, my lords, is no, they could have. But that investigation must be predicated on two things, my lords. An order of the commission and information to me that there is an investigation, because although, my lords, these things sound procedural in the way these rights are conferred to me in the scheme of the statute, this is not a procedural impropriety case which I run in the periphery of a substantive law. I am, my lords, raising this as a pure due process situation, saying that you could not have, the regulator cannot, in the method that it has followed, investigate me. It could investigate me provided the procedural safeguards are followed, leading to, my lords, a due process problem for me. Lords, and in just what is the due process problem for me? I am an outsider to Amazon. Yes. I am an outsider to Flipkart. Yes. There is a section 3 allegation and a section 4 allegation, and I'll take your lordship to the substantive part of it very briefly, my lords. Section 3 allegation, my lords, is on a scenario that I have, my lords, undertaken contracts where, my lords, vertical contracts in which there is a preferential treatment given to one of the sellers on the platform. Second, my lords, section 4 allegation to say that you are a dominant player and therefore you are abusing your dominance in the market. And by virtue of that abuse of dominance, there is an effect in the market, and that effect is an appreciable adverse effect on competition. These were the two informations that were filed, my lords, the common information, but two allegations that were made by Delhi Vyapar Mahasangh and others. My lords, even that information need not be there. The commission has power to
Yes.
suo motu initial. But, my lords, the commission, when a 26(1) order was passed, kept aside the section 4 allegation and said it is not made out. An investigation was directed only regarding, my lord, section 3, which is, my lord, whether there is a preferential treatment, etc., etc., and that too against Amazon and Flipkart alone. Now, my lord, when that is the case, that is Aperio and Cloudtail, notices are issued to me asking me to provide certain material to facilitate the investigation. Under law, is that right available? Yes. But that notice to me is issued, my lords, by the Director General for an investigation it is conducting against Amazon, and asks me to provide material as a third party for the investigation qua Amazon. Therefore, my lords, when a notice is issued to me, let's assume, my lords, I'm not even going to bring a court's reference, my lords, I'm not even therefore taking the example of your lordship's court. A regulator, my lords, when a regulator issues a notice to me and calls upon me for material, the regulator tells me whether the investigation is vis-a-vis X, therefore I can give material vis-a-vis X, whether it is in favor or against, or whether the investigation is vis-a-vis me. Why? Because, my lords, that investigation being vis-a-vis me provides me the right, and that's a substantial right, my lords, under the scheme of the statute and constitution, to provide exculpatory evidence to say I am not wrong. Not once has a notice been issued in 3 years to me asking me to provide material as to what my business operations are, vis-a-vis exculpating myself from the allegation to say I am a party to an adverse effect on competition emanating from section 3 of the act. Nothing at all. Second submission, my lords, in the investigation process, of course, Senior Mr. Raghavan has taken your lordships to multiple of those iterations, but broadly, my lords, there is a difference of treatment to a party who is being investigated and a difference of treatment, my lords, to a third party.
Third party.
For example, my lords, on access to information itself, third party's access is discretionary.
Yes.
Now, my lords, it can't be that a notice is issued to Sajan Puvaya saying you're a third party. I ask for access to information, they say, no, you don't need it.
Because you're a third party.
Because you're a third party, I'm investigating X. I give them material, and that material, my lord, for investigation as in X is ultimately used in an investigating report. That investigating report is tabled, and after it is tabled, the investigation is final, my lords. Now the DG is functus officio vis-a-vis the investigation.
Once the report is.
The DG cannot now reinvestigate unless the Competition Commission directs a reinvestigation. Now the DG therefore finds, my lords, problems vis-a-vis me without having issued a notice to me, without an opportunity to provide exculpatory evidence, and, my lords, indicating that in a report, and then as an ex post facto scenario, impleading me into the report saying you are now an opposite party. The last submission, my lords, is, although others may sound procedural or not, I am fortified by what the Honorable Supreme Court has, my lords, as recently as 2025, my lords, held out, saying that a regulator cannot actually have a steadfast, steel-fisted implementation of this law for one reason without giving me notice. That is because I have, my lords, the fundamental inherent right of cross-examining witnesses who actually produce material against me in an investigation.
At the time of investigation?
Yes, my lords. In fact, it
Then
was
that's-
original.
Then that becomes a substantive
It is
right.
a substantive right, my lords, and therefore I said due process is affected. My lords, in fact, there were two regimes. The previous regime, the law, my lords, the regulations were amended, my lords, of September 2024.
So, one clarity. You're talking of the proceedings before the commission or the investigation by the DG?
Investigation by the DG, my lords.
Why investigation by the DG envisages cross-examination?
Cross-examination right, my lords, if I am being investigated. In fact, I'll take an illustration. If my esteemed friend, Mr. Chinnappa, provides some, my lord, there is an allegation of abuse of dominant position by me. Therefore, I am being investigated. He says that's correct. That's not. I can provide information.
Yes.
Therefore, my lords, Mr. Chinnappa has issued a notice saying that you have been transacting with Sajan Puvaya. Please provide us material. Mr. Chinnappa provides material, my lord.
I won't rule out collusion between.
Yes.
Yes. No, therefore, my lord, that information is given. I'm assuming Mr. Chinnappa won't give information against me, but he does, hypothetically. Now, in that information, the DG relies upon that information to record a finding against me of abuse of dominance.
Correct. Where is the question of you cross-examining Chinnappa?
I have a right, my lords, under the statutory scheme. In a typical investigation before the police, I
It
do
is
not
not,
have.
you don't have.
Not have.
That is why these are qualified provisions
Absolutely, my lords.
where, that's what I'm asking.
My lords, I bow down to that question.
Yes.
In a general scenario of a police
it
investigating,
is
no
not.
cross-examination right. Therefore, whether notice is issued by the police, not issued by the police, may be a procedural issue. But here, I have a right to seek cross-examination and receive cross-examination.
Which is
And
the
my lords, I'll come to that scheme.
Yes,
Just
all right,
permit
all
me
right.
2 minutes. My lords.
Yes.
Seek and receive cross-examination to cross-examine this very witness who has produced, my lords, evidence against me. Provided that evidence is relied upon by the DG to hold me to be a person who is abusing dominance. Now, my lords, two things come up. One, I must have access to information that the DG has called for a third party evidence against
No, no,
me.
if you want to cross-examine, you should have information.
Yes,
How
my
do you
lord.
cross-examine?
Second, there must be material demonstrated saying there is XYZ evidence against you, which is being brought to bear in the investigation against me. I then make an application. That application, my lords, there were two sets of regulations. The regulations that prevailed earlier was that application would be considered by the DG, and my lords, and if it is considered necessary and expedient, that was the standard, cross-examination would be given. The law changed subsequently, of course, after the impugned order,
I mean,
with the wording saying you shall necessarily be given cross-examination. Even the test of necessity and expediency is not to be seen. If an application is made, cross-examination now becomes a statutory right. Well, in the previous regime, where it was not a specific statutory right, except when necessity and expediency or sufficiency and expediency is made out. Even in that regime, the Honorable Supreme Court, the matter traveled up. Supreme Court says even in that regime, cross-examination gives you the inherent right to ensure that evidence against you is either strengthened or crumpled. And if that is lost, then the whole process of investigation is lost. Now, my lords, in that right, and I'll come to the regulation separately, please see my position, my lords. Appareo and Cloudtail are two preferred sellers. For a minute, my lords, arguendo, let's assume Appareo and Cloudtail have not been the best of conduct, etc. That's irrelevant, my lords, for the purposes of merit. But there is, my lords, an information filed before the commission, not, my lords, information to say investigate Appareo, not information to say investigate Cloudtail, information to say Amazon and Flipkart. Flipkart has its own other entities, in my case, Amazon. Amazon has on its platform certain preferred sellers. Amazon on its platform provides deep discounts. Amazon on its platform provides preferential treatment. Therefore, Section 3 is violated. That prima facie information was available before the commission. Commission considers the test, my lords, under 26(1) of prima facie. Your lordships brought about that crucial difference between ex facie and prima facie. But even the prima facie test under 26(1), the Honorable Supreme Court has held, is not a judicial exercise of power. It is simply an administrative order to see whether that material is enough to
that is
direct.
prima facie.
Yes, my lord.
Yes.
Therefore, a 26(1) order, my lords, when prima facie an administrative order is passed, I get one right, not under the statute, but under public law applicable in this country. That is to challenge that 26(1) by virtue of a writ petition.
Fragmented challenge.
My lords, the challenges have been mounted, my lords. There are cases when 26(1), my lords, have been actually set at naught. There are cases in which they are not, but I have a right. Now, I did not exercise that right because I am obviously not an entity against whom investigation has been directed. The commission also admits that fact in its
26(1) never sprang against you.
26(1) did not spring against me, although I was named, my lords, in certain paragraphs of 26(1) as one of the preferred sellers. Apario is named, Cloudtail is named. But the direction to investigate, which was issued in the last two paragraphs, is to investigate the opposite party alone, that is Flipkart and its
And
affiliates,
Amazon.
and Amazon and its affiliates, even at the broadest breadth, which is specifically Flipkart, my lords, Flipkart entity, which is Flipkart India Private Limited, Internet Private Limited, and me as the original Amazon, not the preferred sellers, Amazon Seller Service Private Limited. Do I stand here to plead for Amazon Seller Service Private Limited? Answer is no. There is an investigation report. They will face that. Now, Amazon may have, my lords, a settlement opportunity, my lords, under 48 A. B, my lords, is commitment for me. My lords.
Commitment, sorry, settlement.
They may have, because, my lords, again, very broadly, my lords, commitment kicks in when there is a 26(1) order, but prior to a DG report being tabled.
Report being placed. Now,
Therefore,
report is already there. You have
Report is
brought in
already
after
there.
that. Yes.
Where therefore, for Amazon Services Private Limited, who was named in the 26(1) as the OP, they have lost their commitment right because, my lords, the DG report has come. The only right they may have, my lords, under the act is a settlement option, my lords, under 48A. 48A, my lords. Settlement is put first and then commitment
Yes,
is put,
that's
my
what-
lords. That settlement option which is available because there is a report against them. For me, my lords, the substantive part of cross-examination going away, number one. Number two, a substantial statutory right of offering a commitment going away are two issues, my lords, which takes this case away from the realm of simple procedural irregularity and brings it to the realm, my lords, of purely.
Examination thing is a substantive right.
Yes, my lords. And Supreme Court says so, my lords.
So that's rudimentary.
And well, in this context, my lords, in fact, in the commission's context, my lords, in a previous case of short glass, people named, witnesses came in, the person who was named also to be investigated asks for cross-examination because the condition then was discretion. Sufficiency must be seen, I will not give you. They don't give cross-examination. Ultimately, the matter travels to the Supreme Court. Supreme Court quashes the DG report and the proceedings before the commission on the ground that how can you actually deprive a person of cross-examination?
No, the statute provides, yes.
It does, my lords, and in that context, my lords, I will look at a few of the regulations, my lords.
Yes.
My lords, in fact, after a 26(1) occurred, the DG, my lords, issues notice to me. 26(1) is there, DG is investigating against Flipkart and Amazon.
Notice is issued to you.
Notice is issued to me as what? Notice is issued to me specifically calling me to be a third party. That was not so in Darshita. In Darshita makes an application saying, give me material. I want to inspect, etc. Your lordship pointedly asked, why did you make it? This whole concept in Hindi, my lords, "Aa bail mujhe maar." That was not the concept. I did not do anything. I stood by because it was not against me. A notice comes from the DG to me saying that you please give me material because I am investigating Amazon and I am calling upon you as a third party. Well, that's the minute that happens, I'll show that. The minute that happens, I am fortified on the perspective that I am not being investigated. So I did not challenge the process which is of being
26(1) you did not.
I did not, nor did I make an application for a cross-examination. Why will I? Why should I go? I'm not being investigated. Why will I cross-examine somebody and add more material this way or that way? Therefore, my lords, today then, after the DG report to by virtue of a single order, name 28 people, including the two of us, to be opposite parties in an investigation which is concluded and a finding recorded, and thereafter to bring me into the room, my lords, essentially dovetails itself to a scenario, my lords, that processual irregularity leads to a due process violation. My lords, that is the point for which I will show a few, my lords, provisions of. My lords, please permit me straight away to come to. I may be, my lords, troubling your lordships with one or two of the sections
That's all
again,
right.
but
Yes.
the emphasis, my lords, that I will bring to bear in that may be a little different.
Yes.
Well, let's, before I come to the sections, if I trouble my lord to look at the writ paper book,
And
maybe one or two documents in the writ paper book, then I will straight away, my lord, leave the
that
writ
is
paper book.
Appario Retail,
My lord, this is Appario Retail.
26627.
Please, my lords.
Yes.
Where is it? My lords, please see the 26(1) order, which your lordships will find at page number 77.
Yes.
Well, let's very quickly in 30 seconds.
Yes.
Please see, my lords, the second party there, Amazon Seller Services Private Limited and its affiliated entities.
Yes.
It is a stated case of the commission that I am not the affiliated entity. Now, who am I, my lords? Please come to para 6. 1 minute. Para 6, last line, my lords.
Hmm.
Please see the last line, my lords. Please kindly note, my lords, the allegations are on section 3(4) and 3(1).
Yes.
It's not an allegation on abuse of dominance under 4. My lords, may I just make one submission, tangential. If it was an abuse of dominance case against me, my lords,
Section 4.
I'm fully home and dry because I am not a dominant party at all. I'm one of the preferred sellers out of, I think,
That is why section 3.
1.2 million sellers, my lords, on the platform. I'm one of the sellers. Therefore, I am not dominant. Therefore, the section 4 goes. Now, 3, my lords, in terms of saying whether there's appreciable adverse effect in competition because of a vertical agreement between Amazon and a preferred seller comes into being, my lords, on investigation. I'm holding, my lords, the least common denominator pedestal, saying that let me assume that this aspect is now being investigated. Because the case from the commission will be, if I'm investigating a case of vertical agreement on appreciable adverse effect on competition, I can't have a one-way investigation on one party to the agreement and not investigate the other party. Well, that's optically correct. By all means, you have the power to investigate the other party, but please pass a 26(1), name the other party as an OP. It's not that you don't know who it is, Malach. If it is in vacuum and investigation reveals it, if the discovery is in investigation, I understand 26(1) could not have recorded it.
No, but your name is already.
My name is there. Therefore, it is not a discovery in investigation. The informant says that there is a scenario between X and Y. X is being investigated by a 26(1) by a specific order. Y is left out. Now, please see, Malach, section para 6, last line. These preferred sellers are also alleged to be affiliated or controlled by Flipkart and Amazon, either directly or indirectly. They make an allegation. Well, let's please see 7 for 1 minute. Your lordship saw all those deep discounting, etc.
Yes.
In that deep discounting, please come to 7.1.2 on Amazon.
Yes.
Kindly see, my lords, both of us are named.
Cloud
Amazon
tail.
preferred sellers in the platform so and so. Cloud tail, that is
Apparel retail,
1.12.
both.
Apparel, my lords, is 1.1. Therefore, I am within the cession, my lords, of the commission when 26(1) is passed.
Yes.
Please come to the last paragraph now, my lords, 26 and 27. My lords, 26 at page number 86.
Yes, I'm there.
My lords, in 26, the last 3 lines, my lords. Linkages between, I'm sorry, last 4 lines. The linkages between the preferred sellers and OP allegedly by the informant merits an investigation. Therefore, they say the linkage must be investigated. It needs to be investigated whether the alleged exclusion agreement, deep discounting and preferred listing by the OPs are being used by the OPs. Who is using it as a weapon? OPs. By the OPs are being used as an exclusionary tactic to foreclose competition, resulting in appreciable adverse effect in competition under 3(1) and 3(4). Now, let's please permit me to dilate one bit. There is a weapon. The weapon is called deep discounting. Who is using it as a weapon to create appreciable adverse effect in competition? The OP. Therefore, OP should be investigated. Is the conclusion of not me, my lords, the commission. Please see 27. In view of the foregoing, the commission is of the opinion that there exists a prima facie case which requires investigation by the DG to determine whether conduct of the OPs have resulted in contravention of 3(1). Kindly note that, my lords, conduct of the OPs. Now, this is staring at me, my lords, saying that conduct of the OP is to be investigated. Now, in this light, my lords, please permit me to come to, now, who is the OP, my lords? OP is Amazon.
Yes.
Now,
OP
who
is
did-
Amazon. Yes.
And, my lords, in para 1, it is defined. Although, my lords, in the cost title, they say Amazon and its affiliates. It's like, my lords, in a criminal investigation, Sajjan Puvaya and his
And
friends.
others.
And his friends.
Right.
Now, who is my friend? Mr. Dhyan Chinnappa, I thought was a friend, but he has given evidence against me in that investigation. So, therefore, it can't be that nebulous, my lords, in law. Now, therefore, para 1, my lords, it
No,
indicates.
no, particularly in this, nothing can be left to be nebulous.
It can't be.
It should be specific.
And they refer them separately, my lords. In para 1, therefore, they define it to say, when I say Amazon, I mean Amazon so and so private limited. Now, therefore, my lords, in that, if they say preferred sellers, they could have said preferred sellers so and so also, or OP345. My lords, if that had occurred, I would have no case to stand before your lordships. Then I have to participate in the investigation. I would have exercised my rights, my lords, of cross-examination, whatever it is. Or I would have possibly, my lords, if the DG report had not come out at that point of time, I would have offered commitments, whatever it be, my lords. That has not happened. Now, please see, my lords, this was 13/1/2020. My lords, I'll straight away take your lordships to one other document. Please come to page number, my lords, 88 of this paper book. Please see, my lords, on 17/8/2021. This is, my lords, about 1.5 years after the investigation began.
Notice is issued to you.
Notice, my lords, is issued to me. Now, this is the understanding of the Competition Commission Director General. Please see, my lords, the letterhead, Office of the Director General. Now, please come to, my lords, paragraph number 1, 2, Managing Director Appario. Please see also it. The learned attorney, my lord, said that Amazon has great love for the Karnataka High Court. We have no love to the Karnataka High Court. We have love to Bangalore.
No love.
Our
Ah,
operations are in Bangalore. Therefore, we have come. To turn up and say we are running only to Karnataka High Court is not correct because it's based here. We can't blame it that Bangalore is the technology hub. If Raipur had become the technology hub, my friend is from Raipur, we would have gone for Chhattisgarh High Court. And therefore, rightly, the Honorable Supreme Court said all matters pending anywhere else in the country, please go to the Karnataka High Court. Therefore, it's not because of love. Of course, I love the High Court, my lords. Amazon may not. And the learned attorney shouldn't say we had any love or affection to court. My lords,
Yes.
please come to 7/8/2021. Now, my lords, also so and so, 6th and 7th floor, Shobha so and so, St. Mark's, Bangalore, St. Mark's Road, Bangalore.
Yes.
Please see notice, my lords, and please see the sections. Notice under section 41, which I will read to your lordship separately, and under 36(2. My lords, 41 is on the whole issue of etc. etc. And 36(2 is, my lords, on summoning witnesses, etc. Now, kindly see, my lords, whereas the Competition Commission, vide 13/1/2020, passed a 26(1) order, the Act has directed investigation. The order of the CCI can be accessed at so and so. It's hyperlinked, although not in this.
Yes.
In this regard, certain information is required from you. Kindly note that as a third party. They call me out to be a third party. I'm not even giving myself the status of a third party, my lords. As a third party. Then, my lords, therefore it says, etc., brief profile. I, my lords, of course, respond to it. In fact, my lords, there is much more. After all of this happened, there are dawn raids conducted, my lords, because under the provisions of the Act, my lords, under 41, I will come that there is a search and seizure power also for the Competition Commission. They have to get approval by the magistrate. My lords, again, in criminal law, it's a sui generis scenario. Although the dawn raids might happen, my lords, let us say in Raipur or let us say in Kerala, the direction, my lords, for that and approval comes from the Chief Metropolitan Magistrate of New Delhi. That is because the statute specifically confers jurisdiction
On the
to the CMM New Delhi to, my lords, grant all of these
search and seizure.
search and seizure issues. So search and seizures were conducted, information was taken. All through, I have kept quiet. I said, please collect whatever you want vis-a-vis whom? Vis-a-vis the party who is being investigated. Well, now, after this occurred, where I am called out to be a third party, my lords, kindly now see, there are three other events that have occurred. I'll just place those events. I put it in a note, my lords, but I'll place that events. Your lordship saw, my lords, the first order was 13/1/2020.
Yes.
The first notice issued to me as a third party
17/8/21.
is 17/8/2021. This leads to, my lords, whatever they did, to a report which is a consolidated Amazon and Flipkart report in 11 December 2023. I am not privy to it. I have not put it in my writ petition because I do not even know. It's not even given to me, that 11 to 2023, because I was not a party. My lords, ultimately, it goes to the commission. Commission says, it's not the first time that the commission is looking at the DG report. The reason I'm bringing these facts, my lords, is the commission had an opportunity to look at what is in the report, not now when the impugned order is passed, but on one occasion earlier, 2 occasions earlier, but 1 occasion substantively, that is on 1/5/2024. Please see, my lords, page number, I don't think it's in the compilation, my lords. 1/5/2024 is the date. CCI specifically examines the DG's report and passes an order to the DG saying split this report separately for Amazon and separately for Flipkart. Even in that case,
Where do you get that?
my lord, it is actually in Mr. Chinnappa's petition. In my petition, it's not there.
All
but
right, we'll look at it
went
later.
to that.
Yes, it's not
But
a problem.
for the first time, therefore, when that occurs, and it goes back to the DG to split, the report, my lords, of the DG substantively, which is investigated and conclusions arrived at, goes to the commission. Even at that date, in the order of the commission directing a splitting, I am not indicated to be the opposite party. In fact, the only 2 opposite parties are Amazon and Flipkart. Well, it's thereafter a split report, DG seeks extensions.
You're saying that as on 1/5/2023,
2024, my lords.
2024, when the commission examined,
Yes, my lords.
even then you are still treated as a third party.
Yes, my lords. Because I'm not named there. I'm named as an opposite party
Only on
ultimately.
28/8/24. So till then, you're always a third party.
I was a third party. I was notified as a third party. My material was received as a third party. That material might be used against Amazon. My lords, they can use it against Amazon as much. I don't stand here to defend Amazon. Used against Amazon, a DG report tabled. The question is, could that material of mine or anybody else be used against me to record a finding against me in the DG report when I'm not an OP? It's not a procedural issue. It's about who are you targeting your investigation for. DG does not have a sui generis power to investigate everybody. That's why, my lord, that's
No,
what
DG does not have this.
Commission has. But commission will exercise that power by a 26(1) order alone. Commission, my lords, it's not even information. Commission suo moto can pass an order under 26(1). You please investigate Sajan Poya as well. There's no problem about it. But that becomes the trigger for me. That 26(1) becomes the trigger for me to exercise my right of calling for information, cross-examination, settle either a commitment or thereafter
Oh,
a settlement.
for the entire rigmarole.
Entire melons. Now, in that light, melons, this 1/5/2024 splitting occurred. DG thereafter seeks one extension for the splitting. He does not finish the splitting within that particular time because this evidence is all intertwined. And finally, my lords, the impugned order is passed on 28/8/2024. Please see, my lords, the impugned order for 1 minute. It is, my lords, at page number 70.
Yes.
My lords, please see in this 28 at the very top. Case number 40 of so and so, INRI Delhi Vyapar Mahasangh and Amazon Sellers Private Limited becomes OP1. Amazon Wholesale Sellers Private Limited becomes OP2. Cloudtail becomes OP3. Then Darshita, Mr. Raghavan's client, my lords, that becomes OP4. And Apparel Retail becomes OP5.
Yes.
My lords, now please see para 2.
Mm.
Next page, my lords, 74.
Mm.
I am reading, my lords, 1 and 2 specific fully.
Yes.
Matter was taken up in the ordinary meeting, my lords. One more thing, this ordinary meeting, my lords, although indicates a scenario that it is a meeting in the sense
Informal.
of, it is not, my lords. All proceedings of the
Statutory.
commission are conducted in ordinary meetings of the
That's
commission.
statutorily mandated.
Therefore, even, my lords, proceedings where parties argue and the entire investigation is by the DG, my lords, but inquiry is by the commission under section 27. In the inquiry process, my lords, parties are heard, like, my lords, your lordships are hearing parties. And that is also at a meeting. And therefore, my lords, that meeting, and those are ordinary meetings. My lords, please come to 2. Therefore, my lords, matter is taken up an ordinary meeting means matter is taken up by the commission,
Yes.
exercising its statutory powers, which may be, my lords, regulatory, it could be adjudicatory as well, my lords, when it comes to a scenario of this nature.
Yes.
The commission notes that the investigation report qua Amazon Sellers Service Private Limited, my lords, please see the report is qua whom? Amazon Sellers
Yes,
Service
private.
Private Limited, which is not Apparel, not Cloudtail. The DG has found the following entities to be liable under section 3(4) read with section 3(1) of the Act. Therefore, my lords, for the first time, there is a recording that the DG's report has a finding of abuse of competitive provisions of section 3(4) and 3(1) in its report qua whom? Qua me. Now, please see, my lords, DG has found the following entities liable under 3(4) and 3(1). Amazon Seller Service Private Limited, please ignore it. Amazon Wholesale, please ignore it. Cloudtail, 1.12, my lords. Darshita, my lords, has been argued, and Apparel. Therefore, my lords, by virtue of this summary order, for the first time, 2 things come out. 1, that there is a DG report in which there is a finding in the DG report vis-a-vis me. In fact, my lords, at that point when the DG finds that there is material against Apparel, what could the DG have done? It can't be that DG makes a report against Apparel, submits it to the commission. Commission then takes cognizance of that report and says, I am impleading you as an opposite party. That's not the scheme. The scheme is, my lords,
You have
under
an
section-
opportunity prior to.
my lords, there is a
implement.
section 3A, my lords, which is added to section 26.
When did that come in?
My lords, 3A came in, my lords, in 2023.
18/5/23?
Yes, my lords.
Yes. Hmm.
In fact, my lords, 3A, kindly see, my lords, for a minute on that section 26 3A.
Yes.
It covers these aspects where, my lords, there may be a scenario. My lords, please see 26. Just 2 emphasis, my lords.
Yes.
Please see 26(1) for a minute.
Yes.
I am not reading the first 5 lines, my lords, etc., etc. Please see the last 2 lines of 26. 26(1). If the commission is of the opinion that there exists a prima facie case, it shall direct the Director General to cause an investigation to be made into the matter.
Correct.
This does not prevent the commission from directing it against as many parties because it's the matter which is an issue, not a party.
3A is further investigation.
Yes, my lord. Now the commission, my lords, exercises 26(1) powers and
Yes.
says, I'm investigating against Flipkart and Amazon.
Yes.
They did it. Nobody asked them to control it only to Flipkart and Amazon. They could have said Cloudtail and Apparel also. Not done. Now, please come to, my lords, 3. The Director General, on receipt of the direction under 1, which is direction to investigate the OPs, which is Amazon and Flipkart, shall submit a report of his findings within such period as may be specified to the commission. My lords, I ask myself the question, if the direction under 26(1) is to investigate A and B, his report can be on A and B. Now, what if he, and my lords ask that question, what if he during the process of investigation finds A and B, no doubt I have, but I also have material
C and
against
D.
D and D. Now, please see 3A, my lords. If after consideration of the report of the DG, I stop there, the
Yes.
DG in his report can say, I have material against E and F as well. Now, my lords, if after the consideration of the material of the DG, referred to in 3, the commission is of the opinion that further investigation is required, it may direct the Director General to investigate. Therefore, if it found that there is case against Appario and Cloudtail, DG could have put it in its report, it will go to the commission. DG need not even have made a separate application. My lords ask the question, DG is not a party in the main act, DG is a party here. Could the DG make a application separately? Is that the sheet anchor of the argument? I, my lords, hold a separate position. That is not the sheet anchor of my argument. DG need not even make an application. DG can in its report say, I've investigated Jantinappa and Sajan Puvaya. I also have found material now against Raksha Agarwal.
When that is placed,
Yes, my lords.
the commission directs further investigation under 3A.
My lords, the minute there is a 3A further investigation direction, that becomes my 26(1) order.
Yes, correct.
Therefore, then.
Because you were not at 26(1) stage.
Correct, my lords.
Once 3A stage comes,
Correct, my lords.
it goes back to 26(1) because that is the beginning
Correct.
of investigation.
Therefore, the date of the 3A order becomes the date of my
26(1) order.
and therefore I have commitment options then available to me. Because, my lord, there is already a report table.
No, where is the 3A order here?
No 3A
No,
order at all.
That's what.
That is why, my lords, I fight it on 2 reasons. One, that instead of a 3A order, you take away the vested rights the statute gives me, that apart. But in the absence of a 3A order, you could not have investigated at all. Why? Because you do not have suo motu power of investigation. Your investigation may reveal collateral material against others, no problem about it. But then you bring it back to the commission and get the commission's imprimatur, my lords, to continue investigation vis-a-vis others. And this, my lords, 18(5)(2023) amendment came in, not because, my lords, inherently that was not the process. That was always the procedure contemplated by the regulator. It is now brought in by an amendment specifically. Why? Because people like me had argued earlier, saying, where is the DG? DG's investigation is on A and B. Why is DG even referring to C? To cover that aspect, 3A came in. I fall within the parameters of the protection of 3A, my lords. And in the absence of this, they could not have taken the matter forward. My lords, please permit me now.
So it is the submission is for an OP, 26(1) is the point. For a TP, if you want to make him OP, it should trigger only from 3A on further investigation, which will become 26(1). And the procedure after that should be all over again followed
Yes, my lords.
when you are wanting to come as OP.
With your lordship's permission, may I wordsmith that a little, my lords? I'm attempting to walk the same path with my lordship's mind. Please permit me to do that, my lords. I follow behind, my lords, with due respect. If there is a 26(1) order against a party, that's the end.
No problem, that's all right.
So the party will be.
Correct.
That evidence may reveal that there is a case made out against others as well. If that happens, there is 2 processes by which the Director General could have proceeded. First process statutorily is 3A. That you make a report, in the report indicate that E and F also should be looked at.
Commission permits further investigation.
Then therefore commission permits. Now the second option is that the DG need not even table a final report, because he might believe that he does not want a final report to be put because he has material against E and F and he wants to investigate E and F. Then, my lords, under Regulation 24, he makes an application to the commission. Please see for a minute, my lords, Regulation 24. This is the 2009 regulations.
Yes.
My lords, again, one indication. The 2009 regulations went into multiple amendments until 2024, and those were the regulations applicable to me. After the impugned order, my lords, these regulations substantively, my lords, changed and became the 2024 regulations with effect from September 2024. That is after August of 2024. Impugned order is 9/8/2020. Therefore, I rely upon, my lords, the 2009 regulations as amended from time to time. Please come to, my lords, Regulation 24.
Yes, I'm there.
Yes, please, my lord. Kindly see, my lords, the wording CCI to join parties. That is
Yes.
power of the commission to join or substitute parties in a proceedings.
Hmm.
The commission on an application made in writing by any party to the proceedings may combine any number of persons or enterprises, whether jointly or severally, separately or in the alternative. My lords, kindly see that. Even separate investigations could be directed. There's no problem. It need not be a common investigation. Separately or in the alternative, as parties in the same proceedings in an ordinary meeting. Ordinary meeting is, my lords, again, not backroom. Commission meets,
No,
there
no,
is
that's what
proceedings.
I got. Yes,
And there are daily orders of the commission.
yes, yes.
My lords, even in this case, now I'll come to for a minute, my lords, tangentially, I need not even go to that effect. Case of MRF was read to your lordships by Senior Mr. Raghavan. MRF was a case where under 24, there is a note sent by the Director General to the Commission saying, I am investigating JK Tire, I am investigating Michelin, C8, etc. I want to investigate MRF because I find that there is a cartelization, those are all tire issues, my lords. That note was considered by the Commission and Commission passed an order, my lords, and therefore it becomes a Regulation 24. Commission, DG going to the Commission, Commission passing an order. Commission passed an order and said, please bring MRF into the mix. Even in that case, the Madras High Court held, sorry, you can't. Why? Because investigation has started in my case in 2020. Investigation has gone on till 2024. If you believe that you should now bring me in as, my lords, a party being investigated, I have enormous damage caused to me already in the material that you have collected between 2020 and 2024, on which I had no opportunity to provide exculpatory material at the first available point in time. Therefore, the Commission says you can't now change the character of a bystander to becoming the person who's being investigated. I need to know, my lords, your lordship ask me a question. As counsel of this court, I have an obligation to answer it in a particular manner because my first obligation is to this honorable court. But the same question asked to a party who's not an officer of court may elicit a different answer. So I need to know, is it my personal battle that I'm fighting as a party in person or am I actually counsel? I should be told. Now that's not the case. Question asked to me was, you are a third party, please tell me. I've answered it in a particular form as a third party. That material may or may not be used against me, but seems to be used, because I don't know. Seems to be used against me to say there is.
Because you are drawn as OP.
I am drawn as OP, my lords. That drawing my OP could not be out of thin air, which means there is a finding in the DG report. Why am I not given the right to cross-examine? Therefore, my lords, 3A is one way. Rightly, they should have submitted a report and asked for further investigation. Or it could have done under 24. There could be an order. The Commission admits in its pleadings that there is neither a Section 24, Regulation 24 order to implead me, nor is it a case of a 3A where a further investigation is being directed. My lords, today, if there is a further investigation directed against me, that's it. I will go participate in the investigation. It's not my case that I should not be investigated at all, or I need a ring fencing by virtue of a judicial order against investigation. Why? Because, my lords, the minute a 26(1) order is passed, because in 3A,
Your content is following due process of law.
and my lords, I have substantial rights. I
That's
may
what-
commit.
Due process of law where your substantive rights are protected.
I may commit, I may not commit, but I have a right to cross-examine. My lords, now I will come to that cross-examination issue, my lords, straight away. Please come to, my lords, Section 41. There are one section and
Will
one regulation.
Continue at 2:30?
Lords, may I request, subject to my lords?
Ah.
comments, my lords? This is not something, my lords, which will finish in half an hour. If your lordship
I know
could give
it's-
another date, because
No
I'm
problem.
there, my friends are here, thereafter, of course,
the
at the learned attorney's
learned
convenience and
AG
my
is
lord's
here.
convenience.
Sir, you want to reply together or?
Of course, reply together, because that will be consolidated reply.
Yes, sir.
But I suppose they will conclude by 3:30. No.
Next Saturday is again a working
My
day.
lords, I'm happy to come on Saturday, but I understand the learned
But
attorney.
let them conclude today if possible.
No, not
So
possible.
that I have the benefit of consolidating my thoughts with.
Jan Chinappa
My
is
lords,
there.
there is Amazon entities, then there's
No,
Flipkart
therefore
entities.
I understand a billion people you're talking about.
1.2
Look at the
billion
interest involved.
entities.
No, we are interested in safeguarding our rights. I have a right to do business in a particular manner. in this
I'm only on the broad parameters. Next
Yes,
Saturday
and
will be little
any
difficult.
date of your choice. I am here.
Then it has to go sometime in September.
No problem, sir. September 28th is the last working day.
That Saturday. On the 13th, I'm in Madras. Could it be on 12th of September, is a Friday?
Yes.
No problem at all, sir. No problem.
I will come, my lords. It will be a damage for me, my lords, in terms of Friday, but I'm here.
But no, that will be taken
Amazon
care
will
of.
take care of.
I'll be here, my lords, for sure.
That's not a
Watching
problem.
from a
Yes.
distance.
12.
12th is.
It's 12th September.
12th.
Yes. Oh, well. Well, heard the learned senior counsel, KG Raghavan, who has completed his side of his submissions for reserved submissions for now. The learned senior counsel, Sajan Puvaya, who seeks time to make further submissions in the matter. The list the matter on, and the learned Attorney General, to hear the learned Attorney General and the other counsels list the matter on 12th September. We'll take it at, make it at 10 a.m.
No, it can start from there. Subject to your lordship's consent.
If I make it at 10 a.m., 10 to 1:30
Yes,
or
yes.
2 will, at a stretch, do something. And later on, I can get the mainstream.
In
Yes.
the alternative, my lords, if the lordships could break the regular board in the morning, my lords, and then we'll be here at.
We begin at 10 o'clock at the courts.
So beginning at 10 o'clock will be fine. Yes, so that I'll continue with the proceedings.
That would mean pressure on your lordship, be half an hour earlier.
No, not necessarily. Don't worry about it. Yes.
I may, of course, depending upon the length of.
No, in the other cases also, when the learned attorney was here, we started at 10 and finished it off.
Yes.
It's,
I'm so
we
grateful.
can-
for that. So depending on the length to which the hearing. will
How
stretch
long,
on
how
12.
long will you take, sir?
My lords, respectfully, my lords, I will need an hour and a half, my lords, because I need to take care of both those matters and the factual.
All right, who are the others who are
My
some?
lords, Mr. Chinnappa,
Yes.
then and then senior Mr. Holla is there.
I appear for item 1.8.
Huh.
Respectfully, my arguments are a little different from, I adopt the arguments so far as it pertains to the orders of 28/8/2024. But I'm also, and I have included the order of first.
No problem. No, we'll permit everybody. But one request, if all of you could file your synopsis or written arguments, whatever, not that I'll not hear you, but it would be better by the next date, even the Union of Competition. You already filed, sir?
There is.
My
no,
lords, I
think
seek
I'm-
your leave.
Let them finish. After finishing,
know,
you
I
can do it. Yes.
My lords, I
So-
seek your leave. I'm in item 1.40.
All right. Yes. On 12th, we'll.
My lords, there's no statement of objections that have been filed. In the last date of hearing, there was a direction to file statement of objections. Those have yet to be filed, my lords.
Please file by the next date, sir.
My lords, the commission has to file those.
CCI is not filed.
CC has not filed, my lords.
Readings, same thing in everything, or you want to file objections in each case?
No, it can be adopted, I think.
That's.
My lords, if they're adopted, we may be served a copy, my lord, so that we have the benefit of at least
All
seeing
right,
those
serve the
objections.
copy then, serve the copy and all. Shall I record that objections? will be
My lords,
adopted?
please, my lords, because in the last two occasions, a specific direction
The
was
learned
sought to
Attorney
file statement
General-
of
We have
objections.
filed memos
Then
of
Attorney
adoption.
General
We have already
submits
filed
that.
it.
Sir,
We have already filed memos for adoption.
oh, then fine, that's all.
My lords, those have not been served on us is my instructions, my lord.
1 minute, correct. Housekeeping. 22 and 21. The learned attorney's statement is more than enough. but what
That's
has
all,
happened,
memo
my
is not
lords, I don't think memos are served on all these multiple parties, therefore.
No, sir is saying then that's all right. Yes. The statement is made in the court, then it's done, yes.
My lords, I represent respondent 3 in some of the cases. I represent the informant. We will file an SO and an
You are for
adoption
the
memo.
informant?
Informant, yes, my lords.
All right,
So
file
I'm
your
the
objections if you want to.
My lords, I have
Yes,
a serious objection to that. The law is that the informant is not the dominus litis, it's for the commission. The informant has made his.
My lords,
information-
I am
He's a
respondent.
party
I'm
here.
a named respondent. I'm a named respondent in some of the writ petitions.
Petitioners made
So-
him a party. He's
So
not a
therefore,
party.
once a party, always a party.
Not in my matter. Certainly, my lords, and I have, this becomes a precedent of the informant coming and saying what it is. The
It's,
commission
I
is
think
here
it's
to
for the
tell-
My
court
lords,
to
I
take
had
up.
made extensive
Who is to
submissions
assist the
earlier.
File, whatever he wants file, whether I will consider that and lay down something on that as well.
Please give me the opportunity.
Yes, my
to
lord.
object to his status. Of course, he could
Yes,
file.
no problem.
And as a lawyer, my lords, I have no objection to the assisting this.
That is,
He
But,
was on competition law, Abir, my lords, is sound, therefore he could assist the court.
Absolutely.
But not as an informant.
that we'll see.
But
yes.
if on 12th, I don't know if
12th.
the stretch of time will go beyond
My lords,
post
so what
lunch.
happens? There's me, there's Mr. Chinnappa, but senior Mr. Holla is there.
Or should we seek permission of the Honorable Chief Justice and sit on a Saturday?
That's Saturday, that's the next Saturday.
12th and 13th.
13th would be,
13th
I
is the
think,
second Saturday. Illala.
13th, I'm in some,
13th.
in Chennai.
My lords, and
There
19th
is a Laila College.
My lords,
No,
your
but-
lordships consider 19th and 20th, it could be Friday, Saturday, subject of course to the.
19th and 20th. Yes, no problems.
It will be done.
20th, I cannot decide because will have to seek the permission of the Chief Justice.
No, we do.
19th,
keep it at
definitely
12
we'll
for
keep
the
it.
time being. Keep
So
it
we'll
at
do
12
it this
for
way,
the-
sir. 12th and again 19th.
Possible.
If
Or
it's
20th.
going to spill over, 20th.
20th. Let's see, 20th. Let's see, 12th.
But by then, please complete the
The Lordship
pleadings.
may not say about anything further date beyond 12. Let it be 12th as of now.
12th, yes.
Right.
All right. Sir. We'll sit on 12th again.
Yes.
Yes.
Allah's interim order.
Interim orders are there that will
Telling
continue.
Mr. Raghavan on the lighter side, you have the benefit of hearing. In the meanwhile, we'll be able to assist the court further if you give further investigation report to the court. Everything will be closed. Nothing will remain.
There will be nothing in the case. There will be nothing in the case, my lord.
Yes, we'll take it on 12th, sir.
Your Lordship.
Thank you.
Grateful.
My problem is that there is no, file my case is very different from the others that have been treated so far. There is no objection that has been filed in my case.
No, he's adopting the objections.
Because
Ultimately,
the order itself is different.
no, we are, no, true, factually different, but we are on the statutory landscape here.
No, my lords, the statutory landscape changes because the new order has changed in my case. There's an additional.
You are also drawn in as an OP?
Yes, ma'am.
Yes. All right, let's see.
My lords, that's the overlapping aspect.
No, if they are adopting, why are you worried then?
Because the other two arguments have not.
If they are adopting the objections, why are you worried? Because if you say substantially different and even then they don't.
It will
they're
give them an
adopting, why are you
opportunity.
worried? Yes.
Grateful.
Yes.
Very grateful, my lords, for a very
12th, my
patient.
lord, my presence may be excused.
12th.
I finished.
You have finished, sir. No problem.
Great.
In the rejoinder.
Yes, my lord.
Yes.
I will log in.
Sorry, I didn't do in the afternoon. Saturday afternoon.
Court officer? Court officer? Court officer? My lord, serial number 10, my lord. My lord, serial number 10, my lord. My lord, I myself had moved the memo. My lord, since I came to my village, my lord, kindly have it on 28, my lord.
Serial number?
10, my lord.
ಅಲ್ಲೇ.
I myself had moved the memo, my lord.
Ah,
28, my lord.
you yourself are
28,
seeking
16.
adjournment?
Please, my
Then
lord,
we'll fix a date
because
of what the court would say. 482 na?
because 482, my lord, consensual sex, my lord, it is covered by my lord.
But why are you seeking adjournment?
Because my lord, so I have to be physically present before my lordship
Oh,
to convince my lord.
ಆಯ್ತು.
28, my lord.
28th ಆಗಲ್ಲ, 29th, 30th. Yes.
Please, my lord.
Serial number 25, my lord. Serial number 25.71. That is actually a subvention EMI pause matter, my lord. It has been wrongly linked to this
71,
set.
Or era matters.
25 only 71.
We'll delink it.
Yes, madam. I'm passing the memo here.
Memo for withdrawal.
No, my lord.
Delink
Delink
ಇಲ್ಲ.
ಮಾಡಕ್ಕೆ.
No, memo ಏನ್ ಬೇಡ.
ಅಲ್ಲ, madam. It has to be linked to the ಬೇರೆ subvention matter.
ಅದು ಇದೆಯಾ ಅದ್ರಲ್ಲಿ memo?
ಅದರಲ್ಲಿ ಇದೆ.
Counsel for the petitioner files a memo to delink the matter and link the matter with the connected matters. In terms of the memo, tag this petition along with source.
Interim order may be extended.
Interim order subsisting will continue till the next date of hearing. 20 ಗೆ ನಿಮ್ದು ಹೇಳಿ. Yesterday it has not got delinked. Long back it has got.
25.78. Lord, this is a case wherein we have sought for a forensic audit. It has been wrongly linked with the other rare matters.
Rera matters, huh?
25.78, my lord.
25.78 delink post the matter before the bench having roster.
Much obliged.
ಆಯ್ತು ಇರಿ ಒಂದು ನಿಮಿಷ. ಎಲ್ಲಿದೆ ಮ್ಯಾಟ್ರು ತಗೊಳಕ್ಕೆ? ಡಿಲಿಂಕ್ ಆಗಿಲ್ವಾ? ಆಯ್ತು, ನೀವೇ ಹೇಳಿದ್ದು ಅವತ್ತು, ನೀವೇ ಹೇಳಿದ್ದು ಡೀಲಿಂಕ್ ಮಾಡಕ್ಕೆ. ಆಯ್ತು, ಈಗ ಕರಿಯೋಣ ತಾಳಿ. ಎಸ್ ಪ್ರವೀಣ್, ಯಾರು ಹೇಳಿದ್ದು ಡೀಲಿಂಕ್ ಅಂತ?
We had filed a memo to link only certain set of
ಮತ್ತೆ
petitions.
ಬೇಡದೆಲ್ಲ ಲಿಂಕ್ ಆಗಿದೆ ಅದಕ್ಕೆ.
Then we have ourselves filed a memo to this court saying that only these were connected matters, the rest has to be dealt.
ಇದನ್ನ ಡೀಲಿಂಕ್ ಮಾಡಕ್ ಹೇಳಿದ್ರಿ ಅಲ್ಲ ಅದನ್ನ?
ಹೌದು, dealing ಆಗಿದೆ ಅವರು. They are not connected with our property to be safe.
ಡೀಲಿಂಕ್ ಅವರೇ ಕೇಳಿರೋದು. ಯಾಕೆ ಯು ಡೋಂಟ್ ಲೈಕ್ ರಾಜು ಸರ್?
It's not that question. They are not connected to our property. Our
ಆಶ್ರಯ ಸ್ಕೀಮು ಇದಕ್ಕೆ ಏನ್ ಸಂಬಂಧ? ಆಯ್ತು, ವಿಲ್ ಸಿ, ಲೆಟ್ ದ ಮ್ಯಾಟರ್ ಬಿ ಕಾಲ್ಡ್ ಔಟ್. ನೋಡಿ ಪ್ಲೀಸ್.
Your Lordship, one small submission. Serial number 2, 25.24. That also has to be delinked, Your Lordship.
25.24.
24.
Dealing post the matter before the bench having interim order ಇದೆಯಾ?
In.
Post the matter before the bench having lost. Now call the cases. 18.61. What is 18, sir? 18.61 ಏನು? ಇದಿಲ್ವಾ? Prevention of Corruption Act ಇಲ್ವಾ? 18.61 dealing. No, it will go before the appropriate bench.
18.6.
ಹಾಗಾದ್ರೆ ಇರಿ.
Your Lordship, small submission. 25.2 for interim order is there.
ಇದೆಯಾ? ಮೇಡಮ್ ಅದು ಇಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿ.
18.6 ನೋಡ
ಬೇಡವಾ?
ತಾವು ಹೇರ್ ಮಾಡ್ಬೇಕು ಅಂತ.
ಮಾಡ್ತೀನಿ, ಅದಕ್ಕೆ ಹಾಕಿರೋದು. ಎಸ್.
Yesterday's Supreme Court rendered judgment on 7A
I know, I am aware of that, yes.
that this court order is confirmed.
ನಂದ?
Not this court order. 7A where trap failed trap.
ಯಾವ್ದದು ಕೊಡಿ?
ಹೇಮಂತ್ ಚಂದ್ರ. Order copy. ಅನ್ನೇ ಇದ್ದಲ್ಲಪ್ಪ. ಎಲ್ಲಿ ಇಟ್ಟಿದ್ದೀರಾ?
ನಾನು ಲಾಸ್ಟ್ ವೀಕ್ ಒಂದು ನೋಡಿದೆ, ನಿನ್ನೆ ಒಂದು
ನಿನ್ನೆ.
All right, we'll call it.
Yes, Lord. I have the copy. I pass over to you, Lord.
Yes.
This number 2, still number 1.
For withdrawal.
It's passed away, my lord. So it becomes infected.
Learned counsel for the
first
petitioners.
matter only, my lord.
First matter matra alla. Learned
Okay, Gowda.
counsel for the petitioner submits the petitioner is no more and therefore the petition is rendered petition is rendered unnecessary and infructuous. No, in the light of the death of the petitioner, the petition is disposed as having become
Serial number 2, my lord.
having rendered abated.
Serial number 2. Fresh address ಅಂತ ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ. R2 is a RTA activist. He had come before this honorable court by virtue of writ petition which got referred to ACB. The last known address, that's what I have. 3 ಸಲ summons ಹೋಗಿದೆ ಸ್ವಾಮಿ, it has come back. That's my last known address because I relied upon the writ petition what he had furnished. Thereafter he has not come at all.
PF ಅಂತಿರೋದು FPF ಅಲ್ಲ, ಒಂದ್ಸರಿನೂ ಕಟ್ಟಿಲ್ಲ.
I have, my lord. I have furnished 3 times. I have furnished.
ಆಯ್ತು, list the matter on ಅಲ್ಲ ಇದು ಇದೆಯಲ್ಲ, ಇದು PC Act ಇದೆ ಅಲ್ವಾ?
ಹೌದು ಸರ್.
ಇರಿ ಹಾಗಾದ್ರೆ ಒಂದು ನಿಮಿಷ ಪಾಸ್ ಓವರ್ ಅದ್ರ ಜೊತೆ ಟ್ಯಾಗ್ ಮಾಡಿ.
ಬಟ್ PC Act ಅಂತ ಹೇಳಿದ್ರೆ they are not government servants.
ಇದು ಬೇರೆನಾ?
ಹೌದು.
List the matter on 30th. Interim order
private individuals.
Interim order subsisting will continue to the next date of hearing. Yes.
Number 2.
Vacating interim order. Nobody? No representation. We have the petition. Memo for withdrawal, madam. Serial number 3, withdrawal. Yes. Next.
Still number
3 also.
Number 4.
Office objection. 2 weeks. Interim order ಇದೆ ನೋಡಿ. 2 weeks time is granted. Weeks time is granted to do the needful. In the event office objections are complied with, list on 1st September ಹೇಳ. Madam.
5, 6.
First ಹೇಳ, 8th ಹೇಳ. 1st September, yes.
Just pass over.
5, 6.
ಇರ್ಲಿ ನಿಮ್ಗೆ ಕರಿತೀನಿ ಒಂದು ನಿಮಿಷ.
5, 6, 7 withdrawal.
5, 6, 7 ಎಲ್ಲ 3 withdrawal.
Still number 8.
ಗೌರವ್ ರೆಡ್ಡಿ.
Petitioner.
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ?
Copy ಕೊಟ್ಟಿದ್ದಾರೆ. ಇದನ್ನ ಮಕ್ಕಳಿಸಿದ್ದಿ. This remanded matter. Earlier
ಮೈಕ್ ಇಟ್ಕೊಳ್ಳಿ. ಏನ್ ಹೇಳಿ? ಮೈಕ್ ತಗೊಳ್ಳಿ ಸರ್.
Earlier the honorable court has remanded the matter.
ಆಯ್ತು.
On the ground that the trial court has not considered all the aspects. Again the
ನಂದೇ ಆರ್ಡರಾ?
ಹೌದು.
ಸೇಮ್ ಆರ್ಡರ್ ಇಸ್ ಪಾಸ್ಟ್ ಅಗೇನ್.
ಹೌದು.
ಈಗ ರಿಮೈಂಡ್ ಮಾಡೋದು ಬೇಡ ಅಂದ್ರಲ್ಲ?
ಇಲ್ಲ, ಹೌದು ಸರ್. On the date may be fixed.
ಅದಕ್ಕೆ ಇವತ್ತಾಗಲ್ಲ. Will
3rd or 4th?
3rd. List on 3rd and preliminary hearing. 4th is not CPC day. Yes. 4th bandra it will come in the second list, then won't reach at all. Yes. Next.
Number 9.
My first submission is, Lord, what cannot be done directly, Lord, is sought to be done indirectly. But what is done is, Lord, should see, Lord, the memo that I filed yesterday.
Who filed this?
I have filed, yes.
Yes.
But he had filed this election nomination. But please turn to, Lord, the nomination papers, which my Lord should get it, at page 36. Lord, this is the nomination filed by the petitioner on 6/8/2025. Now, please turn to page 42. But this last portion of page 42, not any dispute or issue raised by candidate shall fall under jurisdiction appropriate court in Kolkata. Now, my lord, what my lord they have sought for before my lords is my lord with regard to nomination. But rejection of my lord his nomination has not been challenged.
Where is the order of rejection?
But order of rejection, not to get it not at page. Page not at page.
Objection now or petition now?
None objections are
Memo of documents.
Memo. 23. Sorry.
23.
Sorry, 20. I'm sorry.
20.
Page 20. 20. It is observed that since you are suspended for a term of 3 years from the primary membership of NIPM, the National Council, you are not qualified to contest National Council election. Very great. Now, what he did also, my lords, is, but his rejection of nomination, my lord, has to be challenged by a election petition. First and foremost, my lord, in fact, my lords have held so, my lord, I'll place a judgment also on record. Second, my lord, is what, my lord, his election to the Mangalore chapter, my lord, it is challenged, my lord, by the returning officer appointed by him. And my lord, there is no interim order.
Which is that petition?
That, my lord, I have produced, my lord, he has not mentioned about it here. My lord, I have produced along with my memo. My lord, so please
You have
turn to
not made a mention about the earlier petition?
It's not filed by him. It's not filed by him.
It is not
but
been.
It is at his instance. What is very evident is the election that is held, he is sought to be declared as valid. That is his election. Now, please turn to page 43 for a moment. 43 early. But this is a suit filed by one Sebastian. But he says the chairman of NIPM at page 45. He appointed him as election officer. And please see the prayer, my lord, which my lords will get it at page 53. The prayer is. My lords have said that
now
he is entitled to.
1 minute. A
Please.
suit is filed.
Please.
Seeking injunction.
True.
Injunction of what?
Injunction, the relief that is sought for with regard to, my lord, his suspension.
Suspension, correct?
True. His suspension, my lord, is challenged. Now, my lord, can I request, my lord, so please see the show cause notice which is issued to him. But why, my lord, he has been suspended? The suspension, my lord, is not merely, my lord, off the cuff. But there's something more which this.
No, I never said it is at the drop of the hat. But maybe reasons. But once the election is over, he loses his right.
True, my lord.
Now, a suspension is revoked or suspension is set aside.
True, my lord. No, that is a process of law. But if there is, but if
elections, sorry.
Not this.
2 years.
I think it's 2 years. But the contention is not if a person not who is suspended, not his suspension is not stayed. But kindly see the situation. His suspension is not stayed. Now, my lord, he approaches this honorable court and in fact does not even produce the order sheet. The order that is produced, my lord, is 1 pager of online extract. Now, please see the order that is passed by the trial court. The entire order, my lord, is not placed before my lord.
All right, tell me.
Page 27.
Why you have not placed?
My lord, the previous day the order was given. The next day we approached this honorable court. The certified copy was not received by us by then.
Online copy?
Online copy we have produced, my lord.
There's only one sentence. Now, please see, my lord, page 28.
Issue summons emergent notice sustained.
Adadmele 4/8/2025. Calgary. Plaintiff has filed the present suit against defendant for relief of declaration permanent injunction. Then he has considered it and then the order is passed. Now, my lord, in the event, my lord, the second submission is, Lord,
what is the last nomination? I think I have captured in my order. Date of nomination was getting over.
Yes, Lord. Lord, what he has done is the election process, Lord, we had issued specific instructions that, Lord, the election process should not be continued with because there is a violation. Despite which, Lord, he proceeds and holds elections in Mangalore. But please turn to, Lord, the show cause notice which is
that is on the merit of the matter.
Therefore, Lord, if, Lord, the order of suspension, Lord, which he has challenged, if ultimately he succeeds.
Now, Lord, with this, I will send it back. Let the suit be heard.
Very well, Lord. But what happens now is not by virtue of my Lord's order, but he'll be entitled to file a nomination.
Correct. That is exactly why I passed the order. Manmohan, imagine this situation. Suspension, you immediately revoke after the election. You find it, there is nothing, you revoke the suspension. What happens to the election that is already? Can a re-election be done? No.
But re-election cannot be
Right?
done. True,
Yes.
Lord.
He would lose his chance for nomination, voting,
No,
or
true,
whatever
true.
it is.
But then there's also another angle to it, Lord.
There is no concept of restitution here.
No,
Because the
absolutely.
day it's over, election is over.
No, there's also the consequence. Kindly see this, Lord. A
Consequence,
person
yeah.
who is not suspended, not if he is allowed to contest elections, not there is. In fact, Lord, I'm told that there was no unanimous election. It was.
Contest election or whatever, his results will be kept in sealed cover,
No,
subject to the
result,
result of the suit.
Lord, I'm told that there are only two candidates. Lord, if his nomination is not there, it will be unanimous.
There is now the cat is out of the bag. Yes.
No, it is
Anything
not so.
else, sir?
Exactly my point.
Lord, can I just persuade Lords with one judgment which Lords have held?
Please keep, sir. Even rejection of nomination, you have to file election petition only.
Yes, Lord.
Yes, sir. I'm fully aware of it. I'm aware of it, Manmohan. No worries.
My Lords have held that, Lord.
I'm aware of it. Followed Justice Pandit's order.
Yes.
I am aware of it, what I've written.
So, Lord, my submission is one, jurisdiction, Lord, will be in Kolkata. Two, Lord, if Lord should permit me to show, Lord, the nomination, the reasons for, Lord, suspension. Can I request, Lord, to please see that, Lord? It is not, Lord, just that there's some reason that it has been done. Lord, please turn to, Lord, that show cause notice.
Reasons may be manifold. I'm not on that. I'll pass an order. I'll consider your submission, pass an order. If you say, I will sustain this, direct the suit to be concluded. It's a 2025 suit.
It's a recent suit, yes.
Just last month it was instituted.
But in fact, I had filed a caveat before the trial court.
Trial court?
Oh, I had filed a caveat. The caveat is not put up. And thereafter, Lord, the order is passed, caveat is put up.
ಅಲ್ಲೇನು ನಿಮಗೇನು ತೊಂದರೆ ಆಗಿಲ್ವಲ್ಲ ಬರೀ ನೋಟಿಸ್ ಸಮನ್ಸ್ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ ಕೇವೇಟ್ ಇದ್ರೇನು ಇಲ್ಲ ನಿಮಗೇನು there is no order granted.
And
you had filed caveat here?
No, I had not. Then the other issue is not with regard to registration of the FIR.
FIR our mela?
Our mela, because of not his actions. What happened was not there was a function or dinner not arranged, and not the excise
cheap
department.
Cheap liquor.
Cheap liquor.
The 32, 34, 35, 54.
But therefore, Lord, my submission would be, Lord, this is not a case where, Lord, he would be entitled for an interim order, Lord, allowing him not to participate in the election process to file his nomination.
It's as simple as that, Manmohan. Tomorrow, next month, the suit is allowed.
But true, Lord.
It is held to be illegal.
But
elections are over.
But what would happen in the converse? Lord, kindly see the situation. But in the event, Lord, his suit is dismissed. Then, Lord, all the votes that are casted, Lord, everything will not go down the drain. And, Lord, the entire purpose and object of, Lord, having, Lord, the process, Lord, as per the bylaws, Lord, is to see that, Lord, every member, Lord, follows the principles set out in the bylaws. Now, Lord, what he does is, Lord,
there are only two contestants.
There are only two contestants now.
So if this man is out, the other person
Ipso facto becomes the
walkover.
Automatically becomes the
walkover.
Yes, please, my lord. See, my submission is very limited, my lords. They themselves claim that there are only two contestants.
Lord, I'll confirm
if he
that.
is elected, let it be subject to the final outcome of the suit.
Will pass on. Wait.
But I'll verify and make clarification whether or not that only two people are there. Lord, can I just request, Lord, at one instance, please see, Lord, the show cause notice that is issued to him. But the show cause notice issued to him, Lord, inter-alia points out.
Yeah. Yes, sir.
But page 71, Lord, is the show cause notice. Lord, the first allegation, Lord, he has not been following the instruction that is issued, Lord, by the defendant. But the second, Lord, is that, Lord, he is...
Who is the defendant?
Defendant, Lord, is the society.
Society. Represented by?
Lord, defendant is not represented by the president.
President. Now the petitioner is contesting for the post of president?
No, Lord.
Secretary.
Secretary.
All right. Earlier he had filed his nomination for the post of president? Yes, Gautami. Petitioner.
My lords,
Had you filed nomination for president?
yeah, I was intending to give nominations for president. Then I withdrew my nominations for president and submitted my nominations only for the
Secretary.
general secretary. And learned counsel is right, my lords. As per the list of valid contestant final list, there are only 2 members contesting for the general secretary post.
But the other submission is not the calendar of events not are already not issued.
Writ petition is not maintained. It's a direct writ petition, Allah sir, GMC.
Direct writ petition Allah. Therefore, my lord, in the scope of interference, my lord, in 227, but with reference to, my lord, matters of this nature, but would, according to me, my lord, would be limited, especially, my lord, when it relates to, my lord, the election process. But because even, my lord, otherwise, my lord, under 226, the court, my lord, would usually say you file an election petition.
227 we will not say, sir.
But so 227 will be, my lord, little, the scope of jurisdiction will be even lesser than, my lord, 226.
Yes,
But I
yes.
don't have to tell the court. But, my lord, here his rejection of nomination is not under challenge. But if his rejection of nomination not under challenge, then, my lord, the question of, my lord, permitting him to file, my lord, nomination, despite there being a suspension of membership, my lord, according to me, my lord, will not arise.
My lords, I have
In fact, my lord, his
2 submissions.
No
to
clarification. Yes.
Not clarification, my lords. I just have 2 submissions to make, my lords. I agree with my lords. The matter entirely, the subject matter of this particular suspension, the elections, is subject is
For the civil
before
court.
the trial court, and the matter may kindly be remanded back, and the said interim order may kindly be extended.
That's the submission you wanted to make?
No, my
All right.
lords. One more submission, my lords. Regarding the suspension, I am seeking for a interim stay on the suspension, my lords. My reason being,
What have I granted?
on there is no specific stay on the suspension, my lords. I'm given the liberty to apply for nominations. My nominations is considered.
Nomination cannot be, or elections cannot be done in the teeth of suspension.
So
that is,
stay
my
on
lord, the other
suspension may kindly
submission.
be
In
granted.
fact, my learned friend said, my lord, there is no consideration of whatever they have submitted. But
How
there
they
was
can?
a meeting that was held.
Merits, prima facie I have indicated. Yes. The petitioner, do I dispose it or what? Or continue the interim order? We'll take it another day, Bekar. They will pass some order now because you have, in case you want to challenge it, Bekagat. The petitioner is before this court.
Challenge madake time illa.
The petitioner is before this court on the score that the concerned civil court does not grant injunction answering an application under Order 39 Rule 1 and 2, but only issues emergent notice. The order of the concerned court reads as follows.
Lord, can I make one request, Lord? Lords may not pass any order. Anyway, my lord, elections are going to be held on 26th. Lord, I have one request if my lords are not inclined. Lord, what is being done is the order that is passed by my lords is placed on record, Lord, in the other matter which is filed, Lord, by the petitioner through someone else.
Which other matter?
Lord, that is filed, Lord, by the election officer holding that is the election process conducted by him is correct, wherein the petitioner is succeeded.
Don't do all that.
That,
We are
Lord,
not. We are not even the advocates for that matter, my lords.
may not be the advocate,
I
but
don't
that
know
is what is placed on
The
record.
advocates of the same petitioner may cause problem, but don't do that. Ask your client not to do that.
No, my client is
Already
not a
placed it on
party,
record
nor
there.
is he involved in that particular suit, my lords. They have produced those documents. I am not a party to that suit. What that plaintiff wants to do is up to
Let me
him.
not leave things high and dry.
Very
I'll
well.
pass an order so that this order should be in consonance with law. Yes, that was only to protect the interest. I had passed that order. The concerned court passes the following order. Yellow Torsarla Manmohan.
Please, Lord.
Which page is that?
But the
Page
order of the
29
trial
of
court-
their memo.
Page 20
9 of their memo they have filed yesterday.
passes the following order. What was sought for in an application in Order 39 Rule 1 and 2 was seeking an ex parte temporary injunction restraining the defendant from acting upon the order of suspension dated 24/6/2025 and permit the petitioner to participate in the election that was ensuing by filing his nomination that was ensuing on 7/8/2025. The non-grant of any temporary injunction drove the petitioner to this court immediately thereon, and this court, by in terms of its order dated 13/8/2025, permitted the petitioner to file his nomination and participate in the election by the following order. The learned counsel for the respondent NIPM, after after being served, has filed certain documents to demonstrate that what is sought for in the petition or before the court is not before this court is not stay of election, but a stay of suspension, but stalling of elections, which cannot be done in exercise of jurisdiction under Article 227 of the Constitution. The submission appears to be erroneous. As the petitioner, being the plaintiff before the concerned court, had sought for stay of injunction not to act on the order of suspension and consequently permit the petitioner to participate in the election. The issue is whether the order of suspension of the petitioner has led to his denial of participation in the election. The issue becomes clear on what the returning officer holds to reject the nomination of the petitioner. It reads as follows, page 20. The nomination is rejected only on the ground that he is suspended for a period of 3 years from the primary membership, and therefore he would not be permitted to participate in the election. It is therefore the aforesaid interim order was granted by this court, as at a later point in time, if the petitioner succeeds in the suit or the respondents themselves would revoke the suspension on manifold reasons, the elections would be over and the petitioner's right to participate in the elections would be completely taken away. The learned counsel for the respondent NIPM, learned counsel for the respondent PN Manmohan further submits that for the petitioner had initially filed his nomination both for the president and general secretary, has later on withdrawn and restricted his nomination only to the post of general secretary. And to the post of general secretary, there are only 2 candidates who have filed their nominations. If the petitioner would, if the suspension of in the light of the suspension of the petitioner, the other candidate would have a walkover, in the sense that there would be no competition to the other candidate to become a general secretary. This is exactly what is observed in the interim order granted on 13/8/2025, as the suspension appears to be passed for the reason to get someone walk away with the results of the elections. Therefore, in the light of the interim order subsisting and a direction that is issued to participate in the elections, I deem it appropriate to grant temporary injunction to the order of suspension only for the purpose of contesting the elections or voting or the as the case would be. Failing which it would not be in consonance with the bylaws of bylaw of the NIPM. In that light, dispose kalisla alle.
These observations will virtually
This observation election nantu contest madak I will not stop.
Not very well,
You
but
have
the
to.
observations that there are only 2 contestants and
That is what she said. Where is that?
that is not her pleading also.
Nomination document ಇದೆಯಾ ಇಲ್ವಾ? ನೀವೇ ಹೇಳಿದ್ರಿ 2 contestants ಅಂತ.
ಅದೇ ಹೇಳಿದ್, but there is no pleading to that effect.
Pleading
But this observation will virtually their suit will be decreed on this count.
This is exactly why the interim order is granted.
Therefore,
Merits and contentions are still kept open.
What
my lords.
nomination could?
This is a rough copy of
Parvala,
this.
you
my
get
lords.
yes.
But I have placed it along with the memo.
You
His
have
nomination
placed
is
it,
already there. Page 36.
Only 2? Only 2?
No, there are only 2.
And if the suspension had not led to the rejection of nomination, it would have been a different circumstance. The only reason of rejection of nomination is suspension.
True, Lord.
So tomorrow, anybody whom you want to do away with for contest, place him under suspension. Election as well, revoke the suspension.
Lord,
Possible?
here- no, that is a possible. I'm not saying no, but here is situation, Lord, where there is material to show.
Maybe material, may not be material.
No, Lord,
But I'm not saying there is no material. There may be material. But it is not that every suspension is bona fide. It could be mala fide. It could be to get away with this candidature for elections.
that is not the situation.
That is precisely why I have permitted him to contest and everything. Everything will be subject to the result of the suit.
My lords.
I will direct this because this is election related. Will direct the suit to be decided.
My lords, glossing over the fact that the suspension was high-handed. I will not go into the merits of the matter. However, as provided in clause 9 of the constitution of the NIPM, the petitioner had an opportunity to appeal the said suspension within the NIPM itself, and he had appealed. He had appealed on 7th of July. 7th of August was the last date to provide nominations.
No reply is given?
No, that's why we
it is
went
rejected.
instituted that.
When did you reject it?
That is rejected.
We were communicated
that is
about the
communicated
rejection on
also to him.
12/8.
It is
After
communicated
a
to
week
her.
of final
It is
date of
communicated to
giving
them. He does not challenge it. It is also communicated. He does not even appear.
kindly
All
look
right.
at page
Let's-
23 of their
Adela,
documents.
argue in this suit.
Lord, can I make one request, Lord? Lord, these observations which my lords have made, Lord,
Will not come in the way of the suit.
this observation, Lord, will have definitely a bearing, Lord, on the court below.
My lords,
I would only request, Lords, without
Wait. Why are you in a hurry? Yes.
Lord, without Lord mentioning Lord those reasons, Lords may stay, Lord, insofar as suspension is
No,
concerned.
no. ಅದನ್ನ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ತಗೊಂಡೋಗಿ ರೀಸನ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ
ನನಗೆ
ಆಮೇಲೆ
ಅದು
ಎಲ್ಲಿಂದ
ಮಾಡಕ್ಕಾಗಲ್ಲ
ಬರ್ತಾರೆ
ಯಾಕಂದ್ರೆ 26 Lord is the because those observations, Lord, will have a direct bearing, Lord, on the suit itself.
No, suit will be contested on its merit, whether I've not said anything about suspension here.
Lords have said that because there are only two candidates.
That is a fact.
That is true, but the subsequent observation, Lord, that prima facie it shows that
it is.
But
That's
there
the
is-
opinion of the court. I will say this will not come in the way of the suit being contested.
True, but
But you
observation-
tell me.
The observation is made by the court, Lord. Definitely, it will have a bearing on Lord.
No, I will say it should not have a bearing.
Practically, Lord, it
No, see,
it
if
becomes
two
difficult.
things were vivid. One, that's why I asked, where is the order of rejection? It is purely on suspension and nothing else.
True.
Correct.
True.
You suspend anybody, do away with elections.
But not if the
This
court
house,
permits.
sir.
Allah,
How-
if the show cause notice is seen, but it will be very evident. It is not that, Lord, there is something not beyond this. Maybe there are only two people.
Maybe there may be many things beyond it.
That
That's
is so,
in the
Lord.
suit.
Can
You
the
argue the suit.
suspension, Lord, be the stay of suspension or the permission to file nomination?
What did I say? Stay of suspension only for the purpose of
Yes,
election.
Lord. If a person who has violated, Lord, all the rules of, Lord, the bylaws of the
That's
society.
yet to be decided, sir.
True, Lord. But
Yet to be
as
decided.
a society, Lord, we have
No,
taken a decision.
as a society, all right, yet to be decided. You throw 100 charges against someone, throw him out of the elections in the fray, and then say, no, nothing is there, we are taking him back. No, sir. I will not permit that at all.
If my
And
lords-
I have said, no, it is suspension is stayed only for the purpose of election.
Lords have said so.
Not that he will come and sit on his chair there.
Lord, my only concern is because, Lord, this will be giving premium to someone who has violated the bylaws of the society.
Oh, no, then I will be putting premium on your action also. Violated the bylaws is a thing to be decided. It's not yet decided. How do you restitute a person who's wanting to contest election after the election is over? General concept of restitution is not applicable here. That is why status
That
quo.
event, Lord, a person, Lord, who is suspended or his nomination is rejected, Lord, as a
Yes,
usual
sir.
practice, he'll have to challenge the election by filing election petition.
No problem. Yes.
But, Lord, may not be in a case where, Lord, there is
That is why
suspension.
challenges to the order of suspension.
True, Lord. It is, therefore, Lord, there is no challenge as on date to the rejection of the nomination.
That's all right. That may be done in
There is no
Calcutta or
challenge to
whatever it
rejection
is.
of nomination, Lord, to permit him to file nomination
No,
in this
no,
case. Right.
Yes, you toss it. So, ಏನು ಹೇಳಿದೆ ಕೊನೆಗೆ ಇದಕ್ಕೆ? Suspension only for the purpose of the conduct of the participation in the ensuing elections to which the petitioner has already filed his nomination.
But can I make one more request? Lord?
Ah.
Let this not be placed before in the other case, and let this not be circulated. Now, what he'll do is, in fact, the video Lord, of the court
1
proceedings.
minute. The observation made in the course of the order is for the purpose of consideration of the case of the petitioner in the subject order. It is made clear that this order shall not be used for collateral purposes or to be placed before any other fora in any other case.
In fact, Lord, the first hearing date, everything is recorded in phone and is circulated everywhere. Yes, yes.
My lords, that was
Owner-
the, you YouTube which was uploaded, that was.
Circulate.
No, I am live, sir.
Your blood-
Phone ಬೇಕಾಗಿಲ್ಲ ಯಾರಿಗೂ.
Although,
Nobody need record it over a phone. Proceedings are live.
true.
Yes.
Lords have said that this is only for the purpose. It will not influence.
ಹೇಳಿದ್ದೀನಲ್ಲ sir.
Great.
ಇದು dispose ಮಾಡಲ್ಲ ಇಟ್ಕೊಳ್ಳ.
Might. I don't think there's anything else that.
We'll dispose it.
Please, my
The,
lords.
at this juncture, counsel appearing for the parties would submit that the matter, the order be sustained and order be sustained and direction be issued to the concerned court to dispose of the suit itself.
Suit plot is 2025.
25 suit itself. In the light of the circumstance that needs an urgent hearing before the concerned court as it is with regard to the suspension leading to consequent elections and the entire results being made subject to the result of the suit pending, I deem it appropriate to direct the concerned court to dispose the suit with an outer limit of 6 months in the peculiar facts of this case.
But only the suspension will be subject out of the
Suspension
count of suit.
ashte.
Not the elections. Lord.
Election alla. Suspension is the foundation.
True.
That's exactly why I have quoted that order.
Very well. Great.
The aforesaid observations, petition stands disposed.
Grateful, my lords.
Seal number 10, adjourned. Seal number 11, hearing on IA.
Alan Barkumbudi, the observations made shall not influence the proceedings in the suit. Otherwise.
7,
That's for the petitioners, my lord, seeking adjournment, my lord, senior is out of
Saturday, you
station.
can't seek adjournment, sir.
Not so, he's out of station, adjournment was not there.
In 482, what's the problem?
Lord, I am filing the objections, my lord, statement of objection. On behalf of the respondent number 2.
Husband,
ಮಾವ ಮತ್ತೆ ಅತ್ತೆ
ಮತ್ತೆ ಈಗ ಮುಗಿಸ್ಬಿಡೋಣ.
ಅಲ್ಲಿ I also produced certain documents with my
ಏನಿದೆ ಅವ್ರ
statement of
ಮೇಲೆ?
objections. ಇಲ್ಲ ಏನಂದ್ರೆ what they have done is to use this wife out of the matrimonial home. They have used extra constitutional machinery.
Extra constitutional machinery, ಯಾವ್ದು sir ಅದು?
Lord, may kindly see the photos, my lord. ಅಂಬೇಡ್ಕರ್ ಫೋಟೋ ಇಟ್ಬಿಟ್ಟು ಅಲ್ಲೆಲ್ಲ ಇನ್ನೊಂದು ಯಾವ್ದೋ ಇದು ಛಲವಾದಿ ಸಂಘ they have come to the property. ಹೌದು, ಗೊತ್ತಿಲ್ಲದಂಗೆ ಸೇಲ್ ಮಾಡಿ ಅವರನ್ನು ತಂದ್ಬಿಟ್ಟು they have been, she has been
that is the problem for these proceedings.
ಅಲ್ಲ, that is not the problem. Before that,
ಸರ್ 498 ಅಲ್ಲಿ ಕ್ರೂಯಲ್ಟಿ ಏನ್ ಬರುತ್ತೆ ಅದ್ ಹೇಳಿ. ಅದ್ ಬಿಟ್ಟು ನೀವು ಆ ಫೋಟೋ ಇಟ್ರು ಈ ಫೋಟೋ ಇಟ್ರು ಅಂದ್ರೆ
ಅಲ್ಲ ಅವ್ರು ಮಾಡಿರೋದು ಅದು. ವಾಟ್ ದಿ ಮಾವನ ಹೆಸರಲ್ಲಿ ಇದ್ದಿದ್ದು ಮನೆ. The name, the house was standing in the name of father-in-law.
ಆಯ್ತು ಬಿಡಿ. What sir? Stoic silence?
Not sir, senior is not instructed, he's out of station.
Yes.
Kindly adjourn for next week. Any time.
List the matter after 2 weeks.
That's IO maybe.
IO, investigating officer.
Interim order.
Interim order, yes. Interim order subsisting will continue to the next date of hearing. In madam. Pavanaputra Resort.
Lords, I appear for the petitioners in this matter. Lord, I may just take my lords through the list of dates and what has happened basically in this matter.
Respondent should be there for you to take
I
through the
agree,
list
my
of dates. No representation by of the respondent. List the matter on, list the matter after 2 weeks. Interim order subsisting will continue.
Great.
No representation by of the respondent who has filed application seeking vacation of the interim order. Yes, next.
Order hearing, seal number 30.
Yes, sir.
This batch of appeals.
The batch of all criminal appeals. Now, ready ಇದೀರಾ ಎಲ್ಲರೂ?
ಏನಾಗಿದೆ, I have filed one application that is not listed. There are 6 special cases.
ಏನ್ application?
Clubbing of charges. Lord, what
So,
transpired?
we'll pass a final order on
ಅಲ್ಲ
that.
ಅದನ್ನೇ ಅದು ಡಿಸೈಡ್ ಆದ್ರೆ whether it should be heard on merits or not ಅಂತ ಡಿಸೈಡ್ ಆಗುತ್ತೆ.
Yes. Today we are not ready. Rahul, next time ಕೇಳಂಗಿಲ್ಲ ಇದು. I'll post this on 30th.
In the meantime, I'll file objections to the clubbing of charges.
ಅದು application ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೀನಿ. ಅದು ಯಾಕೆಂತಂದ್ರೆ
ನೀವು ಒಬ್ಬರೇ ಹಾಕಿರೋದಾ?
ನಾನು ಒಬ್ಬನೇ ಬರ್ತೀನಿ ಬಿಕಾಸ್ ಔಟ್ ಆಫ್ ಅದರಲ್ಲಿ ಓನ್ಲಿ ಇಬ್ಬರು ಮಾತ್ರ 6 ಕೇಸಲ್ಲಿ ಇದ್ದಾರೆ. ಓನ್ಲಿ ಪಬ್ಲಿಕ್ ಸರ್ವೆಂಟ್ ಇಸ್
ಯಾರು ಬಂದೇ ಇಲ್ಲ?
ಅಲ್ಲ ಅದರಲ್ಲಿ
Nobody is prepared to argue, is it? We'll vacate the interim order.
even I have to commence because in all cases I am the accused number 1. I am appearing for.
ಇದ್ರಲ್ಲೆಲ್ಲ ಇವ್ರು ಇದ್ರಲ್ಲ ಹಸ್ಮತ್ ಪಾಷಾ ಅವರು
ಅಲ್ಲ ಇದ್ದಾರೆ ಅವ್ರ ಅದರ್ ಅಕ್ಯೂಸ್ ಗಳಿಗೆ because A1.
Nobody is ready today.
Serial number 15.1 and 3, my lord. My lord, in this matter, interim order is granted, my lord.
ಅಯ್ಯೋ ಅದು ಗೊತ್ತು ಸರ್, ರೆಡಿ ಇದೀರಾ ಇಲ್ವಾ ಅಂದ್ರೆ interim order is granted.
No, my
Yeah,
lord.
it will.
30th I will commence. ಆಮೇಲೆ ಬಂದವರು ಜಾಯ್ನ್
Can't continue like this. This should be over. Criminal appeal ಅಂತ 10 years ಇರ್ಬೇಕು ಅಂತ ಏನ್ ಕಾನೂನಿಲ್ಲ.
ಇಲ್ಲ.
Yes.
Your lordship has heard it substantially at the time
exactly
of.
I am asking. Criminal appeal ಅಂದ ತಕ್ಷಣ
ಇಲ್ಲ.
the big picture is shown and ಆಗಲ್ಲ ಇಲ್ವೇ ಇಲ್ಲ. Buck stops here.
Any date may be fixed.
30th ಹಾಕಿರ್ತೀನಿ. In case division bench ಇದ್ರೆ ಮಧ್ಯಾಹ್ನದ ಮೇಲೆ.
ಆಗ್ಬೋದು.
List on 30th.
ಇನ್ನೊಂದು ಅಪೀಲ್ ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ 2172 for 72/2024.
ಕೊಡಿ. Yes, next. Paper book ಆಗಿದೆಯಾ?
Paper book ready ಇದೆ. We have received it. Much.
Interim order is there.
ಎಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ.
Suspend ಆಗಿದೆ.
Sentence suspend ಆಗಿದೆ.
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ನಾವು extension for time to deposit the fine amount.
ಅದು ಆಗಿದೆಯಪ್ಪ. ಫಸ್ಟ್ ರೆಡಿ ಆಗಿ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಬರೀ ಇಂಟ್ರಿ ಮಾಡರ್ಲೆ 10 years ನಡೆಸ್ಕೊಂಗಿಲ್ಲ. ಎಸ್
ಆಗ್ಬೋದು.
17.
ಜಗದೀಶ್ ಸರ್ ನೀವಿದ್ದೀರಾ ಇದರಲ್ಲಿ? CBI ಮಾತ್ರ.
ಇಲ್ಲ ಇವರು ಇಲ್ಲ ಜಗದೀಶ್.
17.
Order. 7A of the.
ಇದೆಲ್ಲ 7A ನಾ?
Please, my lord, no trap, no.
ಎಲ್ಲಿ BB ಪಾಟೀಲ್?
From 18 onwards it is connected, my lord. From 18 onwards it is connected.
ಆಯ್ತು, ಈಗ ಇದರಲ್ಲಿ ಏನು?
No, there was no trap, my lord, no demand, no acceptance, nothing, my lord.
Yes, for the respondent Lokayukta, my lord. We need some short accommodation, my lord.
ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿಲ್ವಾ?
ಹಾಕಿದ್ದಾರೆ.
ಮತ್ತೆ
R2 ನು ಹಾಕಿದ್ದಾರೆ.
ಎಲ್ಲ ಆರ್ಗ್ಯೂ ಆಗಿರೋ ಕೇಸ್ಗಳಿದೆ, ಮತ್ತೆ ಆರ್ಗ್ಯೂ ಮಾಡಕ್ಕಲ್ಲ.
Some personal inconvenience, senior is not available, my lord. Kindly have it on next
No. Yes.
My lord.
Madam, fourth ನಮ್ದು ಎಷ್ಟಿದೆ?
ಅದೆಲ್ಲ ಇದು ಪ್ರಿಂಟ್ ಔಟ್ ಪ್ರಿಂಟ್ ಇತ್ತಲ್ಲ.
Sir, 1817.
ಅದು ಮೇಡಮ್ ಒಂದು ನಿಮಿಷ.
1817, sir. Serial number 18 is 17, sir.
17. 17. No. 17. ಹೇಳಿ ಸರಿಲ್ವಾ? ಹೇಳಿ ಮತ್ತೆ. Is ready, my lord.
Who's ready?
R1. BB part is serial number 18, my lord.
17. Yes, sir.
Relevant portion I will read, my lord.
Relevant
portion I will read. Complaint, my lord. Relevant portion I will read. There is a demand is there, my lord.
ಯಾರು ಇವರೇ ಡಿಮಾಂಡ್ ಮಾಡಿದಾರ?
Yes, ma'am.
Acceptance?
Acceptance ಇಲ್ಲ ಅದರಲ್ಲಿ. ಡಿಮಾಂಡ್ ಇದೆ, ಬಟ್ ಇದರಲ್ಲಿ on the spot day ಇದರಲ್ಲಿ
No trap.
No trap.
Lordship judgment Shivraj.
ಎಲ್ಲಿ ಕೊಡಿ.
Even yesterday also unsuccessful trap was held by
Supreme Court. ಕೊಡಿ, ಅದು ಎಲ್ಲ ಭಾಗವತ್ ಸರ್ ಕೊಡ್ತೀನಿ ಅಂದ್ರು, ಕೊಡ್ಲೇ ಇಲ್ಲ.
I'll pass it on the case status, my lord.
To 5 order of this court, 6 and 7 not yesterday ordered.
All right, yes. All right. ಎಲ್ಲ 8th ಹಾಕ್ತೀನಿ, all this. 8th ಗೆ be ready with all the cases. The entire list will come on 8th, Monday. ನಾನು ಮಾಡ್ಬೇಕು, ಓದ್ಬೇಕು, ನಾನು ಬರಿಬೇಕಾಗಿರತ್ತೆ. ಒಂದಲ್ಲ 100 ಕೇಸ್ ಇದೆ. List on 8th, entire piece 7A, ಎಲ್ಲ 8th. Interim orders, ಅದು serial number 17, 18, 19. ಎಲ್ಲದರಲ್ಲೂ interim orders subsisting will continue to the next date of hearing. List on 8th at 2:30 PM. ಏನು? Yes.
There is one grievance for me, my lords. That's 18.107. Your lordship connected it with the main matter. Lords, and your lordship granted a common order. Lords, but the registry is saying that order cannot be given. Lords, therefore, I'm derived of interim order.
What cannot be given?
Lords, in fact, there was a hue and cry before the registry which has happened. Your lordship may kindly
What
see
is that, madam?
18.107. I'm the petitioner in that case, my lords.
Correct.
Lords, on 16/12/2024, your lordship asked the registry to tag it along with 5726, which is the principal matter.
All right.
On 18th of the same month, your lordship passed a common order where crime was there restraining from filing charge sheet, where charge sheet was filed restraining them. My lords, the registry is saying just because it is only tagged and not put up, therefore I cannot issue any interim order.
Who is that? Who is that smart man?
No, both pending, writ petition pending and criminal pending.
By today evening you'll get it. Interim order ಇದೆಯಾ ಅದರಲ್ಲಿ?
My lords, your lordship said on
ಇದೆಯಾ ಇಲ್ವಾ? ನೀವು don't beat around the bush. ಇದೆಯಾ ಇಲ್ವಾ ಕೇಳ್ತೀನಿ.
2/5/2025 your lordship granted.
ಅಷ್ಟೇ ಸಾಕು.
Main matter ಅಲ್ಲಿ ಇದೆ, ಅದು ಅವರು ಅದಕ್ಕೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತಾರೆ.
ಅಷ್ಟೇ. You will get it. Please.
Your lordship, your humble submission. In 18.53, your lordship.
Not connected.
Connected matter.
ಮತ್ತೆ
interim order
ಇದ್ರೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
ಇದೆ ಸ್ವಾಮಿ.
ಇದ್ರೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
ಇದೆ. ಅದರಲ್ಲಿ ಓವರ್ಸೀಟ್ ಆಗಿದೆ.
ಓವರ್ಸೈಟ್ ಆಗಿದೆ.
It records that the charge sheet
ಓವರ್ಸೈಟ್ ಆಗಿ ಇಂಟರ್ ಮಾಡಿ ಕೊಟ್ಬಿಟ್ಟಿದೀವಿ. ಹಾಗಾದ್ರೆ ತೆಗಿತೀನಿ. The learned counsel of the petitioner submits due to oversight interim order is granted. So the interim order stands vacated. ಮತ್ತೆ
ಟೈಪಿಕಲ್ ಎರರ್.
ಓವರ್ಸೈಟ್ ಆಗಿ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀರಾ ಅಂದ್ರಲ್ಲ.
ಎರರ್ ಆಗಿದೆ ಟೈಪಿಕಲ್. It records that the charge sheet shall not be filed, my lord. In fact, our IS outside for further proceedings in
ಇದೆಲ್ಲ ಕೊಡಲ್ಲ. ಬೇರೆದ್ರಲ್ಲಿ ಏನಿದೆ? interim order subsisting in all these cases shall continue till the next date of hearing. ಅಷ್ಟೇ.
To be dealing.
18.61.
61.
ಯಾಕೆ?
The matter is not pertaining to Corruption Act, my lord. The offences are forgery and personation.
18.61 na?
61.
Dealing, correct. Dealing 18.61 post the matter before the bench. ಮುಂಚೆ ನಾನೇ ಮಾಡಿದ್ದೇನೆ.
Connected matter ನೀವು.
ಸರಿ, ರೀಲಿಂಕ್ ಅಂತ ಮಾಡಿ ಅಷ್ಟೇ, ಇಲ್ಲೇ ಬರುತ್ತೆ.
Serial number 18
ಮಾಡಿದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬಿಡಿ.
Serial number 18.8, my lords. I have filed the memo for withdrawal.
Thank you, sir.
I have filed it, my lord, in the counter.
Yes. In terms of the memo, 18.8.
Yes, my lord.
Yes. Next.
19, still number 19.
Along with 18, there are other matters which are not tagged. So pass on the number so that it can. It's ordered to be connected. It's not listed.
ಆ ಬೆಂಚ್ ಇಂದ ಇಲ್ಲಿ ಬರಕ್ಕಾಗಲ್ಲ.
ಇಲ್ಲ, ನಮ್ಮ ಮುಂದೆನೇ ಇತ್ತು. Your lordships have ordered it to be connected, but it's not connected. Can I pass on the number?
ಅಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟಿದ್ರು ಬರಲ್ಲ.
ಇಲ್ಲ, ತಮ್ಮ ಮುಂದೆನೇ ಬಂದು ತಮ್ಮ ಮುಂದೆನೇ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಆಗಿ ತಾವೇ ಕನೆಕ್ಟ್ ಮಾಡಿರೋ ಆರ್ಡರ್ ಇದೆ.
ಹಾಗಾದ್ರೆ ಕೊಡಿ, ಅದು ಕೊಡಿ. ಮೇಡಮ್ ಕೊಡಿ. Yes.
19.
And for the.
ಇಲ್ಲಿ ಪ್ರಸನ್ನ ಕುಮಾರ್ ಆಗೋಗಿದೆ ಕೆಲಸ.
Anything is there, we'll give it on reply.
ಇದು ಫೋರ್ಜರಿ ಮೇಲೆ ಫೋರ್ಜರಿ. Yes.
Pass on.
ಕೊಡಿ.
Sorry, my lord. I've got matter. I've got clarified. Mine is not linked to this. Sorry. Apologies.
No problem. No link ತಾನೆ. So correctly dealing. Vishwan sir. Yes.
Let's.
Let's, this is, so far as criminal petitions are concerned, that is the.
Criminal petitions are over.
That's-
Don't get into that at all.
Now, so far
I am holding 5-5.
15.2, that is the 5559/2022 has to be taken along with the 19.6.
19.9,
19.2
2 along with 6,
along with 6 because
the government advocate ಅಂತಿದೆ.
the government has also challenged that.
ಎಲ್ಲಿ ನೋಡಿಲ್ವಾ ರಾಜ್ಕುಮಾರ್? ಅವ್ರಿಗೆ ಈಗ ಅರಿವಾಗಿದೆ, ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ. ಎಸ್.
Now, in this writ petitions, my lord, RRT 8/2021-22 order has been challenged. Now, I have filed a synopsis.
ಇಲ್ಲಿದೆ, yes.
Now, WP, that is Mariappa, has filed 5559/2022. In this, prayer may kindly be seen. That is, I called out.
Yes.
Call for records in case number so and so. That is RRT 8/2020-21 to quash the order dated 4/2/2022. By this order is at annexure Q. This order, what the annexure Q says is that the grant in favor of Muniswamy, that is the genuine. So there is the documents are all genuine, and so far as and directed the Tahsildar to enter the name of this Muniswamy's legal heir's name in the revenue records and therefore survey number 105. And then prayer in WP, that is 20597/2022, that is government, again government has challenged, that is annexure P. Now, the case of the petitioner, that is that I called out, my lord, 19/3/1978, that is this Mariappa claims to be the grantee. That is on 21/7/6/1970, Mariappa contended that Sagoli cheat was issued, and thereafterwards on 2010 Tahsildar passed orders on RTC number so and so. Then 6/2/2014 Assistant Commissioner Bangalore Subdivision Suomoto proceedings was initiated. As against that, 6/3/2020 the Mariappa filed a WP before this honorable court, that is 20627/2016 so and so. Before this one, quashing the order dated so and so. Then the said writ petition was allowed on 6/3/2020 by setting aside the order of the Assistant Commissioner. Then Mariappa filed a contempt. In this, Mariappa, that contempt, may I pass on this, please, notes? Just a moment. That order copy, what I have placed here. 6/3/2020, that is first document, please, madam. Mariappa, Chengappa and Gangappa have challenged.
Mariappa, Chengappa, Gangappa.
No, I am for the this Mariappa, the legal heirs of Muniswamy. I am not party to this, sir. So in this, they have challenged the order passed by the Assistant Commissioner. Para 10 may kindly be seen. Para 10. What
orders without jurisdiction set aside ಮಾಡಿದ್ರು.
ಅದನ್ನು set aside ಮಾಡಿದ್ದಾರೆ. 136(3) ಕೆಳಗಡೆ DC has got power ಅಂತ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು.
So against that, contempt petition was filed. Next document. At page number 23, please. That is the operative portion may kindly be seen. We have heard the learned counsel for the parties at length. From perusal of the paragraph 10 of the order passed by the learned single judge.
No contempt dropped.
Contempt, but observation is very important.
136(3), though it won't amount to committing contempt.
That's what already by that time 136(3) proceedings was initiated. That's the reason, because this judgment is very important, my lord, because this is the judgment they are placing reliance for the entire claim. This is Lordship Justice Veerappa's judgment. Because why they are, because
that is rendered under 136(3).
136(3) ನಲ್ಲಿ RRT 8A ನಲ್ಲಿ ಗ್ರಾಂಟ್ ಆಗಿರೋದು ಮರಿಯಪ್ಪಂದು ಬೋಗಸ್ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡ್ತಾರೆ. ಸೊ ಅದನ್ನ
ಜೂರಿಸ್ಡಿಕ್ಷನ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅದಾದ್ಮೇಲೆ RRT 8A ನಲ್ಲಿ ಕೋರ್ಟ್ ಹೋಲ್ಡ್ಸ್, ದ ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್ ಹೋಲ್ಡ್ಸ್ ದಟ್ ದಿ ಗ್ರಾಂಟ್ ಇನ್ ಫೇವರ್ ಆಫ್ ಮರಿಯಪ್ಪ ಇಸ್ ಬೋಗಸ್. ಮರಿಯಪ್ಪ, ಚೆಂಗಪ್ಪ ಅಂಡ್ ಗಂಗಪ್ಪ. That order has not been challenged till date.
Where is that order?
That I have placed before this honorable court. Page. That is at page number 34, please, Lord.
6 July 22.
July 2022.
All right.
And operative portion, my lord.
It is before your lordship. We have already challenged that order. And it is, I don't know.
Challenge
We are
ಮಾಡಿದೆ.
not, I'm not party.
That is before it connected.
ಎಲ್ಲಿ ಮಾಡಿಲ್ಲ
ಇಲ್ಲ ಇದೆ.
ಇಲ್ಲ ಮಾಡಿಲ್ಲ.
ಕನೆಕ್ಟ್ ಆಗಿದೆ ಅಂತ ಇದ್ರೆ
ಅಲ್ಲ ಅವ್ರು ಯಾವ್ದು ಅಂತ ಹೇಳಿದ್ರೆ ನಾನು ಅಲ್ಲಿ tell right now. You can give the number.
ಮೇಡಮ್ ಇದು ತಗೊಳ್ಳಿ 19.4 ಕೊಡಿ.
Now this 44 may kindly be page number 44. By invoking the provisions of section 136(3) of the Karnataka Land Revenue Act, I hereby declare that the claim made by the respondent over the land bearing survey 105 of Dodda Togur village, Begur Hope, Bangalore South Taluk is not sustainable and no genuinity of grant relied upon by them. From the Tahsildar, Bangalore South Taluk is hereby directed to appropriate steps to initiate proceedings under section 192A. So on the basis of this, criminal proceedings has been initiated. That is before the honorable court.
ಅದು ಕೇಳಿದಿನಲ್ಲ argument.
Thus, this is arising out of that. Now, this order has not been challenged. If they give the correct number now, right now I'll tell because
19.2.
19.2. That is, your lordship may kindly take
19.2 ತಾನೇ ಹೇಳ್ತಿರೋದು ನೀವೀಗ.
19.2 ನಲ್ಲಿ ನಮಗಾಗಿರೋದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು ಅವರು. They are not challenged RRT 8A proceedings.
ಈ ಆರ್ಡರ್ ಡೇಟೆಡ್ ಯಾವ್ದು 26th July 2022 is not challenged.
Not challenged.
All right. Just Kaushik
Please
clarify that.
same order, my lords. He splits the matter. In the same matter, we file the objection. He splits the matter. He proceeds with our matter and passes a separate order. That is all it is. Before that, we had challenged it. In the writ petition, there is an order that subject to the result of the writ petition, this order shall be. Therefore, we have not separately challenged that. So this
All
is
right.
8 and that is 8A. That's all the difference.
Oh, 8 and 8. All right.
No, there are
8A ಅಷ್ಟೇ.
Two separate orders has been passed because what they have done is
ಒಂದರಲ್ಲಿ
No,
ಅವರಿಗೆ
no, I'll
uphold
make my
ಮಾಡ್ತಾರೆ,
submission.
ಒಂದರಲ್ಲಿ
ಏನು
ನಿಮ್ದು-
ರಿಜೆಕ್ಟ್ ಮಾಡ್ತಾರೆ.
ಅಲ್ಲ ಒಂದಲ್ಲ ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ RRT 8A ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡ್ತಾರೆ. ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡೋದನ್ನ ದೇ ಚಾಲೆಂಜ್ ಬಿಫೋರ್ ದಿ honorable court that notice to quash the proceedings initiated under 136(3). So that writ petition, in that writ petition, whatever the notice issued is subject to the result of writ petition. Now the order has been passed. Now that writ petition has become infructuous. They have not challenged that order. That RRT 8A proceedings, they have not challenged.
ಆಯ್ತು.
So my respectful submission, without challenge to the order, they cannot come before this honorable court. That is my respectful submission because their grant had been held that it is the fraud played before the authorities and it is not genuine. So that has, with regard to that aspect, they have not stated anything before this honorable court. So far as RRT 8 is concerned, they have challenged. That is what the prayer may kindly be seen in the my synopsis. That is only they have sought for with a specific this thing that to quash the RRT 8 proceedings. The order passed in favor of this. So then thereafterwards, they file an application after disposal of the contempt. They file an application to seek positive direction in the disposal of writ petition. That is WP number 20627/2016.
ಅದೇನಾಯ್ತು?
Adu this honorable court allows. By that time,
Where?
that is at
Page 61.
yes, please.
Before passing ಇಲ್ಲ ಅದಲ್ಲ.
Yes, 61, please.
61.
61. So this is the order passed by. So in this direction was issued, but when they file an application, RRT 8A proceedings was already initiated. And this order was passed on 16/9/2022. By that time, their grant was held to be not genuine. That is what your lordship, 6th July 2022 is the order. They'll not bring it to the notice of the court, and they obtain an order. And thereafterwards, a contempt petition was filed before this honorable court for not implementing the order, that is CC 999. And government challenges the order, that is in writ appeal. Both the writ appeal and the contempt were clubbed together.
Page 64. Huh?
Yes, please. And in this writ appeal, in this, they have given the respondent has relied upon the overruled judgment, that is his Lord 136, that is Murugarajendra Swami's case has been quoted. And following that judgment, the writ petition has been dismissed. Sorry, writ appeal has been dismissed.
Overrule ಆಗಿದೆಯಾ?
ಹೌದು, larger bench ಅಲ್ಲಿ overrule ಆಗಿದೆ ಅದು. That I have placed. May I pass on?
ಆಯ್ತು.
ಕೊಡಿ. That is the third judgment, my lord, 2012.
I note that. Yes.
Now, this writ appeal was dismissed and contempt proceedings in the above circumstances, writ appeal having been dismissed, CCC is disposed of, giving period of 8 weeks for the respondent accused to comply with the subject matter. So, my respectful submission, my lords, so far as when RRT 8A proceedings, the Deputy Commissioner has already decided the claim of the Mariappa, Chengappa and Gangappa, suppressing the material facts. They execute a sale agreement to this Chandru and Rashtrakuta builders. What is their right when their claim has been rejected? By obtaining RTC, they execute a sale deed on 29/4/2024.
ಈಗ ಅವ್ರದೆಲ್ಲ ಆಯ್ತು. ನಿಮ್ದು ಹೆಂಗ್ ಬಂದಿದೆ ಹೇಳಿ?
ನಮ್ದು grant ಆಗಿದೆ. Just namdu, you lordship may kindly see.
How did you come in possession of the property?
On the basis of the grant, my lord, that is I have stated in my this thing.
You are what? Mariappa, na? ನಿಮ್ಮ ಹೆಸರೇನು? ಮುನಿನಾರಾಯಣಮ್ಮ.
Muniswami Munnaranamma is the wife.
Sari. Yes. How did you come in possession of the property?
That is 18/4/1976. Munswami's husband Munnaranamma was granted.
ಅದೇ forged ಅಂತ ಹೇಳ್ತೀರಾ?
ಅದು ಅವ್ರು ಹೇಳ್ತಿದ್ದಾರೆ.
18/4/1976.
ಅವ್ರದೆಲ್ಲ ಫೋರ್ಜ್. ನಾವು ಇವಾಗ ಅವರು ಪ್ಲೇಸ್ ಮಾಡಿ, ನಾವು ಇನ್ನೊಂದು ಪ್ಲೇಸ್ ಮಾಡಿದ ಡಾಕ್ಯುಮೆಂಟ್ಸ್, ಅದರಲ್ಲಿ ಇದೇ ನಂಬರ್ಗಳು ಕೊಟ್ಟು 4 ನಂಬರ್ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದಾರೆ. ಅವ್ರು ಮಾಡಿರೋದು ಫ್ರಾಡ್. Now, then after payment, mutation and other revenue records was in the name of this Muniswami. In 15/8/1980, Muniswami died. That is, your lordship may kindly turn to my synopsis at page number 15. And then, subsequent to the death of Muniswami, an application was filed by Munnaranamma on 27/5/2020. Thereafterwards, when their application was not considered, WP 20627/2016 was filed before this honorable court for writ of mandamus. 2016.
Yes.
ಅದನ್ನ writ of mandamus direct ಮಾಡೋದಕ್ಕೆ ಇದು ಆಗ್ತಾರೆ. Then that writ petition was allowed on 6/3/2020. And then in the meanwhile, they initiate proceedings on 136(3).
ಅದಾಯ್ತು ಬಿಡಿ, ಸ್ಟೋರಿ ಆಯ್ತು
ನಮ್ಮ ಮೇಲೆ. Then this is Munnaranamma files, that is Munnaranamma filed WP 8805/2020 before this honorable court. Consider the representation. Then the Munnaranamma files contempt petition. Contempt petition was
ಹೇಳಿದ್ರಲ್ಲ ಈಗ.
ಅಲ್ಲ, ನಮ್ದ್ರಲ್ಲಿ ನಮ್ದು ಒಂದು ಆಗಿದೆ, ನಮ್ದು ಬ್ಯಾಚ್ ಒಂದು.
ನಿಮ್ದು ಬೇರೆ ಬ್ರಾಂಚ್.
ನಮ್ದು ನೀವು ನಮ್ ಕೇಸ್ ಕೇಳಿದ್ರಲ್ಲ, ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
ಸಪರೇಟ್ ಬ್ರಾಂಚ್. Yes.
That is what you lordship may kindly turn to. That is the reason, my lord. Synopsis on ಸ್ವಲ್ಪ.
ಆಯ್ತು, ಗೊತ್ತಾಯ್ತು. Yes.
Page number 17 ನಲ್ಲಿ.
ಹೇಳಿ.
19/8/2021. This is Muninaranamma filed CCC 158/2021. To implement the order. Then during the pendency, Tahsildar has issued an endorsement, passes an order, and that was brought to the notice in the contempt proceedings. Then I filed a writ petition before this honorable court, that is WP 13117/2021. That order was set aside and the matter was remanded back to the Tahsildar. Then Tahsildar issues notice under section 136(3). Then that notice that has resulted in RRT 8 proceedings. That is in my case. So then the RRT 8 proceedings.
RRT 8 is allowed, RRT 8A is dismissed.
Rejected. So
6th July 2022.
That's yes. And then, so far as the 19.3 is concerned, my lords, that is WP 5589/2022. That is, I have filed a writ petition to implement the order passed in RRT 8.
All right. That's for mandamus.
Mandamus. And then 19.4, that is WP. Our 7856/2022. This, what they wanted is for mandamus to implement the order
2016.
2016 ಮಾಡಿರೋ ಆರ್ಡರ್ ನ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಿ ಅಂತ, and at the same time to quash the RRT proceeding notice issued under RRT 8A. So this has become infructuous because
8A ಚಾಲೆಂಜ್ ಮಾಡಿದಾರಲ್ಲ.
ಇಲ್ಲ ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ 8A ಪ್ರೊಸೀಡ್ ಕಂಪ್ಲೀಟ್ ಮಾಡಕ್ಕೆ.
8A ಬರೀ ನೋಟಿಸ್ ಮಾತ್ರ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ. You last may kindly turn to that.
8A ಪ್ರೊಸೀಡಿಂಗ್ ಕಂಪ್ಲೀಟ್ ಆಗಿ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ.
ಮಾಡಿಲ್ಲ. So that has reached finality.
That you have to clarify.
That has
ಅಲ್ಲ ಅದು ಮಾಡಿಲ್ಲ
There was first the proceedings.
ಅಷ್ಟೇ ಕಂಪ್ಲೀಟ್ ಪ್ರೊಸೀಡಿಂಗ್.
In that I had the interim order saying that
no interim order,
the writ petition.
No,
it is subject to the result of the
subject. There is no interim order. That is incorrect.
I have the interim order. Copy is there.
You can place.
ಆಯ್ತು ತೊಂದ್ರೆ ಇಲ್ಲ. ಸಬ್ಜೆಕ್ಟ್ ಟು ರಿಸಲ್ಟ್ ಆಫ್ ದ ಪ್ರೊಸೀಡಿಂಗ್ ಅಂದ್ರೆ ಮುಗಿಯಿತು ತೊಂದ್ರೆ ಇಲ್ಲ.
Subject to the result of writ petition. So what is there to challenge? Because when they wanted to implement the order of the order passed by in WP number His Lordship Justice Veerappa's order, that thereafterwards notice has been challenged. That is the reason, my lord. Now afterwards there was no stay in the proceedings. The deputy commissioner conducted the proceedings.
Conduct ಮಾಡ್ತಾನೆ ಆರ್ಡರ್ ಮಾಡಿರೋದು.
ಅದನ್ನೇ ಮಾಡಿದ್ದಾರೆ. ಅದನ್ನೇ now their say is that now there was a stay order.
We'll see.
It is incorrect statement.
Wait, Kaushik, I'll get back.
And then now your lordship may kindly see admittedly the proceedings was initiated in section 67 subclause 2 of the Karnataka Land Revenue Act. So the writ petition is not maintainable. That is the law laid down by this honorable court.
Appeal ಆಗ್ಬೇಕು.
And not the appeal, civil suit ಆಗ್ಬೇಕು.
Civil suit.
ಹೌದು, section 67 subclause 2 ನಲ್ಲಿ if they are aggrieved as on now it has been amended section 67 subclause 2, as on that day they have to file a civil suit within 1 year. That is what I have placed two judgments in support of my contention. So with this background, my lords, what is the locus standi of this Mariappa and Chengappa and Gangappa when their claim has been rejected by holding that it is a fraudulent document? And can they act on the basis of that fraudulent document and execute sale agreement and sale deed? And what is the right that the developer will get? So they want to come on record as impleading applicants when their vendor has no right. They are not necessary party for the adjudication of this real controversy.
Impleading applicant ಯಾವುದು?
ಹಾಕಿದ್ದಾರೆ ಅವರು developers.
ನೀವಾ?
Not the developers, we are the agriculture. We are in actual possession of the property.
ಅವರು ಹಾಕಿದ್ದಾರೆ.
ಮುಗಿಸ್ಲಿ ತಾಳಿ ಸರ್.
Now party ಇಲ್ಲ ಅದರಲ್ಲಿ we have filed the impleading.
That's what. ಅಲ್ಲ ಅವರು ಹಾಕಿದ್ದಾರೆ. And then secondly my learned friend yesterday Basuraj appeared for some of the impleading applicants.
Impleading application ಹಾಕಿದ್ದಾರೆ. It's not that.
No, that's what I have to
ಆಯ್ತು ಬಿಡಿ, ಎಲ್ಲಾರನ್ನು ಕೇಳ್ಬಿಟ್ಟೆ ಮಾಡೋಣ. ಏನೀಗ
why I am submitting, what is the necessity to come on record, because this is what this show, because it is nothing but these present petitioners in 5559 or
they are in possession of the property. ಅವ್ರು ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅವ್ರು ಇದೆ ಅಂತ
ಹೇಳ್ತಾರೆ. ಅದಕ್ಕೆ ಹೇಳಕ್ಕೆ ಅಂದ್ಬಿಟ್ಟು ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್
ಹಾಕಿದ್ದಾರೆ. ಅಲ್ಲಿ ಅದನ್ನೇ ಅವ್ರನ್ನ ಸೆಟಪ್ ಮಾಡಿರೋದು these present petitioners.
That we will see.
Claiming the property separate matter to be argued in that case.
That we will see.
That will see.
Not that collusion.
ಅವ್ರದ್ದು ಪಿಟಿಷನ್ ಗಳಿದಾವಲ್ಲ
ಇದೆ, but their claim is in respect of ನನಗೆ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ. ಅವ್ರು ಅವತ್ತು ಕೊಡ್ತೀನಿ ಅಂದ್ರೆ ಅದು ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಕಾಪಿ ಒಂದು ಕೊಡಿ, ನಿಮ್ದೆ
ಕೊಡಿ. ಯಾಕೆ ಕಾಪಿ ಕೊಡಕ್ಕೆ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ನಿಮ್ಗೆ?
ಅವತ್ತೇ ಕೊಡ್ತೀನಿ ಅಂದ್ರೆ ಅವತ್ತು ಕೊಡ್ಲಿಲ್ಲ. ಕೊಡಿ, ಇಲ್ಲೇ ಕೊಡ್ತೀನಿ, ಈಗಲೇ ಒಂದ್ ನಿಮಿಷ, ಇವಾಗ ನಿಮ್ದೆ ಕೊಡಿ.
ಅವ್ರದೇ ಕೊಟ್ಬಿಟ್ರು ಬಿಡಿ ತೊಂದ್ರೆ. ಎಸ್. ಈಗ ಯಾಕೆ ಓದ್ತಾ ಇದ್ದೀರಾ? ಓದ್ಕೊಳ್ಳಿ ಆಮೇಲೆ.
ಇಲ್ಲ ಓದ್ತಿಲ್ಲ. ಅವ್ರದ್ದು ಫಾರಂ ನಂಬರ್ 53 ಇಲ್ಲಿ ಏನಿದೆ ಅಂದ್ರೆ ದೇ ಆರ್ ಲೇಯಿಂಗ್ ಅಪ್ ಆನ್ ದಿಸ್ ಜಡ್ಜ್ಮೆಂಟ್. ದಟ್ ಈಸ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ಕೈಂಡ್ಲಿ ಟರ್ನ್ ಟು ಪೇಜ್ ನಂಬರ್ ದಟ್ ಈಸ್ ಅನೆಕ್ಷ R2.
ಆಯ್ತು ಹೇಳಿ.
ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ 22nd of February 2024 in this some of the petitioners have filed in this Mariappa, Chengappa, Gangappa are parties, and thereafterwards this Manjunatha, Prakasha, Kumara, and then Muni Narayanamma is respondent number 5. Now, your lordship may kindly turn to this. The court had rejected the contention of the para number 4, please. The court had rejected the contention of the revenue authorities having regard to the judgment of the Honorable Supreme Court so and so, so and so. Then, when the order, para number 6, that being the possession, if it is the contention of the petitioner that they are not in any way claiming the lands that were already granted in favor of the private respondents herein, but they are in possession of various other pieces of land in larger extent of 23 acres. The Tahsildar is required to place the application to the petitioner before the committee along with the recommendation. Consequently, the writ petition stands disposed of with a specific direction to the Tahsildar, Bangalore South Taluk, to place the application to the petitioner along with his recommendation before the committee for regularized unauthorized occupation within a period of 2 months from so and so. The committee shall thereafter consider the applicant pass order expeditiously as possible so and so. So, whatever the granted land that has not been disturbed, that is what the para number 6 did. That being the position, if it is the contention of the petitioner that they are not in any way claiming the lands that were already granted in favor of the private respondents. So their form number 53 is in respect of survey number 103, 106, all those things survey numbers.
Clarify next.
So
yes.
My respectful submission, when their claim itself, the impleading applicant's claim is in respect of some of the survey numbers, how can they come on record in this?
I have not permitted.
No, that's the reason. ಅದಕ್ಕೆಲ್ಲ ಅವ್ರು ಹಾಕಿರೋದಕ್ಕೆ ಅವ್ರಿಗೆ ಕ್ಲೇಮ್ ಹಾಕಿರೋದೇ ಬೇರೆ ಸರ್ವೆ ನಂಬರ್ಗೆ ಇಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು ನಮ್ಮನ್ ಪಾರ್ಟಿ ಮಾಡಿ and moreover there is an observation by this honorable courts that whatever the land granted in favor of private person should not be disturbed. So my respectful submission, my lords, so far as the applicants, impleading applicants, they cannot maintain application before this honorable court. And so far as the writ petition filed, that is the one for that is 19.4 7856/2022 has become infectious because now the order has been passed in RRT 8A, and when they are not challenged, the order passed in my favor, sorry, in their claim, the writ is not maintainable. Then some of the judgments I have placed, so far as with regard to that I have placed, and that overruled judgment has been placed before the division bench, and review petition is pending before this honorable court as against the writ appeal and this thing, and one SLP is pending before the Supreme Court.
28 ಮಾಡ್ತೀರಾ 28 ಮುಗಿಸ್ಬಿಡಿ ನೀವು ಬಸವರಾಜ್ ಸರ್ ನೀವು 28 ಮುಗಿಸ್ಬಿಡಿ 28 again at 4 PM I'll take.
Regarding that writ petition, what is the order that has
ಕೊಡಿ ಶಿವತ್ ಸರ್ ನೀವು ಇದ್ದೀರಾ?
ಸ್ಪಷ್ಟವಾಗಿ ಹೇಳಿದ್ದಾರೆ. I don't want to
8A ಮೇಲೆ ಅದು ಆರ್ಡರ್
8A ಮೇಲೆ ಏನಿದೆ
8A will be
subject to result of the petition.
ಅಷ್ಟೇ.
So now
8A already order ಆಗಿದೆ.
Petition is before your lordship.
ಇಲ್ಲ ನೋಟಿಸ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರಿ ಆಯ್ತಾ? At that time court said subject to the result of the petition whatever will be in. That petition is still pending, is it? Yes. ಅದೇನಾಯ್ತು ಹಂಗಾರ ತೊಂದ್ರೆ
ಅಲ್ಲ, ಅದು ನೋಟಿಫಿಕೇಶನ್ ನೋಟಿಸ್ ಮಾತ್ರ ಅಷ್ಟೇ ಚಾಲೆಂಜ್ ಮಾಡೋದು. They have not challenged the order.
Subject to the result ಅಂತ ಮಾಡಿದ್ರು, order has gone against them.
That's what they have to challenge.
ಅಲ್ಲ ನಾರ್ಮಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಹಾಕ್ಬೇಕಾಗಿತ್ತು, ಬಟ್ ಎನಿವೇ ಇಟ್ಸ್ ಮೇಡ್ ಸಬ್ಜೆಕ್ಟ್ ಟು ರಿಸಲ್ಟ್ ಆಫ್ ದ ಪಿಟಿಷನ್.
ಅಲ್ಲ ಬಟ್ ಆಗಿದೆ, ಬಟ್ ಅದ್ರ ಮೇಲೆ ನಾವು when their claim has been rejected, they go and execute all sorts of documents. How can they execute and knowing fully well that their claim has been rejected?
ಶಿವತ್ ಸರ್ ಏನ್ ಬೇಡವಾ?
ಸ್ಟೇಟಸ್ ಕೋ ಆರ್ಡರ್ ಆಗಿದೆ.
ಸೊ 28 4 PM ಕಂಪ್ಲೀಟ್ ಮಾಡ್ಬಿಡಿ. ಎಸ್ ಕೌಶಿಕ್ ಆಗುತ್ತಲ್ಲ? ಪ್ರಸನ್ನ ಕುಮಾರ್ ಸರ್ ಬರ್ತಾರೆ? ನೀವು ಅಷ್ಟು ಬಸವರಾಜ್ ಸರ್ ಬರಕ್ ಹೇಳಿ. ನೀವು ಇದ್ದೀರಾ ವಸಂತ್?
ಆಮೇಲೆ one more thing, that is that BDA that has lapsed because now notification you have 76, but till date nothing has happened, so that acquisition has lapsed, that has to go.
ಯಾವ್ದದು?
19.5.
ಆಯ್ತು ನೋಡ್. On that day, we'll take this on 28th.
They have not completed.
Criminal complete ಮಾಡಿ. ಹೌದಾ?
We have completed.
ಅವರು ಮಾಡಿದ್ದಾರೆ. ಅವರೇ, ಎಸ್ ಪ್ರವೀಣ್. ಪ್ರವೀಣ್ ಅಲ್ಲಿ ಇಲ್ವಾ? ಪ್ರವೀಣ್ has completed, I guess. ಅವರೇ ತಾನೇ ಅದ್ರಲ್ಲಿ.
ಹೌದು. ಅವ್ರು ಮಾಡಿ.
Then few points will reply to it.
ಯಾವ್ದ್ರ ಇದಕ್ಕೆ? ಕ್ರಿಮಿನಲ್ಗೂ ರಿಪ್ಲೈ ಮಾಡ್ಬೇಕಾ?
ಇಲ್ಲ ಅದ್ರಲ್ಲಿ.
ಅದು ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಮುಗಿಸಿದಿರಲ್ಲ? ಹಾ, ಅದು ಮುಗಿಸ ನೋಟ್ಸ್ ಮಾಡ್ಕೊಂಡಿದೆ. ರಿಪ್ಲೈ ಆಗಿದೆ. ಪ್ರಸನ್ನ ಕುಮಾರ್ has replied also. If you want to say something, you can say. But Thursday this should be over. 28th. Please. At 4 p.m.
Petitioner, your lordships, in the 20 matter.
What are these 4 matters, madam?
It's pertaining to the Birds Act, your lordships.
Why is it before me? We'll post it before the appropriate bench.
It can be heard, your lordships, because.
You are ready?
Yes, your lordships.
Then come on. Yes.
Your lordship, I'm accused number 12 in this matter. My name is not even reflected on the complaint nor the FIR, your lordship, but I have been charge sheeted. The only claim I was
No
made.
problem. Name need not be there in the complaint or the FIR.
The reason why my name has been reflected is I was a brother of the accused number 7 who has already obtained stay from this case. It is one of the connected matters.
Interim orders are operating here.
Yes, your lordships.
Let the state come. Jagdish sir barak heli. Next time.
Any date might be fixed.
Next Saturday.
Next Saturday.
Yes,
Much obliged.
next Saturday is also a working day.
Yes, your lordships.
All right. Heard the learned counsel. What's your name?
Nazifa Mullah.
So and so, appearing for the petitioner. List the matter on 30th. Interim order subsisting will continue to the next date of hearing. Yes. Next.
20.1 and 2, there is an interim order of stay.
Wherever, all the matters interim order continue ಮಾಡಿ.
Please.
Next.
21.
20?
21. Serial number 21.
Yes, sir.
Because these RFS, we are ready to proceed with the matter.
Ah.
Being led by Mr. Srinivas Raghavan, who's on his legs in the adjacent court hall, my lords.
Pass over madla.
Pass over Madi, or my lords may have it next Saturday. We are ready to proceed.
You are ready to proceed?
We are ready to argue the matter. Mr. Raghavan on his legs in the adjacent court hall. That is the only difficulty.
We'll be proceeding till the next week.
Well, any
Yes.
lordships.
You are ready?
Ready.
See?
They will be ready.
You should be ready.
Well, Mr. Raghavan conducted trial in this matter.
2011, sir. It's by special orders also. Yes.
Well, we are ready. We have our synopsis also. May either pass over the matter.
Synopsis ಕೊಟ್ಬಿಡಿ. ನೀವು next week ಮಾಡಿ ತೊಂದರೆ ಇಲ್ಲ.
I'll
Let me go through it. Serve ಮಾಡಿ ಅವ್ರಿಗೆ.
I'm handing copy.
But finally, I'll post it on next Friday. Friday ಅಲ್ಲ. 30th Saturday. In case 30th bench ಇದೆ ಅಂದ್ರೆ, I'll fix a date. Another day it should get over.
In fact, last date also we were ready, my lords. My
I was
lords had
not
a division
ready.
bench. So
That's
that's why the matter didn't reach. So we are ready to proceed.
All right. ಜಗದೀಶ್ ಸರ್, ಅದು 482 ಯಾವತ್ತು ಹಾಕ್ಲಿ? Birds Act. Any ಇನ್ನೊಂದು ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಹಾಕಿರ್ತೀನಿ, ನೀವು ಫ್ರೀ ಇರ್ತೀನಿ. Yes.
Saturday, my lords.
Saturday.
Grateful, my lord.
ಅವತ್ತು ಮುಗಿಬೇಕು.
22.
22, I'm appearing for the respondent slum dwellers. My lord had heard this matter, my lord, and synopsis has also been filed.
My lord, appear for petitioner. Yesterday I filed NOC wakalat, my lord.
ಒಂದು ನಿಮಿಷ ಸರ್.
My lord, ಇದರಲ್ಲಿ arguments conclude ಆಗಿದೆ. Synopsis have been filed by both the parties.
ಇದು what matter is this?
This is the slum matter, my lord, where the land, which this, my lord, the
That
petitioner.
next to temple.
Illa, that's the other one, my lord. This
All
is
right.
the one which is in Dollars Colony, where BDA claims that they have acquired this land on which the slum is. Thereafter, my lord, the slum gets declared. Then this petitioner, my lord, is now claiming that he is the owner of that land. And this, my lord,
Yes.
had heard this entire matter.
This one,
Synopsis has been filed.
we'll take it on 1st September.
Yes, my lord.
So I've filed a memo for retirement.
Who has come on record?
Venkatesh P. Dadwai.
ಯಾರು?
Yesterday I filed wakalat NOC wakalat, my lord.
ಯಾರು?
Petitioner.
ಯಾರು ಕೌನ್ಸಿಲ್ ಹೆಸರೇನಪ್ಪ?
Venkatesh P. Dalwai.
Dalwai. Learned counsel submits that Venkatesh P. Dalwai has entered appearance in place of Keshav M. Datar, who has filed a memo for retirement. In the light of, in that light, memo of retirement accepted, so and so permitted to retire. Next.
Interim order extension.
My lord, and first, my lord,
First, yes.
grateful.
23.
Petitioner in this case. Lordship were pleased to quash this petition, and subsequently memo for being spoken to was filed by the state, saying that the de facto complainant was not heard.
He served unrepresented.
Since the last 5 occasions, they are not here.
ಇವ್ರು ಬರೋದಿಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಕೊಡೋದು ಅಷ್ಟೇ. I had already quashed it.
Quashed. Other accused persons are acquitted before the trial court, considering that your lordship were pleased to quash this petition.
ಅಲ್ಲ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ನಾ ಅಥವಾ
ಆರ್ಡರ್ ಪಾಸ್ ಆಗಿತ್ತು, ರಿಲೀಸ್ ಆಗೋ ದಿನ ಅವರು when your lordship were in Dharwad.
ಚೆಕ್ ಮಾಡ್ಬಿಡಿ ಅದು ಚೆಕ್ ಫಾರ್ ದಿ ಆರ್ಡರ್ ಇದ್ರೆ ಅದು ಜಗದೀಶ್ ಸರ್ ಸೇಮ್ ಆರ್ಡರ್ ಹೆಂಗೋ ಇಸ್ ಅನ್ರೆಪ್ರೆಸೆಂಟೆಡ್ ಡಿಸ್ಪೋಸ್ಡ್.
ಗ್ರೇಟ್.
ಅದು ಆರ್ಡರ್ ಇರಬೇಕು, ಚೆಕ್ ಸೈನ್ ಮಾಡಿ.
24.
For petitioner, my lord, in respect of the compromise decree, my lord, that we are
ಇನ್ನೂ
challenging.
ಮುಗ್ದಿಲ್ವಾ?
ಅದನ್ನು ಮುಗ್ದಿಲ್ಲ.
3 ಲಕ್ಷ ಏನಾಯ್ತು? 3
3
ಕೋಟಿ.
ಕೋಟಿ 34 ಲಕ್ಷ, my lord. They have given a proposal for 1 crore. I'll make submission.
ಹೇಳಿ ಮಸ್.
They have given a proposal for 1 crore. They are ready to give to the landowners, my lord. We are the landowners. They are admittedly, they are the agreement holders. What I suggested them is 50-50 you make it. It comes to around 1 crore 80 lakhs, my lord. If it is reasonable, they are landowner, and the two, she is not the landlady, only owner of the property. Other sisters are there, they have filed a suit, they have obtained an interim order.
ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಆಮೇಲೆ ಏನ್ ಬರಿತೀವೋ ಗೊತ್ತಿಲ್ಲ. ಇಟ್ ಇಸ್ ಬೆಟರ್ ಟು ಸಿಟ್
ಅಕ್ವಿಷನ್ ಆಗಿರೋದು ತಾವು ಒಂದು ಜಜ್ಮೆಂಟ್ ಮನೆ ಬರ್ದಿದ್ದೀರಿ, ನಿಮ್ದು ಒಂದು ಜಜ್ಮೆಂಟ್ ಇದೆ. ಅಕ್ವಿಷನ್ ಆದ್ಮೇಲೆ ದೇ ಆರ್ ನಾಟ್ ದಿ ಓನರ್ಸ್. ಅಲ್ಲ ನಾನು ಹೇಳೋದು
ಆದ್ಮೇಲೆ ಪರ್ಚೇಸ್ ಮಾಡಿರೋದ.
ಹೌದು, ಅದೇನಾಗಿದೆ, ಲ್ಯಾಂಡ್ ಹ್ಯಾಸ್ ಬೀನ್ ಅಕ್ವೈರ್ಡ್ ರೈಲ್ವೆಗೆ ಆನ್ 17/9/2019 ಲ್ಯಾಂಡ್ ಅಕ್ವೈರ್ಡ್. ರಿಜಿಸ್ಟರ್ಡ್ agreement of sale dated 16/2/2021 after 2 years. Hagagi
landowners
and that too, I don't want to make submission. The respondent, the agreement holders or lawyers, I told them this is a land acquisition matter. I requested him, I being the representative of the bar, I should not big the things here. I advised him, if feasible, 50-50% landowners also they will get. I am the landowner.
We have sat with them, we have spoken, but
but purchase after acquisition.
My lord, the question here before this
national highway ಮೊನ್ನೆ ಬರ್ದಿದ್ದೀನಿ.
ಅದೇ ತಮ್ಮದೇ ಇದೆ
ಗಿರಿಧರ.
But the question before this honorable court in this writ petition is whether a compromise decree.
No, that is correct. adamele but I can land acquisition connect agide. No, the land acquisition matter is also connected here.
Correct, my lord. Both the matters are connected.
No, if I answer that, ಆಮೇಲೆ ಏನು ಸಿಗಲ್ಲ. What Madhusudan says is correct.
50%. I am also
discretion best part of valor.
ಹೌದು, ಮತ್ತು ಇಂಟ್ರೆಸ್ಟ್ ಸಿಗುತ್ತೆ ಅದರಲ್ಲಿ 50-50.
ನೋಡಿ, it is better to do that way. He is absolutely right. If you go strictly by law,
my lord, if
post preliminary acquisition, preliminary notification, gone. That's my judgment.
Yes, ಅದನ್ನು ಕೊಡ್ತೀನಿ ಅವ್ರಿಗೆ ಸಾಹೇಬ್ರು ಇರಿದಾರೆ.
ಅಲ್ಲ, I only reiterated the settled position of law.
Yes.
Yes, Arun.
Lord, may I seek a week's
ಅಲ್ಲ,
accommodation?
ತಗೊಳ್ಳಿ, ತೊಂದರೆ ಇಲ್ಲ. That is the best way to resolve this problem.
In fact, my lord, we
You are also there, my brothers. I don't want to, that's why they are from my native. I advised him.
We put our honest efforts, my lord, by going to their office. Again, I am ready to go. That is not the issue, my lord.
ಏನೂ ಬರಲ್ಲ ಇಲ್ಲ.
50-50.
ಆಯ್ತು.
One chart date.
12th September I'll take.
Please.
ಅಷ್ಟರಲ್ಲಿ ಮಾಡಿರಿ. List on 12th September.
Please.
Yes.
Please.
These RERA matters ಏನಿದೆಲ್ಲ.
25.
I am in 25.71. The issue appears to be that
the petitioners are home buyers, there is a default on the part of the promoter, at least in my case. So they say that the bank must collect the money from the promoter and the landowner. Their loan must be paid by the bank. That seems to be the case.
See, there appears to be some rationale if that is the contention. Now, the developer
My lords,
upfront collects the entire amount or takes loan from the bank.
please.
They are made to pay EMI, no money, no house. That is why upfront collect money. If that is the issue in this, ಏನು issue ಇದರಲ್ಲಿ?
Issue is with regard to the constitutionality of the imposition of delay fee circular notes.
Delay fee circular.
Yes, my
Which is that?
It is.
No, no, but in
Hmm.
ours there are no such
You
prayers.
come to the mic, madam.
That's fine, but there are no prayers.
My lord, we are supposed to file certain quarterly returns according to the Act, my lord, which if not filed in time, or if we are seeking for extension of time, there is a delay fee which has been imposed as a precondition to file the extension report.
No, imposed by whom?
There are, my lord.
By RERA.
Yes,
That is what is under challenge.
Yes, please, my lord. That particular circular which
ಮತ್ತೆ ಇದ್ಯಾವುದು ಬೇರೆ ಅಂದ್ರೆ ಮನು?
My lords,
Circular is challenge.
in mine the circulars are produced, but they won't, their relief stops at pay the
See,
loan and
now
rectify
this
my civil score.
circular imposing delay fee and delayed submissions of quarterly update and annual audit statement. Who is the petitioner in this?
All developers.
All the petitioners are developers.
Builders are.
All the developers and builders are petitioners.
Gautam,
Always,
ನೀವು ಹೇಳ್ಬೇಕು.
it's on the circular, my lord. Circular, because under the statute, my lord, RERA Act, my lord, they are duty bound to
RERA Act ಕೊಡಿ ಮೇಡಮ್.
RERA Act. My lord, section
Who is
11,
leading the submission here? ಹೇಳಿ.
Yes, my lord.
Which is your petition, madam?
My lord, minus 25.16.
ಅದು ಸಿಗುತ್ತಾ ನೋಡಿ ಮೇಡಮ್. 25.16.
My lord, majority of the matters are with respect to the circular, my lord, which is dated 1/6/2018 and 3/9/2020, my lord.
3/9?
3/9/2020, that is at Annexure C, page 37 in my petition.
All right. 3/9/2020, I have it, yes.
This is the impugned circular, my lord, which levies a certain amount. There is a basis for calculation is also mentioned. Which levies certain amount as a delay, as a fee for granting extension to file the audit report. And my lord, my petition is has one more additional prayer along with other petitions, that is with respect to recognizing the right to withdraw my application, my lord.
What application?
Lord, when I make an application seeking grant of registration, that is granted, and then I start my construction, and when the construction commences, I parallelly invite for applications from the public.
Home buyers.
Home buyers. Now, my lord, when the home buyers don't turn up and the registration doesn't
So there is
happen.
no home buyer at all.
No, my lord, there is no home buyer due to the reason of force majeure. And when there, in such circumstances, I am supposed to extend the registration and I don't have the permission to withdraw the same under the RERA Act.
So this is the additional relief you have sought.
Additional relief along with challenging the circular in my particular petition.
So broadly, these are the challenges
Broadly,
in all
these are
these
challenges.
cases.
Yes, please, madam.
mainly the
Gautam,
circular.
objection ಹಾಕಿಲ್ವ ಯಾವ್ದ್ರಲ್ಲೂ?
We have filed in
ಹಾಕಿದ್ದೀರಾ?
many cases, my lord.
fine,
We'll adopt
yes.
the same objection to.
Now, what is your ground of challenge? Tell me.
Let's, under section 11, under section 4 and section 37.
4/11/37.
4/11.
Yes.
And these are the three provisions that have been invoked by the authority for issuing this circular. Let's 37 is the blanket power utilizing which I'll read out the provision below. It says, section 37.
Yes.
Powers of authority to issue directions. The authority may, for the purpose of discharging its functions under the provisions of this act or rules or regulations made thereunder, issue such directions from time to time to the promoters or allottees or real estate agents, as the case may be, as it may consider necessary, and such directions shall be binding on all concerned. This provision talks about the issuance of directions. However, furthermore, they have also invoked the provision section 4(2)LD. Section 42LD talks about the application of registration for real estate projects. Now, there are certain duties and the format in which the application has to be filed. That is what is provided under section 4.2 minutes.
Yes.
I'll just read out the relevant provision. Section 4.2 reads, the promoter shall enclose the following documents along with the application referred to in subsection 1, namely, so many documents are there, brief details of the enterprise, the project launched by him, authenticated copy of the approvals. The fourth point is 4.2L is with regard to the declaration supported by an affidavit which shall be signed by the promoter or any person authorized by the promoter stating that he has legal title to the land with regard to the project.
4 to LD.
LD.
4 to 1D.
LD. 4 to
1D sanction plan.
LD minutes.
LD. L has A to D. In that 70%, ada?
Yes.
All right.
70% amount is what is prescribed. Now, these are the mandatory compliances that the promoter has to do. Now, furthermore, reading under section 11 minutes. Section 11 clause 1. It says functions and duties of the promoter. The promoter shall, upon receiving his login ID password under clause A of subsection 1 or under subsection 2 of section 5, as the case may be, create his web page on the website of the authority and shall enter all details of the proposed project as provided under subsection 2 of section 4 in all the fields as provided for public viewing, including details of the registration granted by the authority, quarterly up to date. Now, this is where the submission of the quarterly update comes into picture. Here it says under clause B, quarterly up to date, the list of the number and type of apartments or plots as the case may be booked. Quarterly up to date, the list of number of garages booked. Quarterly up to date, the list of approvals taken and the approvals which are pending subsequent to the commencement of certificate. Quarterly up to date status of the project, such other information and documents as may be specified. Now, reading all these three provisions, it becomes abundantly clear, Millards, that the authority has no power to issue the impugned circular because they have imposed a delay fee of rupees 10,000 if there is a delay less than 1 month. Or if there is a delay beyond 1 month, the amount increases to 20,000 rupees. Now, this particular power, Millards, to impose the delay fee is nowhere provided under any of the provisions, even not there under the rules as well. Now, for this particular provision, Millards, they've also relied on the rule 15D of the Karnataka real estate regulation, Millards.
Regulation or rule?
Rules, Millards, I apologize.
15D.
15D, Millards.
Promoter shall upload the following updates.
Yes, Millards. Now, these are some of the obligations that have already been imposed on the promoters. But nowhere reading these provisions, there is no provision for imposing any kind of delay fees. Now, I have filed 8 petitions. In these 8 petitions, the amount that have been demanded in the projects, Millards, in one of the lead petition, the amount is 7.9 lakh. In the petition 3941, the amount is again 7.9 lakh. In another project that is WP 3206, the amount is 38 lakhs.
Delay fee.
Delay fees. In other projects, there is 47 lakhs. There is 8 lakhs. So the number is very, very different. And
otherwise, how can you be bought to books?
Millards, but we are ready to comply with the orders, Millards. What has happened is the imposition of the delay fee is unconstitutional, is what we are challenging. Because, Millards, we have been submitting, because otherwise what happens, the website that is provided by the authority, it is developed in such a way that even if we don't pay the amount that is imposed on us, we cannot move further, we cannot submit, or we cannot take up any other projects. This is one of the important impediments that the project, that the RERA is imposed.
Milord, the contention is that
appeal. ಏನು appeal? ಯಾವುದರಲ್ಲಿ?
37 directions under section 37 ಅಲ್ಲಿ 43 they can go and appeal. Today the tribunal is functioning.
ಇದು functioning ಇಲ್ಲ ಅಂತ stay ಮಾಡಿದ್ದ ಎಲ್ಲ.
ಆ ಟೈಮ್ ಅಲ್ಲಿ functioning ಇರಲಿಲ್ಲ.
And Milord, there is no bar on filing a writ petition as well.
See. Yes. Challenge the constitutionality. So.
My lords, the only contention is that, my
Wait,
lord,
madam, we see.
my lord, the only contention is that, my lord, as your lordship said, there are other ways, as your lordship
You
said,
tell
my
me
lord.
which way can the developer be
My lord, that's an administrative action which
held
has to
on
be
to the
decided
hooks?
by the
Otherwise, you
respondent,
will
my lord. I cannot.
take money and run away.
No, my lord, that's an administrative decision of the respondent. Something that is constitutionally valid. Delay fee is
Lord,
way more than the extension fee itself.
No, that's the correct. No, to charge any fee, you must have power.
Yes, my
Otherwise,
my lord,
imposition of
Lord,
imposition of impost can be only on a power that is conferred under the statute.
My lord,
yes,
there
my
is
lord.
one
My lord,
additional
section
submission with
34,
respect
the
to.
functions of the authority.
1 minute,
itself.
Purnima, madam.
Section 34 may kindly be seen, my lord. Section 34, functions of the authority shall include, F, my lord, to ensure compliance of the obligations cast upon the promoters, the allottees and the real estate agents under this act and the rules and regulations there made. Ensure compliance of its regulations or orders and directions made in exercise of its powers under this act, my lord. That is the functions of the very function of the authority is such, my lord, to ensure that there is a compliance of the obligations cast upon the promoters. The promoters have been
No
cast.
problem. But how do you get fees?
My lord, we have the power to issue directions, my lord.
See, tax is imposable. No question of bargain you have to pay.
Yes.
Fee is always a quid pro quo.
Yes, but
What is the quid pro quo in imposing delay fees? What is that
No,
RERA is
my-
giving or
there is
somebody
a-
else is giving
there is a
for imposition of fee? With a fee, without quid pro quo, no fee.
my lord, there is an obligation under
That's
this.
settled principle of
My
law.
lord, they have duty bound to pay the
Duty bound.
duty bound.
Duty bound to perform that act.
Yes, ma'am. Perform this act.
Adike, performing that act, if they have not performed, what is the consequence?
Then we under the section 37, we can issue directions, my lord. Section 37.
So 34 see, the drill goes like this. Now a registration is made by a developer
Yes, ma'am.
under RERA. In terms of section 11, he has to update the on the RERA website quarterly on quarterly basis what is the development. So he does not update. He does not update, then the functions of the authority comes under section 34. If 34 only you may be penalized ante you come to 34 to maintain a database website viewing so and so for which has been revoked or have been penalized under this act. So they are not yet penalized. Now come to 37. 37 is power of the authority to issue directions. Now non-compliance of 11 can result in issuing a direction of imposition of a fee. You must have power.
My lord, section 38.
And that should be explicit.
Section
You
38.
can't see fees or tax cannot be inferred.
My lord, section
It should be on the face of it, you should have power. Power cannot be inferred and that power should be exercised in terms of that statute.
Section 38, I request,
Yes.
my lord. The authority shall have the power to impose penalty or interest in regard to any contravention obligations cast upon the promoter, the allottee and the real estate agents under this act or rules and regulation made thereunder. The authority shall be guided by principles of natural
That's
justice.
okay. Powers to impose penalty, interest in regard to contravention of the obligations cast upon promoters, allottees.
That was the obligation, my lord, earlier.
Let us see.
My
Yes,
lord,
sir.
there is one additional submission.
Neevu idira?
Circular is issued
That I know, sir. Contrary to the act.
contrary to the act. And my lord, circular is dated 3/9/2020. Lord, the delay which has occurred during the year 17-18, 18-19.
Adu madidara?
It's a retrospective circular.
That circular is given effect to retrospective effects and delay which has occurred during the year 18, 19 and 20. Lord, they have
So
imposed.
20 ಆದ್ಮೇಲೆ ಪರವಾಗಿಲ್ವಾ?
ಯಾವಾಗ್ಲೂ ಹಾಕೋದ್ ಬೇಡ ಅಂತ. But assuming for a moment they have got power, they cannot impose fee for delay fee prior to 3/9/2020. They have invoked section 37, issued circular. Circular is not always prospective in nature.
No, they themselves have mentioned in the circular.
No, it can't be retrospective at all.
At all.
if that is so, they cannot charge.
Two things, Gautam. One is circular cannot have retrospective effect, no doubt about it. The other is to charge fee, you must have a specific provision. And fee should be charged not as deviation of any obligation, but as a quid pro quo. Delay fee, yes, for what is it? Penalty anta ನೀವು ಮಾಡಿದ್ರೆ ಅದು ಬೇರೆ. You have to answer it, yes.
My lord, there is one more submission, my lord. As section 38 stipulates that principles of natural justice should be followed.
Notice ಕೊಡ್ಬೇಕಾಗಿತ್ತು.
There is no notice, and in fact, the act even stipulates that a
Yes,
hearing
cut at
should
the
be
root of the matter.
My lords, may I, my lords, one
Who
submission,
did
please?
Yes, sir. Now we see, tell me, madam.
My lords, in furtherance to the submission that the circular is prospective, but the fee is levied retrospectively. If the levy of the fee itself is seen from the quarter of 2019, while the circular was operating, the fee.
That is already submitted, yes.
Yes, yes, my lords. Yes, my
It is neither retrospective nor retroactive, yes.
Yes, my lords.
Then, hey,
My lord, one more.
went off. Sorry, buddy.
My lord, one submission to the additional prayer and my petition, my lord.
That's your petition. That's the only petition which is additional prayer.
I'm not aware of that, my lord, but my petition.
Idರಲ್ಲಿ ಏನು ಹೇಳಿ madam.
My lord, my submission is that Rule 7 of care era rules, my lord. It deals with extension of registration of project.
You want to withdraw from the registration.
Yes, please, my lord.
Now, if that is permitted, tomorrow you collect money and everything and withdraw from the project and walk away.
No, my lord, but
Who
in
will
case-
regulate you?
My lord, I'm asking for permission to withdraw only in case of force majeure, not in all conditions.
What force majeure has happened in your case?
COVID, my lord. I
Oh.
started during 2020. That was the peak time of COVID. I couldn't attract any
Why did you
buyers.
choose that year?
Fate, my lord. My lord, I'm not, my lord, but still, my lord, this is like, my lord, they have made the application in 2020 and then they were not unable to attract any buyers. And since there were
COVID
no
ಅಲ್ಲಿ ಯಾರು
prospective-
ಬರ್ತಾರೆ madam?
Lord,
Yes.
construction was also not completed. So they applied for cancellation of plan from the municipality. And later on, my lord, applied for withdrawal of registration before the care era. Now, my lord, this circular is being, clauses of the circular is being held as a leverage to permit me to withdraw my project. Now, my lord, my only contention is that my right to withdraw accrues along with making the application. Since I'm not continuing the projects, maybe this might not be applicable to all the projects, my lord, but under circumstances of force majeure, if there is a direction given to the respondent number 1 to make suitable changes in
We'll
the
see.
act rule.
Your case is unique, will see. Added unique. Otherwise, it is common.
Yes, my lord, yes, please.
Yes, Nanjali sir.
Milord, there are no complaints, Milord, against regard to Milord, whether I have completed or any complaints linked to
No.
cheating or.
Manu ಯಾರಿಗೆ?
Lord, it appears, my lords, that at 2:30 it was mentioned and it was de-tagged from this because the issue in my petition is
Different.
Very different.
D-tag ಆಗಿದೆ ಅದು.
at 2:30, that's what court officer informed.
Yes, Gautam, ಅಷ್ಟೇ ಅಲ್ಲ? Objections ಹಾಕಿದ್ದೀರಾ? Consider.
There are fee, the power to levy fee is there for the RERA, my lord. If they are to deem the fees and ಹೇಳಿದ್ರೆ, there is a power to the RERA to levy fees, registration fees, so. all the
ಹೌದು,
fees
ಎಲ್ಲ
there
ಫೀ
are
ಇದೆ.
powers, all of
ಫೀ
them.
ಇದೆ.
Penalty-ಗುನು fee, powers ಇದೆ.
ಅಲ್ಲ, ಇದು violation of any condition of the statute, ಅದಕ್ಕೆ ಫೀ ಇದೆಯಾ?
Violation of the condition is 38 itself, my lord.
ಅದೇ, that's what Gautam said, 38.
38 is very clear and 37 is a direction to give effect to 38. And all such orders are appealable. Now the constitutionality, the question doesn't come because
ಅಲ್ಲ,
of the power.
because they have appealable ಅಂದ್ರೆ the provision itself is called in question.
I can see-
Circular is called in question.
If I can demonstrate that 37 direction.
No, that is all right. If circular is called in, circular of RERA is called in question, RERA itself considering it cannot happen.
Appellate tribunal. I can
Whatever.
see. For a moment.
Where appellate tribunal?
37, there's a power to issue directions to give effect to 38. And my lord, fees, my lord, is aware registration fees as well as the.
Those fee, yes,
all
ಅದು
of-
specific ಆಗಿ ಪವರ್ ಇದೆ.
Specific power.
ಡಿಲೇ ಫೀ ಎಲ್ಲಿದೆ?
Delay fees, they are not contemplated at the time of, because quarterly updates were to be made in the website.
We should amend the provision to that effect.
My lord, the blanket provision I would say is as per, my lord, as Gautam had rightly pointed out, as 34, my lord, the powers of the RERA to give effect to its, may the, my lord, 34.
I think that should cover.
That should cover is what.
We'll consider. If there's anything, I'll post it for further hearing.
In 3 more petitions, challenged one more circular, which imposes annual audit report, that is submission of annual audit report, and it imposes a penalty on us, Millards.
ನಿಮ್ದೇನಾರು ಇದೆಯಾ?
Millards, may Millards, may I?
Same circular is challenged.
Circular, but only submission, my lord, I wanted to make is the circular cannot have a force of law unless.
That's what all of them have submitted now.
Nevertheless, the act also, though a special enactment does not, my lord, empower them to, my lord, levy any tax penalty.
That's all.
Prospective effect may not be correct because the circular itself says it is prospective. That may not.
Circular is prospective.
Correct. It
But
is-
what you have charged is retrospective.
That may not be an accurate statement.
Anyway, if that is not there, 1819 charge should go straight away.
That is not
This
the
will see whether it is sustainable or not. Yes, Sandeep.
Millards, to supplement all the submissions made, Millards, in my writ petitions, as Annexure D, I have added the statement how this comes, Millards, the rationality. One is the banking of, or the statutory banking of imposition of these charges. The other one is, Millards, reasonableness of what this charge actually has its implication. Now, Millards, I have made a statement, Millards, in all these projects, in this, it almost runs to 26 lakhs, 30 lakhs, and today it will almost go about 40 lakhs, Millards. Millards, can this be reasonable in terms of imposition?
How to hold your tenterhooks?
Millards, the statute gives the power to the authority, Millards, to make the rules. The power has to be reasonably exercised, Millards, is what is my submission, Millards.
You don't tell me about law. I'm asking you, if you don't do it at all, how can you be held responsible?
Millards, indeed, Millards, if there is a delay, my humble submission is this: if there is a delay and default for a period, I should be penalized for that period. It cannot be made, it is something like this, Millards. If I can draw parlance with respect to simple interest and compound interest, literally this, if my statement is seen, the nature in which the fee has been imposed is similar like a compound interest, Millards. It just gets added in both parlance, Millards, on the 2018-19 from each quarter for each month, Millards. If my statement can be seen at Annexure D, Millards, I have produced it to show. It is just in addition, not only in the lateral, Millards, but also in the vertical column. That's why the entire total delay amount increases multifold, Millards.
All right.
So the reasonableness of this imposition is what also is one of the grounds that I have raised, Millards, in my petitions.
Yes, Anjali.
They want to impose any penalty or something like that. There should be a complaint, Millard. If not, and no opportunity.
Complaint Allah. See, that is a duty cast upon every registered entity to upload quarterly updates. That can complaint bekagilla.
Even otherwise, Millard, they should natural justice. They have not.
That is what she said. Yes.
Milords, one last submission, if I may be permitted. Milords, although the authority may have the power to levy the penalty, there is no show cause notice that is issued.
The violation of natural justice.
Milords, what has happened is each case is different, and there are also cases where, because the online portal was not functioning, the promoters have gone ahead and tried to file hard copies of these audits. All of that has not been considered. So if there was a show cause notice, at least case by case, we had an opportunity to submit our merits before the authority. So this circular, Milords, is blanket, and for all the promoters, without looking into the facts of the case, the penalty, the delay fee is levied, Milords.
Ashana?
Yes. In three more petition, Millards, we are challenging the circular issued on 13/10/2022. Again, that is also retrospective in nature. This particular circular also imposes submission of annual audit report as per section 4(2) LD. Now, even under this provision, Millards, quantum of fine varies from 25 lakhs in one case to 18 lakhs in another.
No, that's
case
not
from
listed today, right? Is it listed here?
Clubbed along with these.
Oh, yes. Which is that? Tell me. Number?
WP, Millards, WP 3. I'll just tell the serial number.
Good. One second. Girish. Full money. Ready, Dira? Yes, Jelly. Gautam is ready? after this. What's that extra challenge in your case?
Milords, 25.45 and 25.33. Now, in these petitions, Milords, again, there is retrospective imposition of the annual audit fees that they have computed and imposed to the tune of 25,70,400 rupees.
25.33, na?
Yes, 25.33, 25.45.
What is that fee?
Submission of annual audit report per 42 LD.
That's correct.
Proceedings of the authority.
No, same thing.
No, Milords, it's a different circular that was issued on 13th of October 2022. The circular under other petitions are 3rd of September. This is on 13th of October.
Maybe DTAG, my lord, I don't know that.
Yes, my lord, we don't, my lord, will file objection.
2022 the detag ಮಾಡಬೇಡಿ. 39/2020 circular will pass orders. That we will detag. ಯಾವ್ಯಾವುದು ರಾಘವದು?
22.45, 25.45, 25.33. There's one more petition.
All three ಅದನ್ನ ಕೊಡಿ. ಅದನ್ನ detag ಮಾಡಿ. 22 circular I am not answering. We will answer only 39/2020 circular. But reserved. If there's anything clarification, I'll post it for the hearing.
Section
37.36.
Power is granted only to authority to issue directions.
Oh, that is the direction they issued, sir.
Your Lordship may kindly see section 21, which says what is an authority. Speaks about composition of authority. However, the circular has been issued by secretary.
That is
All three
approved.
In the name of RERAs.
That's bottom. It is written approved by the
Delegation.
It need not be ಅವರೇ ಮಾಡಬೇಕು ಅಂತ. In the name of. Sorry.
And also section 61, which imposes penalty. Therefore, under general provision, they cannot impose penalty, saying it's a delay. Section 61 says if there is any violation of obligations, then penalty up to 5% of the project cost can be imposed. Now the cost every month they are increasing by 20% for 6 quarters, which is almost 1,20,000
that is
each month.
If they consider
the limit has been set at 5% of the project cost.
So 2022 circular I am not touching. Only 2020 I will answer. A dealing ಮಾಡಿ further hearing ಅಂತ ಹಾಕಿರಿ. ಇದು ಮಾತ್ರ reserve ಮಾಡಿ. Third reserve.
My lord, regarding withdrawal, my lord.
That also I'll answer, madam.
Please.
ಅವ್ರ withdrawal ಬಗ್ಗೆ ಏನು ಹೇಳಿದೀಯಾ? ಅದ್ರಲ್ಲಿ ಯಾರಿದ್ದಾರೆ respondent?
No specific objection, my lord.
No, but who is the respondent?
Kera, my lord. Kera
Counsel ಯಾರು madam?
Sir ಇದ್ದಾರೆ.
ಗೌತಮ್ ದೇವ್. ಗೌತಮ್ ಅದ್ರಲ್ಲಿ ಏನು withdraw ಮಾಡಕ್ಕೆ?
My lord, I'll seek instruction.
Objection ಹಾಕಿದಿರಲ್ಲ.
My lord, my lord, ಇದರಲ್ಲಿ withdrawal also, my lord. Even the
tomorrow registration is done. Building collapses for many reasons. Earthquake and building collapses. Registration ಇಟ್ಕೊಂಡು ಏನ್ ಮಾಡ್ತೀರಾ?
Under the act, my lord, if they have already allotted, my lord, then
already allotted is a different thing. What madam says is no allotment came about. They will produce. They will give a representation enclosing all the details why they want to withdraw. Withdrawal is impermissible ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ.
Can we be
permissible
directed to consider that, my lord? Consider
my lord, ಈಗ ಏನಾಗಿದೆ ಅಂದ್ರೆ my lord, ನಾನೀಗ if I have to withdraw, ನಾನು first extension fees ಕಟ್ಟಿ extend ಮಾಡಿಸ್ಕೊಂಡು ಆಮೇಲೆ withdraw ಮಾಡಬೇಕಾಗಿದೆ.
ಈಗ ಲ್ಯಾಪ್ಸ್ ಆಗೋಗಿದೆಯಾ ಅದು?
No, lapse, it is, my extension is lapse. That's why I am under this circular. I am being affected by the circular. Now, just in order to withdraw, I have to pay the extension fee, get it extended, and then withdraw the matter.
We'll try to answer.
Direct us to consider, my lord.
That only consider, so we'll see. But this will answer this circular.
Lord, my contentions are in page 24 of the petition.
Yes. In petition 25.16. ರಾಘವ್ ನಿಮ್ದು ಯಾವುದು? ಮಿಕ್ಕಿದೆಲ್ಲ ನಿಮ್ದೇನಾ?
Writ petition number
25.16 ಪ್ರವೀಣ್ HP ಅಂತದ.
13, my lord. I apologize. 13. WP 4770 of 2024.
25.37 madam. ನಿಮ್ ಕೇಸ್ ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ?
Mine is the lead petition.
My apologies.
Along with other 7 connected petitions.
Yes. Yes.
Minor 22 matters of minor, my lords. All are of this 2020 circular, my lords.
All right, only 2020. So Venkat Subra avare, nimdu 2020 circular matra.
Please, one another matter of withdrawal which is not listed.
Ivar
One
taradda?
is the number, please.
Number.
One is the number, my lord.
No, what Purnima submitted, same thing.
Similar, my lord, project could not take place. Where we apply for withdrawal, my lord, we've been demanded, my lord.
All right, we'll answer.
Grateful,
What
my
is
lord.
that?
Furnish the number.
Number put.
Much obliged.
Yes, next.
Move further here.
ಬೇರೆ ಅಪ್ಪಿತಪ್ಪಿ ಬಂದಿದ್ದೀರಾ ಇದೇ ಕೋರ್ಟ್
ಅಪ್ಪಿತಪ್ಪಿ ಪೋಸ್ಟ್ ಆಗ್ಬಿಟ್ಟಿದೆ.
ಹಂಗ ಹಾಗಾದ್ರೆ ರಿಲೀಸ್ ಮಾಡ್ಬಿಡೋಣ ಬಿಡಿ.
Lord, this matter, my lord.
We'll release it from part heard
For some time, my lord.
Sometime ಅಷ್ಟೇ ತಾನೆ.
Then, my lord, matter was
Serial number
26. Only
special court matter. ಅಲ್ಲೇ ಹೋಗ್ಲಿ.
Small issue, my lord, and it
ಈ
is
ಸ್ಪೆಷಲ್
covered.
ಆರ್ಡರ್ ಏನಾಗಿಲ್ಲ ಅಲ್ವಾ ಇದು?
Further hearing ಅಂತಿದೆ. Was heard.
ಅಲ್ಲ ಅದು ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಆಗ್ಬೇಕು ಫರ್ದರ್ ಹಿಯರಿಂಗ್. ನೆಕ್ಸ್ಟ್ ಎಲ್ಲ ಮ್ಯಾಟರ್ ನೋಡಿ ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಮ್ಯಾಟರ್ ಎಲ್ಲ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಆಗಿದೆ. ಇಲ್ಲ ಅದು ಇಲ್ಲ. ಆಯ್ತು ಹೇಳಿ.
But while granting interim order, my lord, observations are made. Detailed order has been passed.
ನಂದ?
Ordinate bench, my lord.
ಓ
Not today, my lord.
Only allegation is effigies have been burned, my lord, in a public road. That too in, my lord, in front of the police. No damage has been caused. Damar suttu hogide anta heli.
ರಾಮನೇ ಸುಟ್ಟೋಗಿದೆ.
Damar.
ಡಾಂಬಾರ್
suttu hogide anta ಒಂದು. That is only allegation. That has been considered while granting interim.
ಅಂದ್ರೆ ಅಷ್ಟು ಪೂರ್ ಕ್ವಾಲಿಟಿ ಹಾಕಿದ್ದು.
That is.
ಹೊರದೇ ಇದ್ದಾಗ ಹಾಕಿರೋದು.
My lord, it was during the rainy season. It was burned.
ಮಳೆಯಲ್ಲಿ ಬೆಂಕಿಲಿ ಡಾಂಬರ್ ಸುಟ್ಟಿರೋದು. ಎಸ್.
That is only allegation.
Yes, Jagdish sir.
Public property.
Next week, not
ನೆಕ್ಸ್ಟ್ ಇರ್ಲಿ ಬಿಡಿ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕ್ತೀನಿ. ಬರ್ಲಿ ಸ್ವಲ್ಪ ಈ ಕೋರ್ಟ್ಗಳು. ಅವ್ರು ಬರೀ ಬೇರೆ ಇದು ಯಾವ್ದದು ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ಲೇ ಇರ್ತಾರೆ. ಎಸ್.
ಎಲ್ಲ ಕೋರ್ಟ್ ಇರ್ತಾರೆ, ನಿಮ್ ಕೋರ್ಟ್ ಒಂದ್ ಬಿಟ್ಟು.
ಇಲ್ಲಿ ಮಾತ್ರ ಬರೋದೇ ಇಲ್ಲ ಅಂತ. ಎಸ್. ಐ ವಿಲ್ ಪೋಸ್ಟ್ ಇಟ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್. 15ಕ್ಕೆ ಹಾಕ್ತೀನಿ, ಸೋಮವಾರ. ಸೋಮವಾರ ಮಧ್ಯಾಹ್ನದ ಮೇಲೆ ಪಾಠ ಹಾಕ್ತೀನಿ. ಅವತ್ತು ಜಗದೀಶ್ ಸರ್ ಮುಗಿಸ್ಬೇಡ. 15th.
Yes. Interim order may be.
Interim order subsisting will heard the learned senior counsel Arun Sham appearing for the petitioner. List on 15th. Interim order subsisting will continue to the next date.
Serial number 27. Serial number 27. ASG AV Raju sir had to attend, but due to some personal convenience, he is not able to.
27.
Yes, my lords. There are also some, we are the respondents for with 3 matters, my lords, and also a petitioner in 1 matter.
You are petitioner in 1 matter. Only Krishnan, yes.
So request you to please give us a date on.
Same 15th. No more adjournment. Interim orders will continue. List the matter on 15th.
Much obliged.
Made clear, no further adjournments. Yes, the Harvard bench. Mood idea. Yes, Jagdish sir.
Use space matter.
ರಿಪೋರ್ಟ್ ಕೊಡಕ್ಕೆ ಹೇಳಿದ್ದು ಇದೆಯಾ ಇವತ್ತು?
ಇವತ್ತಿಲ್ಲ, 28th.
28th ಹಾಕ್ತೇನೆ. ಎಸ್, ಅದೊಂದು ರಿಪೋರ್ಟ್ ಕೊಡಿ ಏನಾಗಿದೆ ಅಂತ. ಎಸ್, ಧಾರವಾಡ ಬೆಂಚ್ 233 ತಗೊಂಬಿಡಿ. ರಾಜು ವೇಟ್ ಮಾಡ್ತಿದ್ದಾರೆ ಅದಕ್ಕೆ. 230 ಮ್ಯಾಟರ್ ಬರಲ್ಲ ಅಂತ ಒಂದು ಕಂಪ್ಲೇಂಟ್, ಇದು ಬಂದ್ಮೇಲೆ ಕರೆದಿಲ್ಲ ಅಂತ ಆಮೇಲೆ ಯಾಕೆ ಕೊಡಿ. ಎಸ್, ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್
Filing memo. Madam.
Withdrawal memo.
Preliminary hearing, seal number 2. Aishwarya Hegde.
Please, yours. Petition by IOC.
Indian Oil Corporation ಯಾಕೆ?
Lord, IOCL is a judgment debtor. Lord, the suit was filed for eviction. We are running a retail outlet. Compromise petition was entered into wherein my lord, we have agreed to pay damages of rupees 1 lakh per month. And we were given time to vacate till the end of my lord, 1st January 2026. We were depositing the rent, my lord, after deducting the TDS. My lord, the learned trial judge raised an objection and decree holder also raised an objection, and that has been upheld by the learned trial judge, holding that you cannot deduct TDS. My lord, it's a statutory requirement as per section 194.
TDS ಎಷ್ಟು 10%.
10%, 7,497 per month. Now, my lord, the learned judge has ordered for attachment of movables.
Correct ಆಗಿ ಮಾಡಿ.
ಅಲ್ಲ ಈಗ ನಾವು TDS deduct ಮಾಡದೆ ಕೊಟ್ಟರೆ we will be given imposed with penalty.
Correct. Otherwise
he will get double payment.
Otherwise it will become TDS.
My lord, he cannot take double benefits, my lord.
Who cannot take?
The decree holder. Compromise petition alli.
The petitioner, judgment debtor, is at the doors of this court calling in question an order of the concerned court dated 30th June 2025 by which the court directs the petitioner Indian Oil Corporation not to deduct tax deduction at source on the rent that is paid, which is pursuant to a compromise. The learned senior counsel Vigneshwar Shastri submits that the compromise was entered into between the landowner and the Indian Oil Corporation, who runs a petroleum outlet on a lease basis. And in terms of the compromise, it was agreed that rupees 1 lakh will be paid to the owner. The 1 lakh that is being paid is now directed that there should be no TDS deducted. The order prima facie is erroneous. In that light, the
attachment ಮಾಡಿದ್ದಾರೆ.
Sorry, in the light of in the light of the deduction of TDS notwithstanding the aforesaid direction, attachment of the property of the petitioner Indian Oil Corporation has driven the petitioner to this court. In the light of the aforesaid reasons, there shall be an interim order of stay of the order dated 30/6/2025 till the next date of hearing. Emergent notice to the respondent. Next.
Order is dated 36/20.
ಅದೇ ಹೇಳಿದ್ದು.
Please.
ಇನ್ನೇನು ಹೇಳಿದೆ? 30th June ಅಂದ್ರೆ 36/25.
Even order of attachment. Even order of attachment.
ನೀವು ಬಿಟ್ರೆ ಇವ್ರು ಬಿಡಲ್ವಲ್ಲ, ಏನದು?
And my lord, one more order, my lord, 28/4 ಎರಡನ್ನು ಕೇಳಿದ್ದೇವೆ.
ಏನದು ಆರ್ಡರ್? ಇಲ್ಲ, ಎಂಟ್ರಿ ಮಾಡಲ್ ಒಂದೇ ಇರೋದು.
ಅದೇ ಎರಡು ಡೇಟ್ ಇದು ಕೇಳಿದ್ದೇವೆ. IA number 4.
ಅಲ್ಲ, ಈಗ ಎಂಟ್ರಿ ಮಾಡಲ್ ಎರಡು ಇದೆಯಾ? ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಸ್ಪ್ರೆಡ್ ಫಾರ್.
Please.
ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಬೇಕಾ? ಥರ್ಸ್ಡೇ ತಗೊಳ್ಳಿ. ಎಸ್. ಶನಿವಾರ ಸಾಯಂಕಾಲ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಕೇಳ್ತಿರಲ್ಲ, ಹೆಂಗ್ ಕೊಡೋದು?
ಬಂದು ತೊಂದರೆ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಬೇರೆ ದಿನ ಆದ್ರೆ ಓಕೆ, ನಾಳೆ ವರ್ಕಿಂಗ್ ಇದ್ರೆ ಥರ್ಸ್ಡೇ. ಎಸ್ ಸಿದ್ದರಾಮಯ್ಯ.
First respondent is the chit fund. Second respondent is
ಮಾರ್ಗದರ್ಶಿನಾ?
ಮಾರ್ಗದರ್ಶಿ.
ಸರಿ, ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಸ್ಪ್ರೆಡ್ ಫಾರ್. ಎಸ್.
Number 4.
Similar madam.
ಸೇಮ್.
Number 5.
Daddy, hand delivery ನಾನು ಇವತ್ತು ಕರೆಕ್ಟ್ ಮಾಡಲ್ಲ.
ಏನ್ ನೀವು ಹಂಗೆ ಕೇಳಿದ್ರೆ?
ಇವತ್ತು ಮಾಡಲ್ಲ, ಗುರುವಾರ ಮಾಡ್ಕೊಂತೀನಿ.
ಗುರುವಾರ ತಗೊಳ್ಳಿ.
ಇದನ್ನವರೆಗೂ ಆರ್ಡರ್ಸ್ ಕೊಟ್ರೆ ಸಾಕು, ನಾನು ಅವತ್ತು ಕರೆಕ್ಟ್ ಮಾಡಿ.
ಆಯ್ತು, ಕೊಡಿ
ಮೇಡಮ್. ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ
ಅದ್ರಲ್ಲಿ ಏನ್ ಬರಿಬೇಕು ಅಂದ್ರೆ, ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಟು ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್, there shall be an interim order of stay of further proceedings before the concerned court till the next date of hearing. ಮಾರ್ಗದರ್ಶಿ ದಿನ ಒಂದು 4 ಸ್ಟೇ ಮಾಡ್ತಾ ಇದೆ. ಎಲ್ಲ ದುಡ್ಡಿಸ್ಕೊಂಡ್ಬಿಟ್ಟು ಆಮೇಲೆ ತೊಂದರೆ ಕೊಡ್ತಾ ಇದ್ದಾರೆ. ಎಸ್. ಎಸ್ ಕಲ್ಯಾಣ್.
The respondent number 124 files a suit for partition, suppressing the real facts, my lord, about previous filing suits and compromise arrived between the family members.
Same property?
Same property. Initially, a suit in OS number 110/2002 was filed.
The urgency,
urgency is that, my lord, now they have obtained a decree before the Lok Adalat. They enter into a compromise before the Lok Adalat.
Who are you?
My lord, I am the legal heirs of Virappa. My lord, Siddhalingaya had.
ಈಗ ಮುಂಚೆ partition ಆದಾಗ you were.
My lord, Originally, my lord, OS number page.
ಅಲ್ಲ,
number-
OS 2006 ಅಲ್ಲಿ
My lords, before that, a OS number 110/2002 was filed. Page number 138, your lordship. In this suit, the subject matter of the property, page 142, survey number 19/2. 142 is the relevant portion. Schedule was 19/2 and 35.
ಲೋಕ ಅದಾಲತ್ 13(7) ಆಗಿದೆ ಆಲ್ರೆಡಿ.
Already agide. That is called in question now.
You are not a party there?
I am not a party there. In OS.
And your properties are there?
Yes, my lord. 119/1 was purchased by Veerappa. The petitioner is daughter
The
of
petitioner is before this court calling in question a compromise entered into before the Lok Adalat without making the petitioner a party. It is the submission of the learned counsel K. Kalyan that, R. Kalyan, that the properties of the properties which belong to the petitioner are made subject matter of the suit, and the suit has entered into a compromise, thereby putting rights of his property to jeopardy, right of the property of the petitioner to jeopardy. In that light, further proceedings pursuant to the compromise recorded on 13/7/2024 shall remain stayed till the next date of hearing. Petitioner to serve on the respondent, counsel representing the respondents or the respondents by way of hand summons, and file an acknowledgement of such service by the 29th. List the matter on 10th September in preliminary hearing. Next.
Admission seal number 6. Raj.
CRP for ಇದಕ್ಕೆ ಯಾಕೆ urgency?
There is no urgency.
Withdrawal ಅಂತ ಹೇಳಿ.
Withdrawal ಅಷ್ಟೇ.
ರಾಜು ಸರ್, ಅದಕ್ಕೆ ಯಾಕೆ urgency? ಕೊಡಿ.
Yesterday, my lords, the suit itself is compromised.
ಹೌದಾ? Learned counsel Subramanya are representing the petitioner submits the suit has ended in a compromise, therefore the seeks withdrawal of the subject revision petition. Petition is disposed as withdrawn. Why is Ravi Shankar sir waiting? You ಕರೀತೀನಿ ಒಂದು ನಿಮಿಷ.
Matters pertaining to Dharwad bench seal number 1.
Deepa Pavan. Interim order ಇದೆ ಮಾಡಬರ್ಲಿ. List on 19 September interim order subsisting will continue to the next date of hearing. ಇದರಲ್ಲೂ ಇದೆ. All 482 matters 19th interim order ಇದೆ ಎಲ್ಲದರಲ್ಲೂ.
5.
Hello, serial number 2, my lord. Attend serial number 2, my lord.
You are here.
Yes, serial number 2,
yes.
my lord. It's a covered matter, my lord.
ಕೊಡಿ.
My lord, 188 of IPC, my lord, FIR, my lord.
ಕೊಡಿ sir. Now latest judgment 188 cannot be
Yes. And
by
my lord,
a police officer at all. Yesterday's judgment. Supreme Court.
serial, it is a crime number 31, my lord. Respondent number 2 has filed against me, my lord, complaint, my lord. Same is caused by this coordinate bench, my lord.
But same accused ಅಲ್ವಲ್ಲ?
Same accused, my lord.
ಅಲ್ಲ same proceeding ಅಲ್ವಲ್ಲ? Same
Different-
FIR.
FIR number 31 and 32, my lord. This proceedings is 32, my lord. 31 is already caused by this court, my lord. Coordinate bench. my lord.
CC ಏನು? Different. ಅಲ್ಲ, you are not the same complainant?
Complaint is same, my lord.
ಬರ್ಲಿ ತಾಳಿ ಅವರಲ್ಲಿ. List on 15th.
And my lord, it's a
Interim order ಇಲ್ವಾ?
interim order ಇದೆ, my lord. But police
15th
is.
quash ಮಾಡು.
Yes, my lord.
Let the government.
Yes, my lord.
Yes, next. 5 ವರೆಗೂ ಇಲ್ಲ. 6 ಬೇಡ. ಎಲ್ಲ interim order ಇದೆ. Up to 9. 10 ಅದು interim order ಇದೆ. Yes, 11. ASG, first court ಮುಗ್ದಿದೆ.
Add inform.
MRP.
MRP on tobacco. Scheme of the GST acts as such, my lords, that the GST is levied only on the transaction value. And now, my lords, the transaction value is only on the incident of supply. Now, my lords, the issue of the validity of the compensation cess had come up before the Honorable Supreme Court in the judgment of Mohit Minerals. Now, my lords, there, I'll place that judgment. Mohit Minerals, there the issue was whether the compensation cess itself is lawful or not. My lord, the Supreme Court specifically in that case held that the levy is valid, though the incident of tax is the same. There can be two imposts on that tax, my lord. One was the GST impost, the second was the compensation cess impost. Now, my lords, there is no dispute that the incident per se, the taxing event is the same. That is the event of supply. Now, my lords, one yardstick is applied so far as GST is concerned. The yardstick so far as GST is concerned is the transaction value. Now, my lord, so far as compensation cess is concerned, they say it is MRP. Now, my lord, this is the impact that happens. Let us say, my lords, it is 10.
Lords may make a submission in serial number 11.1. Senior counsel has been engaged in that.
ಇವಾಗ ಮಾಡ್ತಾ ಇದಾರಲ್ಲ ಸುಮ್ಮನೆ wait.
Any
Mr.
other
Shivdas
day.
is,
Wait, sir.
my lord, Mr. Shivdas is there in 11.1. He had instructed that we can start and he will subsequently.
Maybe another day.
You know, ASG, it's only 5 o'clock. We'll post it another day, but start ಮಾಡಿ.
Very well.
On a Saturday evening, let's not trouble the ASG.
My lord,
Ravi Shankar is also.
My lords, because today has been a heavy day for my lords also. 30th, my lords, if it's not inconvenient to my lords.
ತಮ್ಗೆ ಆಗ್ಬೋದಾ ಸರ್?
30th.
30 ಇಲ್ಲ 8 1 8 Mondays also it can be.
We are getting intimidated by Mr. Ravi Shankar. There is a finish fast.
30th is okay.
30th is okay. 30th in case there is a bench, I'll post it on 1st Monday.
Not
Very well.
any date after the first of senior.
The lordship have it on 1st also.
First
September, Monday.
1st September Monday.
I'm sorry. 1st September. 1st September, but 30th early.
30th early. 30th in all probability it will be there. Yes. Interim will continue. Yes. Then ASG 5 minutes ಸಾಕಿದ್ರು. MRP ನ ಮೇನ್ ಅಂತ ಅಷ್ಟೇ ಇನ್ನೇನು.
In fact, there is a statutory provision which permits the government.
ಆಯ್ತು, will see. Yes. Yes, ರವಿಶಂಕರ್ ಸರ್. ಇದರಲ್ಲಿ ಯಾರು ಗಿರೀಶ್ ಹುಳ್ಮನಿನ? ಶಿವರಾಜ್ ಬಳ್ಳೊಳ್ಳಿ.
The issue is very simple. The entire transaction value or the turnover is taxed for VAT. I have paid VAT. They issue a notice. I submit all the purchase orders saying that whatever is concerning your notice or the transaction value is already exigible to VAT and VAT is already paid. Now, page 115 para 28, he says, though VAT is paid, I am not satisfied that the purchase orders and the invoice which you have given is having any relativity to the total income which is declared in my income tax returns.
ಶಿವರಾಜ್ ಬಳ್ಳೊಳ್ಳಿ ಬರ್ಬೇಕಲ್ಲ?
I'll just file a synopsis.
ಅದು ಕೊಟ್ಬಿಡಿ.
The list of judgments has already been submitted. I have extracted the relevant
Ask
portions
Shivraj
also.
Balloli to come on 29th.
Please, my lords, I'll inform.
Post it on 29th.
Please, my lords.
List on 29th at 4:30 PM.
Please.
Written arguments ಇದೆಯಲ್ಲ?
Please. The written
Interim
submissions.
order is there.
Interim order. At the learned senior counsel, D.R. Ravi Shankar appearing for the petitioner, awaiting the submissions of Shivraj Balloli, list the matter on 29th at 4:30 PM.
Please.
13.
Please, my lord, the matter has been covered, my lord, and proceedings as against accused number 1, 2, and 4 has already been quashed, my lord. Standing on same footing, my lord.
ಇಲ್ಲಿ ಜಗದೀಶ್ ಸರ್ ಹೋದ್ರಾ? ಹೌದು, ಧಾರವಾಡದಲ್ಲಿ. ಸಾರಿ, ನಮಗೆ ಎಲ್ಲದಕ್ಕೂ ಜಗದೀಶ್ ಬೇಕು. ಯಾರಿಗೆ ಕ್ವಾಶ್ ಆಗಿದೆ?
My lord, accused number 1, 2, and 4, my lord.
The Buds Act ಇದೆ. Wait. Yes. List the matter on 15th.
Please.
Yes, sir.
That RFA which has gone to 30th, maybe be taken up on 29th of 1st, my lords.
29th ಹಾಕಿರ್ತೀನಿ, but I don't know.
Or first
is better.
First is,
yes.
I've
1st September. Inform the other side and that day finish.
I'm present.
Yes.
Serial number 21, list 2.
ಆಯ್ತು, ಗೊತ್ತಾಯ್ತು. RFA ಇರೋದು ಒಂದೇ ಸ್ಪೆಷಲ್ ಆರ್ಡರ್.
Bench court of grateful, my lords.
You don't worry, even if I forget, court officer won't forget. Yes. Ishad madam. Hello. Yes, Rahul.
Milord, sir, interim order, Milord, I had mentioned.
ಯಾವ್ದ್ರಲ್ಲಿ?
18.107.
ಹಾ ಮಾಡ್ಸಾಯ್ತಲ್ಲ.
Please.
ಹೇಳಿದ ಸಾಯಂಕಾಲದೊಳಗೆ ತಗೊಳ್ಳಿ ಅದನ್ನ, ಯಾರು ಕೊಡಲ್ಲ ಅಂತಾರೆ.
ಅಲ್ಲ.
ಸಪರೇಟ್ ಆಗಿ ಬರುತ್ತೆ ನೋಡಿ. You apply for it. You'll get it.
ಅಲ್ಲ. That is where the problem.
ಅಪ್ಲೋಡ್ ಮಾಡಿಸ್ತೇನೆ.
ಅಪ್ಲೋಡ್ ಮಾಡಿದ್ರೆ the main order, interim order.
5 o'clock ಒಳಗೆ ಅಪ್ಲೋಡ್ ಆಗುತ್ತೆ.
ಅಲ್ಲ, ನಮ್ಗೆ ಅಪ್ಲೋಡ್ ತೊಂದ್ರೆ ಇಲ್ಲ. But the mentioning I was trying to make is let the main petition interim order be extracted herein because the registry is saying it
Sir, yes, don't worry about it.
Please, that's
Milord,
all.
interim order may kindly be extended. Serial number
That will be extended, sir. Yes.
Please, please.
Please.
This is serial number 25. Please tell me the next page. This is 25. This is 25.
ಒಂದರಲ್ಲಿ ಹಾಕೊಂತಾರೆ. ನೀವು ಏನಾದ್ರು ಬರ್ತಿದ್ದೀರಾ, ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? ಬೇರೆ ಎಲ್ಲ ಯಾಕೆ ಬರ್ತಿದೆ ಅಂತ ಎಲ್ಲ ಕ್ಲಿಯರ್ ಆಗಿದೆ. ಮೆಂಟಲ್ ಎಬಿಲಿಟಿ ಒಂದೇ ಫುಲ್ ಸೆಟ್ ಹಾಕ್ಕೊಳ್ತೀವಿ. ನೀವು ಇದಕ್ಕೆ 5 ನಿಮಿಷದ ಮುಂಚೆ ಇಲ್ಲಿ ಬಂದು ನಿಂತ್ಕೊಂಡು ಹೇಳ್ಬೇಕಂತ ನನಗೆ ಹೇಳ್ತಲ್ಲ. ನಾವೇನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? ನನಗೆ ನೀವು ಹೇಳೋದೇ ಬೇಡ. ನಾನು ಹೇಳ್ತೀನಿ. ಲಾಜಿಕ್ ನನಗೆ ಯಾವಾಗ ಹೇಳ್ತಾರೆ ನಾ ಹೇಳ್ತೀನಿ.
ಬ್ಯಾಚ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಯಾವತ್ತು ಬೇಕು ಮೇಡಮ್? 8-9 ಅಲ್ಲ?
ಹಾ.
8-9